and welcome you all to the University of Pittsburgh Law Review's Symposium in honor of Professor Arthur Hellman. My name is Anna Miller-Little. I'm the editor-in-chief of the University of Pittsburgh Law Review's Volume 85, and Dean Mary Crossley will be providing you with an official welcome, but I just want to extend a few thank yous on behalf of the Law Review before she does so. So first, I want to thank Daniel Tublin. He's the tall gentleman in the back, so thank you. He serves as the Law Review's senior articles editor and the Symposium chair, and his leadership has been tremendous in putting together this event. So thank you, Daniel. I also want to thank committee members, Katie Fisher, Kadina Mancini, Natalie Simmons, Chelsea Bolio, and Danny O'Byrne. Their hard work, again, has been tremendous. The Law Review would also like to thank 5 Pitt Law faculty members who were instrumental in making this event possible. Dean Mary Crossley, Vice Dean Jerry Dickinson, Professor Peter O, and Professor Christian Sundquist. Your guidance and support in helping us honor Professor Hellman has been exceptional. So I also finally would like to thank A.B. Change, Deb Geary, Luann Driscoll, and Corey Parise for helping us put together this event. So with that, I will turn things over to Dean Mary Crossley to welcome you all to today's extraordinary event.
Good morning. My name is Mary Crossley, and I serve as the interim dean here at the University of Pittsburgh School of Law. And it's really my great pleasure to welcome you all to this symposium on federal courts organized by the University of Pittsburgh Law Review in honor of Professor Arthur Hellman. From the perspective of a dean, this is the very best kind of event. The event springs from the energy, creativity, and passion of our talented and tenacious students. It demonstrates the impact of a faculty colleague's scholarship and engagement with the legal system. It reflects the organizational skills of our dedicated staff. It draws alumni back to the law school and reminds them of the value they drew from their time here. And this symposium highlights all of this for an audience that includes distinguished jurists and practitioners and scholars. I'm grateful to many people for making today's symposium possible, more than I have time to acknowledge publicly. But there are a handful whom I must recognize. First, I want to thank everyone acknowledged in the program who has provided financial support for today, and especially the symposium's platinum sponsors, specifically the law firm Jones Day, which is an institutional platinum sponsor, and attorney Kim Watterson, who is an individual platinum sponsor. Second, I want to thank the Law Review staff for having a truly ambitious vision for this event and then making it a reality. I had the pleasure of personally working with Anna Miller-Little and Daniel Tublin around this program, but I know that many more members of the Law Review have been essential to its coming together. And the Law Review received generous support and guidance, particularly from Professor of Law and W. Edward Sell Fellow Peter O., who has helped the Law Review members with everything from raising funds for the symposium to navigating the law school's sometimes labyrinthine administrative structure. And finally, we would not be here were it not for Professor Arthur Hellman, whose impact and legacy we celebrate today. You'll hear much more about Professor Hellman and his work over the course of the day, but I just want to start off the day by giving you some brief background regarding Arthur Hellman. He joined the Pitt Law faculty in 1975. Fresh off a stint serving as the Deputy Executive Director of the Commission on Revision of the Federal Court Appellate System. And that experience laid the foundation for a distinguished career as a scholar and teacher. For more than 40 years, he taught generations of Pitt Law students in courses including federal courts, First Amendment, constitutional law, and civil procedure, leaving an indelible impression on law students. Today, when I talk to alumni who had Arthur as a professor, They talk not only about his brilliance, but about his ability to engage their interest and help them understand how the law and the courts as systems work. And as a scholar studying the federal courts, Arthur Hellman's reputation and impact are unrivaled. Arthur's work has influenced the development of the law, both through his plethora of publications, as well as through his work with the judiciary committees of the House and Senate. He has testified at judiciary committee hearings and assisted the committees in drafting legislation relating to the federal courts. In recognition of his status as a scholar, in 2002, Arthur Hellman received the Chancellor's Distinguished Research Award, and in 2005, he was appointed as the inaugural holder of the Sally Ann Semenko Endowed Chair at the university. I could go on, but that brief introduction of Professor Hellman's career will help to set the stage for today. And speaking of brief introductions, my final responsibility is to introduce briefly our opening speaker, Chief Judge Mark Hornak. And you can find additional biographical information about Judge Hornak in the program. The Honorable Mark R. Hornak was appointed as a United States District Judge by President Barack Obama on October 19, 2011. He became Chief Judge of the District Court for the Western District of Pennsylvania on December 7, 2018. Judge Hornak received both his bachelor's degree and his law degree from the University of Pittsburgh, and while in law school, he served as editor-in-chief of the University of Pittsburgh Law Review. After graduating from law school and clerking for a year on the Fourth Circuit, Judge Hornak began practicing law at the Pittsburgh office of Buchanan, Ingersoll, and Rooney, where he practiced until taking the bench. We at Pitt Law are proud to claim Judge Hornak as an alum and delighted that he is here this morning to offer opening remarks. Judge Hornak.
Good morning, and thank you to Ms. Miller-Little, Mr. Tublin, their colleagues on the Law Review for the invitation to be with you today. And welcome to Pittsburgh to my colleagues from around the country and to our friends and the students that are here today. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. With those first 30 words of Article 3 of the Constitution, the founders invented the institution we examine today as we honor one of its most dedicated, thoughtful, and inquisitive students and scholars. For more than 45 years, Arthur Hellman has committed his more than considerable intellect and enduring energy to assessing the implications of that sentence and how the institution that it created fits snugly into our national consciousness and the American tradition. With precision of thought and unwavering dedication to educating law students, along with judges and the public about the federal courts, Arthur Hellman has exemplified the best of critical scholarship about this very special institution. And that is demonstrated by the presence of his fellow scholars who have joined us today. They are the who's who of the nation's thought leaders on the structure and role of the federal courts and the ethical obligations and societal expectations of the judges that inhabit them. For those who've personally participated in that academic journey with Arthur, we know that it has been more than his intellectual horsepower that has fueled Professor Hellman's work. Although his mind has enabled his scholarly pursuits, it is his heart that is the engine of his work. Arthur Hellman knows the central role that the federal courts play in the search for equal justice under law. Beyond that knowing, he as much feels the special place they hold in the American experiment, both structurally and symbolically. Whether we were his students recently or more than 40 years ago, Arthur's kindness, approachability, patience, and wry sense of humor have been the hallmarks of his relationships with his law school and with his students. He cares about us and our lives because he has cared so deeply about our understanding the focus of his studies, the role of the federal courts in a democracy made up of unelected judges appointed for life with protections from retribution by the partisan branches of the national government. Professor Hellman has long recognized that the structures of and for the federal courts, established first in Article 3 and then by Congress, inevitably affect how judicial decisions are made as they regulate the nature of the cases before those courts, especially the Supreme Court, and then define the mechanisms by which they are decided. He has examined with characteristic precision the relationship between the federal and state courts as each applies the same supreme law of the land under a single federal constitution. He knows that those structures are akin to a legal Jenga game, one in which removing or replacing any one element will eventually impact all of the others, and then without question, the administration of justice. Today's symposium examines the design of the Supreme Court and of what are, for most litigants, the true federal courts of last resort, the regional federal courts of appeal. The limited jurisdiction of the federal courts, especially the federal district courts, will be up for discussion and commentary, followed by what will almost certainly be a lively discussion of judicial ethics and the essential questions touching upon the expectations of the public for the personal and professional conduct of the women and men who hold federal judicial office. As those conversations begin, please allow me to share reflections from the front lines on how Arthur's work has enlivened the consideration of those matters. As a judge of an inferior court, I am reminded each day of the particular and extraordinary obligations of public service that I must bring to my work. We're expected to be courageous in the face of public and private criticism, and at times genuine risks of tangible harm to ourselves and those close to us. We're expected to earn anew every day the invocation in the first line of our commissions, to be women and men worthy of special trust in our wisdom, uprightness, and learning. To paraphrase famed NFL referee Jim Tunney, the public expects us to be perfect on our first day and then to get better each day thereafter. And as Socrates observed, as we do so, we are to listen courteously, answer wisely, consider soberly, and decide impartially. For every litigant, the delivery of our work is expected to involve a championship level of judicial performance. Between the realities of the volume of litigation, the tight formulation of standards of review, and the modest number of cases accepted by the Supreme Court for final adjudication, having a case in a federal trial court is usually a once-in-a-lifetime experience with the narrowest of windows for do-overs. These are high bars, as they should be, given the stakes involved in the cases in the federal courts. How justice is to be considered and delivered, and the ethical responsibility of those entrusted with those obligations has been at the heart of Arthur Hellman's life's work. I can gratefully say, as one of his students, that how I began to think about that work and the institution that I now served was shaped indelibly by Arthur's teaching more than 40 years ago. Arthur's work has reflected a deep appreciation for the special place of the federal courts in our history, coupled with the intricacies of how their work is allocated and conducted. His scholarship has been a persistent reminder that the federal courts are and always have been an essential element of our national self-governance. They are central to the thoughtful and peaceful resolution of vigorous disputes about matters of consequence within the rule of law. But as they say in the late-night television commercials, but wait, there's more. And it has been that more that Arthur's work has played a central role in considering. As Tocqueville observed 2 centuries ago, in America, every important national question eventually becomes a question of the law. Experience teaches that when there's a dispute that touches upon the allocation of government power, the definition and exercise of rights enshrined in the Constitution, or of government action, which someone believes impedes their enjoyment of freedoms they are certain the Constitution recognizes, they most often come to the federal courts. But the centuries-old formal legal structures and the unwritten norms for the work of the federal courts that they have generated are encountering new, and dynamic pressures and challenges. When I graduated as part of the Pitt Law class of 1981, our commencement speaker was Fred Graham, the legal correspondent at CBS News. At that time, he was it, the one and only legal expert who was a dedicated member of the news team at a national television network. Now, the news of the day includes the reporting of multiple Fred Grahams, joined by an array of actual or at times self-declared legal experts serving as special correspondents on the more discrete legal topics. And such is the case no matter the flavor of the news coverage that fits the tastes of any viewer. In ways beyond those of Fred Graham's solo act of the early 80s, the work of the federal courts now receives unprecedented examination under the blogosphere's microscope. While generating a broad and better public understanding of the work of those courts is an essential foundation of an informed populace, for better or worse, the nature of the public's interest in that work has evolved. Individual judges increasingly no longer toil somewhat anonymously for decades in the legal vineyard, but are instead known by name in the news and on the web, and then associated with the president that appointed them. Good faith predictions about how a judge might carry out their work and reach their decisions have at times been replaced by explicitly stated expectations for the substance of those decisions. And it is a world that includes an encroaching belief that any important decision by those that hold authority is driven more by personal motive than by the rule of reason, coupled with public assessments of how judges go about living their lives and speaking of their work both on and off the bench. How the decisional structures Arthur has considered and analyzed will accommodate those newer realities is perhaps the subject for the Law Review Symposium a decade from now. Tocqueville's prediction has come full circle, as few of the most significant decisions and questions our society faces are considered without traveling through or at least bumping into the federal courts. The big stuff that has been part of our work for decades, such as voting rights, allocations of government power, equal protection and due process, rules of procedure, sentencing, and freedom of speech and religion, check, without a doubt. But there is more. Student loan forgiveness, check. Guns and who can possess them and in what circumstances, check. What is taught by whom in public schools and in colleges and universities, check. Whether Division I student athletes may transfer between universities and still play their sport, yes, check to that also. As lawyers and citizens, we can wonder how we arrived at this spot and what that means for our legal system, but it is difficult to deny that we're there. And that is where Arthur Hellman's work in today's program comes in. No matter our varying views on the methods of legal analysis that should be applied in and by our federal courts, we are not likely to go back. We will encounter new and sometimes novel legal theories and developing analytical principles in the context of unprecedented scientific advances and technological change. Our 335 million fellow Americans will continue to look to the federal courts as the fundamental forum for the vindication of rights enshrined in the Constitution. And the sometimes harsh combat of the partisan institutions of our government will increasingly require the resolution of competing claims of final legal authority. An independent federal judiciary structured to generate neutral decisions in an orderly manner, unencumbered by the need to please anyone or anything other than the oath judges have sworn to uphold, and then known and respected for exactly those things, will be an even more essential element in preserving and advancing a free society. Arthur Hellman has long appreciated these fundamental responsibilities of the institution we gather to discuss, debate, and celebrate today. Understanding the work of the federal courts and federal judges, along with the framework in which they do that work, and then critically considering the expectations demanded of those judges, will remain central to fulfilling those responsibilities. And accounting for the history and traditions of our federal courts as they existed at the founding and are of necessity brought to life in today's world and then into the future has been central to Arthur's work. His studied commentary on the work and structure of the federal courts has been a gift, not only to his students, but to the public which entrusts the judicial power of the United States to that institution and to the human beings who comprise it. Thank you, Professor Hellman, for your exceptional scholarship and teaching. You're animated by your generosity and your persistent good cheer. It is a privilege to be with you in the presence of your esteemed colleagues to deliver a belated but heartfelt appreciation for your dedication to your students and to each of us as lawyers and judges engaged together in the daunting work of delivering equal justice under law. Congratulations, Arthur, and thank you.
Thank you, Judge. Our first panel of the day is titled "The Supreme Court and Its Modes of Doing Business." Before I begin, I will just note that in the interest of time and saving more room for discussion, I've asked the moderators to keep the introductions brief. I encourage you to review each of the biographies of our distinguished panelists and moderators online or in your program. Our first moderator for this distinguished panel is the Honorable J. Nicholas Ranjan of the U.S. District Court of the Western District of Pennsylvania. He also chairs the Wendell G. Friedland Society, an organization comprised of judges, lawyers, and law students dedicated to the advancement of litigation excellence. Prior to his appointment as a district judge in 2019, Judge Ranjan practiced here in Pittsburgh at K&L Gates for 14 years, where he focused on complex commercial litigation, appellate litigation, and domestic arbitration. He clerked for the Honorable Deborah L. Cook of the Sixth Circuit and received his JD from the University of Michigan Law School. We are honored to have you lead this discussion, Judge. Thank you very much.
Sure, thank you.
I have to turn this.
All right. Good morning, everyone. Thank you, Daniel. I feel bad. That was an extended introduction of myself, and I'm going to give truncated ones of our distinguished panelists here today. So thank you for having me. I'm honored to serve as a moderator for this distinguished panel. And we're going to be discussing today the Supreme Court and its modes of doing business. Allow me to introduce the panelists briefly. To my immediate right is Professor Michael Salamini, who is the Donald P. Klenkamp Professor at the University of Cincinnati College of Law. To his right is Professor Carolyn Shapiro, who is a professor at Chicago-Kent College of Law, where she is also the founder and co-director of Chicago-Kent's Institute on the Supreme Court of the United States. Then to her right is Professor Bert Wong, who is the Harold R. Median Professor of Procedural Jurisprudence at Columbia Law School. To his right is Professor Stephen Vladeck, who is the Charles Allen Wright Chair in Federal Courts at the University of Texas School of Law. And finally, at the end of the row is Judge Thomas M. Hardiman, who is a circuit judge on the United States Court of Appeals for the Third Circuit and has been in that capacity since 2007. And prior to that, was a district judge on the Western District of Pennsylvania. So I welcome all the panelists here today. And as Daniel alluded to, and as Chief Judge Hornak alluded to earlier today, our panel will be discussing the Supreme Court and its mode of doing business. I think certainly everyone is concerned with and is interested in the merits of Supreme Court decisions. But I think, as you'll hear from these panelists, equally important is the procedure surrounding how the Supreme Court gets its decisions, gets its cases, controls its docket. Are there alternatives to things like writs for certiorari? Is there a disconnect between the Supreme Court and the lower courts, particularly based on how it's issuing its rulings? We've all heard of this nefarious shadow docket. We'll talk about that and different trends associated with how the Supreme Court is deciding things, whether through the shadow docket or through grants, vacatures, and remand orders. And we'll also talk about congressional regulation or the lack thereof of the Supreme Court and whether there's a connection between that and some of the procedures that have been implemented by the Supreme Court. And finally, I think this will be very instructive here, also judicial perspectives, certainly from Judge Hardiman, as to some of these procedural issues and how it plays with the guidance that perhaps some of the procedures that are used at the Supreme Court providing lower courts in deciding cases. So with that, allow me to introduce first Professor Salamini, who will lead things off.
Yeah, because the people on the Zoom won't be able to hear the microphone.
Okay. Okay. What I asked. So, thanks to everyone here for this wonderful symposium, and I'm honored and flattered to be part of this and part of the many, if I may say, distinguished scholars who are a part of this. So I see the title of my talk is on the screen, and so if you'll bear with me in the few minutes I have here, and Judge, please keep track of time. Bear with me as I take you through a journey in the past to talk mainly about the Warren and Berger courts and their dockets, but at the end, as the title of my talk indicates, I'm going to return to the present and talk about some of the things Judge Ranjan just mentioned. And the paper is definitely informed by Arthur Hellman's wonderful scholarship, and also he very generously provided me with his data and list of cases that he's used, that he has empirically gathered over the years and discussed in his own, scholarship over the years, going back to the 1970s. So thank you, Arthur, for inspiring this very paper and your help in it. So okay, so let's go in the past now briefly. So the Judge's Bill, yes, the Judge's Bill, now 99 years old, passed by Congress, essentially says, as I think everyone knows, that most of the cases that go up to the U.S. Supreme Court are on discretionary writs of certiorari, but that bill left intact what are called the mandatory appeals in a few cases. That the losing litigant had the right to, that's why it was called mandatory, to appeal, not on a writ of certiorari, but appeal the case to the U.S. Supreme Court. And the Supreme Court, reflecting the word mandatory, had a mandate to decide the case on the merits, or at least that's at least what what it was set up to be. But in fact, the conventional wisdom for much of the 20th century was that there wasn't, I think it's fair to say, not everyone may agree with me on this, perhaps. I think, nonetheless, I think it's fair to say that both on and off the court, the distinction between certiorari cases and mandatory appeals cases, it wasn't a big deal. It wasn't much of a big deal. So it seems. And why is that? Is that most of this, so-called mandatory appeals cases did not result in an opinion, a written reasoned opinion by the court. Most of them were, as Arthur's scholarship is, documented and discussed, the vast majority of mandatory appeals resulted in summary dispositions of some kind by the U.S. Supreme Court. They were either summarily affirmed or dismissed for lack of jurisdiction, or dismissed for lack of a substantial federal question in the jargon of the Supreme Court's practice. And it appears that the court itself, or one could argue the court itself and the legal community as a whole, more or less considered those summary dispositions as the functional equivalent, more or less, of a denial of certiorari, right? So here that's one reason that it wasn't that many lawyers and law professors, political scientists, and other people who kept track of these things didn't think the difference was a big deal. Arthur, you were an exception to that rule, to be sure, but nonetheless, many people thought that. I think another reason the distinction between certiorari and mandatory appeals wasn't thought to be a big deal was the argument that the cases that came up on mandatory appeals, certiorari would have been granted anyway, even if the mandatory appeal process simply didn't exist, and 100% of cases were governed by writs of certiorari. The argument was made the cases that the U.S. Supreme Court did decide on mandatory appeals, those were, so the argument ran, important high-profile cases, and surely they would have been, cert granted if certiorari had governed. So that's another reason the distinction at the end of the day wasn't thought to be a big deal. So my argument is that it did make a big deal. It's contrary to that conventional wisdom, or at least if that's putting it too strong, that it made it had an unappreciated influence, the distinction between certiorari and mandatory appeals, and it did make a difference, at least in larger or small ways. So as the title of my of the paper indicates, I'm going to focus on just one of those types of mandatory appeals, not the universe of mandatory appeals, just one, and that's from direct appeals from three-judge district courts, and three-judge district courts for much of the 20th century adjudicated constitutional challenges to state and federal statutes. It's what it sounds like. It would be a trial court of three judges, almost always one appellate judge and then two district judges. And by the statutes as they existed at the time, there would be a direct appeal or available by the losing litigant directly to the Supreme Court, and that would be, at least ostensibly, a mandatory appeal. The U.S. Supreme Court couldn't deny it; they had to decide it. And just due to space and time constraints, I'm focusing on equal protection and due process cases, also revealed in the title, and obviously lots of other important cases by subject matter, but I'm just focusing on those. So to move right along, briefly about the Warren Court. So per the data and cases Professor Hellman has supplied to me, in the 15 or 16 years of the Warren Court, there were 41 equal protection and due process cases that involved direct appeals from three-judge district courts that resulted in full opinions from the Supreme Court. Some of these, I'm sure, are quite well known to everyone in the audience here. Brown versus Board of Education, Baker versus Carr, the famous reapportionment cases, other reapportionment cases are examples. Another one, no less important, though perhaps less high profile, Williamson versus Lee Optical. Does that ring any bells? That's the case that said most economic regulation is subject to rational basis scrutiny. It's a direct appeal from a three-judge district court. I would even say that the summary dispositions, the vast majority of these direct appeals resulted in summary dispositions, mostly summary affirmances. That's true. But some of those summary affirmances, I suggest, also had jurisprudential influence. I'll just mention one from the Warren Court. It's Browder versus Gale. Browder versus Gale. I see Professor Vladeck nodding his head because it's. I think you're nodding your head, Steve. That's the Montgomery bus boycott case from the mid-50s in the aftermath, the post of the Brown decision. The Supreme Court summarily affirmed the three-judge district court which had invalidated the Alabama statutes that the Martin Luther King Jr. and others were fighting against. I have in my notes that's an early shadow docket case because it was a summary affirmance. Okay, moving on. Burger Court. So a lot more. There were a lot more for a variety of reasons, including just more litigation at, of civil rights cases in general during the Burger Court. And I drew on Arthur's work for this as well. There were over 100 equal protection due process cases during the Burger Court, just in the first 10 or 11 terms of the Burger Court. Just some quick examples of this on the equal protection side: San Antonio School District versus Rodriguez, the school funding case. Craig versus Boren, the case that said intermediate scrutiny applies to gender classifications and other sex discrimination cases. On the due process side, Roe versus Wade and other cases challenging abortion restrictions, all direct appeals from three-judge three-judge district courts. So I'm going to move along here now to talk about a bit more about my thesis that I introduced earlier, which is my thesis is not simply that. Isn't it interesting that these high-profile, important cases, got up to the Supreme Court by mandatory appeals from three-judge district courts and not merely certiorari. I think that is kind of interesting, but that's not my thesis. That's the background of my thesis. My thesis, not to blow it out of proportion, but it is that the fact that they came up by mandatory appeals had an effect, some effect. I can't pretend to quantify it. Had some effect both on the content of those decisions, the very fact they were decided. Let me go that change the order. The very fact they were decided by the Supreme Court, the content of the decisions, and the rapidity of change in doctrinal areas in equal protection and due process, all were affected to some degree by the fact they came up by mandatory appeals. So what's my evidence for that? So I think there's various overlapping pieces of evidence for that proposition I just made. One is that during the time period I'm talking about was essentially 1953 to the late 1970s. Because in 1976, actually, the Congress drastically, basically eliminated the three-judge district court and left it intact only for reapportionment cases. So during that period, the justices just openly, unapologetically lobbied against all mandatory appeals, not just those from three-judge district courts, all of them in court opinions, in testimony to Congress, in a variety of other ways. And while I don't think any of the justices actually said this, commentators said that the justices didn't like their hands to be forced, or that's the words that were used. And if the distinction between certiorari and mandatory appeals wasn't a big deal, why did they expend all this energy successfully, mainly to get rid of mandatory appeals by the late or by the 70s and later on in the 80s, if it really didn't make a much difference? Another piece of evidence is I said earlier that at least many commentators implicitly or explicitly said that, well, these mandatory appeals and the cases that come up on writs of certiorari, they're loosely the functional equivalent of each other. Well, not strictly speaking, not really. The reason is that it's long been held by the Supreme Court itself that denials of writs of certiorari have no precedential effect. They have no precedential effect. And that wasn't true for summary affirmances, and that the Supreme Court itself explicitly said, and in full opinions, many of which, by the way, from 3-judge district courts themselves, said that no, that summary affirmances of direct appeals from 3-judge district courts have at least some precedential effect, and so that's seems to be another piece of evidence for that the court itself, in various ways, took the distinctions seriously. So if time permitted, and it doesn't, I could go into more detail about the content and rapidity, as I see it, of doctrinal change, but just to throw out real quick examples. I mean, the reapportionment cases, of course, Baker versus Carr was only one. There were a lot of other reapportionment cases in the 60s and later on too, and almost all of them were, yes, direct appeals from 3-judge district courts, and the reapportionment revolution, as it was rightly called in the 1960s, was facilitated, I think, a great deal by these direct appeals. There are more examples in the Berger court. I'll just mention, due to time constraints, I'll just mention one. The cases on gender and sex classifications that came before, included, and came after Craig versus Bourne, and I'll quote a very well-known scholar who let me see if I can find it here. Yeah, the sex classification, including Craig versus Bourne, that the Supreme Court's attention and change in law in that area. This endeavor, this scholar says, was substantially aided by the operation of the obligatory jurisdiction of the court. Arthur, that's you, who I'm quoting. So I'm not, again, I'm trying not to blow this out of proportion. I think some of my claims here are modest. So I'm not really saying that the court wouldn't. I'm not saying that the court would not have decided Craig versus Bourne and other cases in the absence of these mandatory appeals, but nonetheless, they were mandatory appeals. And I think they had some, that the court felt under some obligation to decide these mandatory appeals, and where they might have, denied certiorari. I have to be careful about attributing too much significance to this, because another well-known scholar, we know who he is. He says this argument in one of his articles, that this argument is obviously undercut by the fact that a substantial majority of appeals did not receive plenary consideration. That's you, Arthur, again. So I'm trying to be modest, but I hear in my claims, but I think there is a difference. So okay, I'm almost done, Judge. So last point. So I think some of this is historically interesting, but it does have a contemporary valence here, contemporary relevance, is because there's a lot of talk these days from a variety of sources about, yes, reviving at least some mandatory appeals to the U.S. Supreme Court. Professor Vladek is one of those scholars who has so argued, but he's not alone in making those arguments. So Steve and others have argued, among other things, that when federal judges decide whether to grant or deny nationwide injunctions or universal injunctions, they have made the argument that they have argued, and I hope I'm stating this correctly, Steve, that at least some of those cases ought to be adjudicated nationwide or universal injunctions, especially against federal legislation or federal law by, yes, a 3-judge a district court with a mandatory appeal to the U.S. Supreme Court. The argument is, among other things, that those sort of high-profile cases would be better adjudicated in that way, both at the trial level and at the Supreme Court level. And other people have argued, Jack Balkin, James Fanders, a few days ago in an article that was published, have argued to various degrees that restoring some, at least selectively, some mandatory appeals would make the U.S. Supreme Court appear less political and less manipulative of its own dockets. So those are real interesting and important issues that I think will be confronted in the near future. So I think, if that comes to pass, it will be and should be informed by the experience that I share with you with the Berger, with the Warren, and with the Warren and Berger courts. So it'll depend heavily on the scope of the restoration, if it happens at all, mandatory appeals. We'll just be limited to a certain number and type of cases, or a larger amount of cases. Another interesting thing to consider would be the summary dispositions that I talked about. That if we restore even a selective version of mandatory appeals, will the justices just summarily dispose of them through summary affirmances or other things like that. And then the final point is there's a lot of talk as well about a closely related issue, the shrunken docket of the Supreme Court, which, Arthur, I will attribute to you again on one of the title of one of your well-known articles. Is it a good or bad thing to have this shrunken docket for a couple decades or more now, and how, if at all, will or should a revival of mandatory appeals deal with that? So, Judge, I'm sorry if I went beyond my time, but I am done, and I'll look forward to any comments anyone has, as well as the rest of the symposium. Thank you.
Thank you. Thank you. Before we turn to the next speaker, I'm curious to get the panelists' thoughts on this. Maybe I'll start with Professor Vladeck, because I know Professor Salamini mentioned, that you've written on kind of the maybe the mandatory appeals and the politicization of maybe that reduces sort of the political overtones of the Supreme Court. And then sort of curious too about maybe everyone's perspectives on that as a way of, maybe it's a check on nationwide injunctions. And I think, Professor Wang, you maybe wrote on conflicting injunctions, which I'm not sure plays a role in this, but I'm sort of curious to get your thoughts on that, as well as any judicial perspectives as well. But sir, maybe Professor Vladeck. We have to turn it on.
It's green.
Up there.
There you go. Oh, okay, now it's on. So, I mean, I think we should put a couple of numbers on this first. So the Supreme Court this term is set to decide 60 cases after full argument and consideration. It's going to be the 5th term in a row that the court doesn't get over 60. Just to put that in context, the last time the court decided fewer than 60 cases was 1864. Right, compared to 150 cases as recently as the mid-1980s. I don't think it's going to be that helpful to spend time fighting over exactly which categories of cases we ought to be adding back to the court's docket, but I think we can probably build pretty broad consensus that when the court's deciding 60 hand-picked cases a year, the decisions of the Supreme Court are going to skew toward the cases the justices are interested in. And when only one side of the court has the ability to grant certiorari, since it takes 4 votes to grant cert, that skew is going to have ideological connotations as well. And so I think, it ought to be relatively uncontroversial that it would behoove the court to do more that looks less ideologically charged. And, obviously one way to do that is for the justices to commit to taking more cases. Jeff Fisher at Stanford has proposed reducing the threshold for certiorari to 3 votes. I'll just say, sort of preview of coming attractions. I think there are other reasons why having Congress restore mandatory jurisdiction would be salutary, not just to have the justices deciding more cases that they don't want. And, just to sort of throw one possibility out there, besides nationwide injunctions, which gets into a whole definitional problem, what about a universe in which a majority of the active judges of any federal court of appeals could vote to require the Supreme Court to take up a case? That may sound odd. That may sound odd to you. That procedure is already in the United States Code, and not even a majority of active judges, a majority of a panel. It's the Supreme Court that has turned that process, which is called certification, into a dead letter. Doesn't have to be, right? And so there are lots of different ways to get at the same problem. It seems to me that the starting point is, if we could build consensus that the shrinking docket is not necessarily a good thing, that there are categories of cases, even if we might disagree about which ones they are, that the court ought to be taking that it isn't, and that more fundamentally, Congress asserting more of a role in managing the court's docket would actually have lots of positive direct and indirect effects.
Professor Salmin, I think, referred to, or at least alluded to, at least how I construed it, maybe potentially perverse incentives and effects of mandatory appeals as well. I mean, Professor Shapiro, I don't know if you can touch on this a little bit. I know in Rucho, there were some Supreme Court justices that pondered during oral argument, well, if we make all these partisan gerrymandering cases justiciable, we're going to get a lot of these cases. So maybe, I think some commentators thought, well, maybe that's why they're non-justiciable. I mean, are there similar effects here, concerns, and just when we talk about docket control? I think Professor Salmini alluded to back in the old days, some would argue these were just summary denials. Any thoughts on that?
Yeah. Am I on? Okay, good. So in Rucho, the Supreme Court said in 5-4 decision that partisan gerrymandering is a non-justiciable political question because it does not come with judicially manageable standards. And I'm actually going to talk about that in a moment from another perspective. But one of the things that happened during oral argument, it's not in the opinion, but during oral argument, the Chief Justice said, well, we have mandatory jurisdiction over these cases because one of the only categories that's left of mandatory jurisdiction, and really the only functional one, is constitutional challenges to apportionment, redistricting. And he said, so we'll be getting all of these cases, and won't that make us look so political? Just kind of ironic, given what we've just been saying about the discretionary jurisdiction being political. So we really, that should be a reason why we don't take these cases. Now, I don't actually think that the existence of mandatory jurisdiction in that context is in any way relevant to the constitutional question of whether these partisan gerrymandering is a political question. But leaving that aside, it actually gets the history backwards. The history of that one thing being left for mandatory jurisdiction in the 1980s is that the civil rights community went to Congress and said, look, if you're going to eliminate mandatory jurisdiction, which we don't want you to do, by the way, but if you're going to do it, please don't do it for reapportionment. Those cases are so important. We think they really need to go to the Supreme Court directly. We want you to keep it. And the Congress did. So there was something particularly ironic about this concern that somehow mandatory jurisdiction means we shouldn't take these cases. It's completely ahistorical, and I think misconstrued the maintenance of mandatory jurisdiction there. So it had sort of this ironic, perverse effect in the run of history, where it had the opposite effect of what was intended. And now the Supreme Court says no federal courts can hear these cases or of this particular type of constitutional challenges. There are, of course, others that do continue.
Thank you. Judge Hardiman, any thoughts on this from where you're sitting, either, as a circuit judge or even back in the old days, maybe when you were a district judge, as to this process?
Well, I'm fascinated with the thought of being able to force the Supreme Court to take our cases. I hadn't thought of that before.
You're welcome.
And I also have to disclose a conflict of interest because I've been reading slip opinions since 2003 when I went on the district court, and my summer beach reading has declined substantially, giving me more time to read books. But I take the point, certainly on the circuit courts, we do sometimes see ripe circuit splits that are not getting resolved by the Supreme Court. And of course, our job is just to get it right and to do what the Supreme Court is telling us to do. But when you've got these ripe circuit splits that can promote a greater uncertainty, and then perhaps you could say they're waiting too long to decide certain issues, because when you look at the gap of time between, for example, Heller and Bruin, it was, I don't think I'm being too critical of ourselves and our friends on the district courts, but there was sort of chaos out there in the jurisprudence in that interregnum between Heller and Bruin. So I'll be curious to see if in this very dynamic area, they quickly took Rahimi after Bruin. So I'll be curious to see whether they take more Second Amendment cases to try to provide more guidance to the lower courts.
I mean, that's a good point, and I'm sort of curious if the other panelists have a thought on that. I know from the judicial perspective and a lawyer perspective as well. I remember when I was a lawyer and defending class actions, we were all waiting for Spokane. And we were waiting and waiting. Everyone's moving to state cases. Oh, look out. Here comes Spokane, which is, is a standing case. And if you're defending class actions, including like statutory violations under Fair Credit Reporting Act, everyone's like, don't worry. Supreme Court is going to decide this issue. Then Spokane comes out and everyone's scratching their head, standing and requiring concrete harm. But what does that mean? And then we have to wait, I don't know how many years after that till 5 years until TransUnion before the Supreme Court explained to us what that means. Meanwhile, judges have been staying all these cases and then decide, and I think there were a host of circuit splits, I believe, that led to that point. But would mandatory appeals have assisted, sort of forced the Supreme Court maybe to take a broader view of the issue? Maybe decide a little bit more, the first time around, and whether it's in Heller or in Spokane. I mean, Professor Salmi, I guess I'd start with you on that.
Yeah, real quick, it would. Yeah, it could. It could, provide a mechanism for more rapid resolution, whatever it may be, by the Supreme Court of those issues. But the Second Amendment cases, are constitutional cases, which would fall into the old ambit of the three-judge district court. The Spokane cases are it's statutory, are non-constitutional federal statutory cases. So you'd have to, include, make it broader if you were, restoring some version of mandatory appeals. It would have to be in a broader way, which I'm not saying is necessarily wrong. But it would probably be more controversial, I imagine. And I'm also guessing that based on past experience, the court wouldn't, wouldn't think kindly of expanding its mandatory jurisdiction.
I would say that I don't know that it would make the court decide the big questions earlier in terms of but would it have said more in Spokio? I don't think it necessarily would, but it does give the court the opportunity to do common law judging in a more meaningful way. And which is something that that actually Professor Hellman wrote about in his Shrunken a number of years ago, and that I'm about to talk about too, again, but that there's the sort of the values of judicial minimalism, of which there are many, are served less well when there are so few appeals than when the court is going to be incrementally addressing the same issue more frequently.
Professor Wong, you gonna say something?
Sure. This is on. Yes. I'll just add a word of caution. We've already heard kind of 3 cautionary tales about we've already heard 3. The Supreme Court being very good at not deciding what it doesn't want to decide, with apologies to Judge Hardiman's hopes and dreams. There's not going to necessarily be a lot of actual foisting of issues on the court. I mean, we've heard a story about certification becoming a dead letter. We've heard the story about mandatory appeals in the past being treated as if they were certiorari through summary affirmances, or now flat out dismissals. They'll just dismiss, they'll just not take it for want of jurisdiction, whatever that means. And then we've heard a story about sort of possible incentive effects or spillovers on doctrines, as we heard in the Rucho case, and also Spokio itself is a case where they decided the standing issue in a weird way because they were trying to punt the case on something else, and that may have actually made things worse. So just a word of caution, not to say that it shouldn't be proposed, but there are things to be solved.
Okay. Well, why don't we move on to Professor Shapiro?
Well, I'd like to start, of course, by thanking Professor Hellman, whose work has been incredibly valuable to me. And I was honored when he himself reached out to, we've never met before today. In fact, we still haven't met face to face. He reached out to me directly to invite me to be here, which I very much appreciated. And I also want to thank the Law Review staff and editors who've been incredibly well organized and professional in putting this together. So it's wonderful to be here. You've already heard a little bit about Professor Hellman's article from 1996 called The Shrunken Docket of the Rehnquist Court. And you've already heard a little bit about the context for that article, but just to reiterate, in the 70s and most of the 1980s, the Supreme Court was deciding and hearing argument in and deciding about 150 cases a year. And that sounds, I think, to us today with this 60 cases a year, like really quite an astonishingly large number. And even then, I think it's fair to say people thought that was a lot. People thought that was at the absolute maximum of what the Supreme Court really could realistically manage, maybe even beyond that maximum. And if you go back and you look at the judicial administration literature from the time, whether commentary in law reviews or speeches or reports that people were writing, there was all kinds of concern about what we were going to do about this 150 cases a year. There were proposals for things like an intermediate National Court of Appeals, things like that, things that we don't even bother to think about today because we are now in this new universe of 60 cases a year. But to go back to Professor Hellman's article in 1996, by the mid-1990s, the Supreme Court's caseload had shrunk dramatically. In the 1995 term, which was the last complete term that he addressed, the court had only 77 fully briefed and argued cases. And the question was why? And in this article, Professor Hellman analyzed in his very meticulous and careful way a number of possible explanations for why there was this dramatic decrease in a relatively short period of time. And one obvious explanation is what we were just talking about, that in the late 1980s, Congress eliminated almost all remaining mandatory appeals. But Professor Hellman concluded that that change in the law did not actually really explain much of the decrease in cases. And I'm not going to go through how he reached that conclusion, but he basically says we can't know for sure because there are lots of things we can't observe, but it does not look like the mix of cases that is coming up and that is being granted would suggest that there were that is the explanation for the reduction in cases that are being argued. Instead, he concluded, and this is a quote, that the primary agent of change was the Supreme Court itself, a change in its view of its role. The court, he argued, had become Olympian, and that is his term. It was taking a less judicial role, less interested in common law judging. Instead, it stepped in only to resolve really big issues, whether they were big, important direct conflicts between circuits, but not all circuit splits were being addressed, maybe to protect the US government's important interests when the Solicitor General said, hey, we really, really, really want you to take this case, and maybe sometimes to protect the supremacy of federal law when state courts were pushing back against it. As a result, he argued this Olympian court was further from the work of the lower courts than it had ever been before, and especially the most routine workaday cases. And it was willing to tolerate more doctrinal gaps and inconsistencies. So now I'm going to just take a point of personal privilege and tell you why this Olympian court metaphor or idea is important to me just as a matter of my own scholarship and development. When I joined the academy, I came from a plaintiff's side civil rights practice. And I came in with a very specific question as my first project, which was why were the lower courts so inconsistent in the application of the standards for summary judgment in employment discrimination cases? Even after a 2000 opinion by the Supreme Court that many people believed instructed the lower courts to be less willing to grant summary judgment to employers in those cases. And the answer, I concluded, was in large part a feature of this Olympian court. The Supreme Court's real lack of interest in evaluating whether a correctly stated standard, and the courts all can state the standard correctly, they all do, is being consistently or properly applied. So my very first law review article, and I have a visual aid here, was called The Limits of the Olympian Court, Common Law Judging versus Error Correction in the Supreme Court. So it's been, in preparing for today, I've revisited the shrunken docket of the Rehnquist Court, and I revisited what I wrote now quite a few years ago. One thing that I discovered in revisiting that literature is that Professor Hellman made several predictions in 1996 about the impact of the Olympian Court that seem quite extremely prescient today. Here are two. When the court addresses a particular statute or doctrine only in isolated cases at long intervals, the justices may not fully appreciate how the particular issue fits into its larger setting. And they may lose sight of the practical aspects of adjudication that emerge only when judges actually apply their rules to resolve disputes in a variety of factual contexts. Now, I think those both ring true today, and one example is one that we've already alluded to or discussed. We didn't allude to it, we talked about it, which is Bruin. And I think we talked about, or Judge Hardiman talked about the gap between Heller and Bruin and how there was much disarray in the lower courts during that period of time. Bruin itself did not necessarily make things better. Bruin announced a new historically focused test for determining if gun regulation is constitutional, and it's a test that doesn't exist in any other constitutional context, requiring looking back at the types of regulation that were in place at the founding. And commentators and judges across the political spectrum have complained and started complaining within 3 months of Bruin's being issued about how incredibly difficult it is to apply Bruin. Only 3 months after issued, Professor Jacob Charles, who's a Second Amendment scholar, started documenting the inconsistent ways that lower courts were implementing Bruin. Only a year after the decision was issued, the Brennan Center documented that federal judges appointed by Presidents Reagan, Clinton, George W. Bush, Obama, Trump, and Biden were complaining about its unworkability. Strong supporters of Second Amendment rights, including Randy Barnett, argued that Bruin gave lower court judges an enormous amount of flexibility and was unworkable, again, in large part for that reason. I will say that the Supreme Court did take Rahimi, a case involving whether or not the Second Amendment prohibits the government from removing guns from people who have orders of protection due to domestic violence. And in the oral argument in Rahimi, we don't yet know the result. It certainly seemed that at least some of the justices understood that the Bruin test itself was creating problems. But I think a similar set of arguments about the court giving direction that doesn't take into account what it's actually going to be like to implement that direction could be said about other cases as well. And I'd say one of them is Dobbs. The Dobbs majority, I think, appeared to believe at least that once they overruled Roe versus Wade, there just wouldn't be cases about abortion anymore. Now, that's obviously not true. It wasn't true then. It shouldn't have been something anybody thought at the time. And I am not, they didn't say that in so many words for the most part, so I'm inferring that. But it really is was a fail to the extent that that's what they were thinking, or some of them were thinking. It's a failure to understand the way that one set of precedents, Roe and Casey, interact with all other areas of law as we are seeing today. The right to travel, the FDA's authority to regulate medication, Medicare regulation of hospitals. We're going to see there's going to be endless abortion litigation. It's just going to look very different. And I think the failure to recognize that, or at least to acknowledge it, is a kind of Olympian distance from, if not the work of the lower courts, then the workings of the law. And I'll say, I think Rucho too is an example of this. I talked a minute ago about how Rucho, in Rucho, the Supreme Court or the Chief Justice expressed concern about mandatory jurisdiction. But there's another thing about Rucho that I think is Olympian in this sense. What the court said in Rucho was that the standards for evaluating partisan gerrymandering were not susceptible to judicial management. There were no judicially manageable standards, and that's why it needed to be a political question. But as Justice Kagan pointed out in her dissent, lower courts had been doing this. There were all kinds of opinions in the lower courts where they were, in fact, developing a method, applying the method, sometimes ruling that partisan gerrymandering in a particular case exceeded constitutional bounds, sometimes ruling that it didn't. And the court itself even said, state courts can do this under their state constitutions. It's not really clear to me why it's more judicially manageable for state courts to do it than for federal courts. But again, it was a sort of Olympian disregard of what had been happening in the lower federal courts. Now, I want to pause here to say that cases like Dobbs and Bruin and Rucho, of course, are all really hot button, hotly contested, controversial cases. And they're not, of course, the only kinds of cases that the court takes. And it even in areas that are controversial, sometimes does take a series of cases to sort of home in on a particular standard or method or ruling. And maybe in retrospect, we will see that in some of the areas I just talked about. Professor Hellman pointed out to me the Janus case and the cases leading up to it, in which the Supreme Court said that fair share fees paid by non-union members in public employment violate the First Amendment. There was a series of cases before the court finally made that announcement. And of course, the court decides a fair number of more technical cases that we mostly don't hear about, because they don't have a powerful political valence, although as we were discussing, perhaps not enough of them. It still is unanimous in somewhere around a third of its cases, and in many others, the split is not along ideological lines. But even in the less ideologically charged cases, even in some of the unanimous cases, if you look to see what people who practice in those fields say, or you look to see what lower court judges say, there are a surprising number of complaints about how the court is giving inadequate or unrealistic guidance. And there are fewer cases overall. So just proportionately, it appears that the justices are spending an awful lot of time on these hot button cases relative to what I'm going to call the more workaday cases. Now, as Professor Hellman has also recently pointed out, there's information the court itself has provided indicates that there's another way in which the court is not engaging deeply with these more workaday cases. And that has to do with the discuss list. The discuss list is the list that circulates among the justices. Any justice can add a case to the discuss list. And those are the cert petitions that the court will discuss at conference. Any case, any cert petition that's not on the discuss list is automatically denied. And so they just don't talk about most of the cases in which a cert petition has been filed. And that's been true for a very long time. What's happened, though, as he determined by looking at information the court itself provided alongside its new code of conduct, that it looks like 97% of petitions never get to the discuss list. And if you do the math, he says, that appears to mean that based on what we know about what was happening in the 80s and 90s, there are now about a fifth as many cases, or even fewer, on the discuss list than were back then. So that means that even aside from the cases that the court is taking to decide on the merits, the justices are delving into even fewer of these more workaday cases to look and see. They don't even have to get up to speed enough to talk about them at conference. And I think that's only likely to exacerbate the problems that Professor Hellman described in the shrunken docket. If we look at the court and its role today, I think that really is what we see happening. I can't really make claims of causation here, but I want to end by talking about what I see as a constellation of factors that are mutually reinforcing. We have the justices at an increased remove from the routine work of the lower court. At the same time, we do have a court that, as Professor Vladeck has demonstrated, he's not alone, is increasingly willing to decide interlocutory matters in contexts that in the past it would have refused to get involved in. Perhaps the spending less time on the sort of day-to-day workings of the lower courts means more time to spend on involving itself in these very high-profile shadow docket matters. And we have a court that has, across a wide range of subjects, limited the power of other institutions, Congress, the administrative state, the states, lower courts themselves, while claiming power for itself, as Professor Mark Lemley has laid out in his 2022 article, which is called The Imperial Supreme Court. Now, Professor Hellman in 1996 warned explicitly that the court seemed to be on its way to becoming increasingly imperial, a word he also used. I don't think his use of the term imperial is exactly the same as the way Mark Lemley uses the term, but I do think what we can learn is that his careful analysis of what the justices spend their time doing interacts with, and how that interacts with what they do, with the substance of what they do. And that provides really important insight for critics and defenders of the court alike. I think that we all owe Professor Hellman a debt of gratitude in helping us reflect on the way that procedure, the way that the administration of justice and the administration of the court has such a profound impact on the substance of what the courts do. Thank you.
Maybe we can start by Judge Hardiman, maybe getting your thoughts on thoughts or airing of grievances on something on what Professor Shapiro alluded to, and I think we talked about this before, but I know when I had read Bruin, the dissent in Bruin, and then also the dissent in Kennedy, both alluded to the fact that the tests that were implemented were very historical based, and how are the lower courts going to grapple with dealing with these issues? Any thoughts on that in terms of the sort of disconnect, either in that context or even broader?
I do have some thoughts on that, but looking at the clock, I want to make sure Professors Wong and Vladeck have a chance to say their piece. So I'm going to defer to them.
Okay.
And then come back around if we have time.
Okay. That makes sense. Thanks for looking at the clock. Professor Wong, do you want to go?
Hi, can you hear me okay? I feel like the Wizard of Oz. Pay no attention to the man behind the podium. Someday AI will make that talk, and then it will be really, really a treat. Well, I'm so honored to be here, here in the presence of so many scholars I've admired for so long, and also so many intimidating judges. I was joking with a friend last night that there are enough judges here for a Ninth Circuit en banc. So Judge Schroeder can correct me if I'm wrong. This friend I was joking with, by the way, is an appellate lawyer who came in from DC, happens to be the nephew of one Arthur Hellman. I presume my friend is here for CLE credit. I don't know why else he would be here. Oh yes, exactly, right. But it's wonderful to be here and to get to celebrate Professor Hellman. Many thanks to the Law Review, especially Anna and Daniel and Danny. Many thanks to the school, the administration, especially Professor O. And above all, thanks to Professor Hellman for teaching us so much, all of us so much about the federal judiciary. So in 1983, this Law Review published not one, but two articles by Professor Hellman. The one I'll be speaking about is called Error Correction Lawmaking in the Supreme Court's Exercise of Discretionary Review. Now, this article meticulously, you know his articles, he meticulously and with deep insight investigates a particular moment of change in how the Supreme Court does its work outside of its plenary merits docket that we're all familiar with. And it talks about the guidance that these kinds of cases do or do not offer to the public and to the rest of the judiciary. In a way, it was really early work about the shadow docket. Every time I say the word shadow docket, Steve gets a nickel for royalties for his book. So I'm gonna say it a lot. I hope you all do as well. The setup for Professor Hellman's observations in this 1983 article were that in the 1950s and the 1960s, the court had a practice of issuing summary reversals without opinions. Now, you think you've never heard of that. Well, it's because they don't do that anymore. And Professor Hellman's article documents the decline of this and relates it to two other changes. Like, where do these cases go? Well, they declined. The disappearance of the summary reversals without opinions converted into two things. And you can imagine what they might be. One is summary reversals with sort of an opinion, some writing, and then the other was just not deciding them. And instead using a new practice at the time called granting, vacating, and remanding, which we now know as the GVR, if there was an interceding case. So in a way, this was a wonderful origin story of the GVR for me, of the summary reversals with opinions, or some revs, as we now call them, that are all very familiar practice today. Now, Professor Hellman has recently reposted this article with an updated preface, pointing out that we are now again in a time of change along similar lines. And in particular, he writes he notes the rise of the emergency docket or the shadow docket, nickel to Steve, and the decline also of these very summary reversals with opinions that we had just been seeing increase in the 70s. They seem to be declining at the same time that there's a whole bunch more stuff going on the emergency docket. Maybe there's a link, maybe there's not, but without trying to make a causal observation, I think I'll take my time just to offer a couple of quick thoughts about Professor Hellman's invitation to compare these two moments of change. focusing on the quality of the guidance to the public and to the rest of the judiciary that these kinds of rulings offer or don't offer. Here, I'll be drawing on many scholars' works, including Steve, including Professor Hellman, of course, but also Will Bode and Ed Hartnett on some revs, Rachel Bayevsky, Portia Pedro on stays, and also 2 recent law graduates. So those of you who are law students here, you can go out there next year, write an article, and they are Ed Pickup and Hannah Templin, who wrote about experimentation in this form. So let me just say a quick word of background about what I have observed and others have observed as going on in this current moment of change, which is what we'll compare with Professor Hellman's moment of change in the article. Up until like kind of the 2010s, we saw a good number of these summary reversals with opinions, some revs. Up until the 2010s and into 2020, we saw kind of the rise of emergency relief. And yet that emergency relief, the shadow docket work that Supreme Court was doing, wasn't really explained. There wasn't a lot of writing. And this came in for a great deal of criticism of the kind that Professor Hellman noted was happening also in the 50s and 60s about decisions without explanation. So there was not much writing up, although there was a lot of shadow docket activity. And possibly because of the criticism, there sort of was a moment of let's try something new, it seems to feel like, coming from the court. And what we started to see was writings explaining these shadow docket orders. And in particular, writings during the COVID era, starting in 2020, that look a lot like summary reversals with opinions. They look the same, they're called per curiams, opinions of the court. Some of them they are coming out in slip ops on the day you hit refresh and you download it. Apparently, they will be posted in the US reports in the same section. Professor Hellman points out there's a front of the book and a back of the book. These look like they'll be in the front of the book. So in a way, like visually, they're almost indistinguishable from summary reversals with opinions. Now, the court seems to have backed off a little bit from that, although it's not clear that they're entirely gone, because just a couple of weeks ago, 6 weeks ago, we had an oral argument in an emergency, actually injunction case at the Supreme Court on the Good Neighbor EPA policy. And there they are having an oral argument without further merits sort of process. It's not a cert grant, for instance. And so what we've seen in this period is a lot of experimentation where these stay orders or injunction or the court with or without oral argument, with or without some writing, with or without potentially a cert grant, kicking it into the merits docket. So one question for us is, well, where's this going to land? What are they going to do? It doesn't seem like they completely backed off on it. And if they do continue to issue opinions in shadow docket cases that look like per curiam opinions that we're used to seeing from summary reversals, I want to point out a note of caution. I guess I'm the note of caution guy today. A note of caution about this, because these are not the same thing. They may look the same, but they really are not the same thing. And why are they not the same thing? First is that for summary reversals with opinions, when you download one of these and you read it and you realize that they took it up without even having oral argument, yeah, they granted cert, but they didn't have oral argument, they didn't ask for briefing, it's on the petitions. The message there is that this is super obvious, like this is clearly wrong. And that's a marker of like certainty about where the law is and how it applies to those set of facts. The ones that look identical that are coming from the shadow docket are the opposite of that. Shadow docket rulings, because they're at a preliminary interlocutory posture, they're about a stay or an injunction with a standard for relief that involves guesswork about what the law is rather than, or what the law will be, rather than what it is, are statements of uncertainty. It is the opposite of this is so obvious. What these rulings really should be saying is, this is not obvious. We're making a guess. We're not deciding this now because we're going to decide it later properly on the merits. And all we're doing is guessing about the likelihood of success on the merits. That's all we've got here. And yet, we have these two types of opinions that look kind of similar. Potentially, there's confusion for the public, confusion for maybe the judiciary, potentially for lawyers, and maybe even at the court, as other scholars have pointed out, there may be a role confusion where when the justices are writing up something that looks like an opinion, they think they're declaring law in a posture where that's not really what they're doing at all. So just to serve it up as a possible thing to think about, where is this all going to land? We don't know. My hope is that they will use certiorari as the bright line for clarifying for everyone. This is what we mean by the law, and leaving the shadow docket opinions out of that kind of category, either visually or cosmetically, or even in their own minds. So with that, I want to thank Professor Hellman once more for guiding me into this line of inquiry and for teaching us so much.
Thanks very much. It's a treat to be here. Apparently, even Mother Nature is shook by Professor Hellman's work. There was just apparently a 4.8 magnitude earthquake in northern New Jersey. We don't have those in Texas. What I wanted to do in my brief remarks is to try to sort of tie a couple of threads together from what we've been talking about already this morning, and maybe to expand a bit from the specific question of different features of the Supreme Court's docket to all of the other ways in which historically Congress has used various of its powers to nudge the court in particular directions. Just to give you one example, I like to start with this example because it's so ridiculous. In 1882, right, Congress passed a statute basically telling Justice Ward Hunt that if he retired within 30 days, they'd give him a pension. Right, Justice Hunt had had a paralyzing stroke. He wasn't inclined to resign unless he could get a pension. Congress responded by indulging him. That may sound ridiculous. That may sound bizarre. That may sound like something you would never imagine Congress today doing. That, I want to suggest, was the norm for about 200 years, that Congress used an array of its powers, big and small, right, to regulate the court, to nudge the court. And this really, I think, dovetails with one of the broader themes that cuts across so much of Professor Hellman's work, which is interbranch accountability as a critical feature of our understanding of the Supreme Court. Fast forward to last summer, July of 2023, in the middle of conversations about Congress potentially imposing a code of ethics on the Supreme Court, Justice Alito gave this rather remarkable interview in the Wall Street Journal where, responding specifically to questions about ethical rules, he made what seemed to me like a more general statement, where he says, I realize this is a controversial position, always a good place to start, but I'm willing to say it. Justice Alito, no shy guy. No provision, he says, in the Constitution gives Congress the power to regulate the Supreme Court, period. The period is what makes it art. So of course that's wrong, right? Article 3, Section 2 expressly gives Congress the power, at least with respect to the Supreme Court's appellate jurisdiction, to, quote, make exceptions and regulations, what a crazy verb, right, to the court's docket. We've already been talking about some of the ways in which Congress has used that power historically. But even if Justice Alito meant more specifically in the context of shaping the justice's behavior, that's just not true as a matter of historical practice. So let me just quickly outline just a few of the ways that Congress historically has used its powers to regulate the court. Some of these are pretty obvious. Congress controls when the Supreme Court sits. So you guys might know the first Monday in October. You might not know that's a statute that Congress changed most recently in 1917. I don't think even Professor Hellman was writing back then, right? You might, think, well, that's just silly. Of course, the Supreme Court's going to sit. But like the 1904 World Series, there was no 1802 term of the U.S. Supreme Court. Why not? Because Congress was messing with the court. Congress cancels the Supreme Court's 1802 term, basically to say, hey, these fun little cases you have, Marbury versus Madison and Stewart versus Laird, just take your time thinking about them. Don't worry what's going to happen if you decide them in a way we don't like, right? We're just going to give you a whole year off. Right? Congress using its power over the court's calendar to nudge the court, to push the court. Where the court sits, probably not something else you spend a lot of time thinking about, right? The Supreme Court today has this beautiful, ornate marble building in Washington that was, among other things, the brainchild of President and later Chief Justice William Howard Taft. Congress used to sit in the Capitol. Not just in the Capitol, until 1860, Congress sat in the basement. Sorry, the Supreme Court sat in the basement of the Capitol. What does it tell you about the power and independence of the Supreme Court that it sat in Congress's basement? How many of you guys have lived in your parents' basement? Right, who was independent? You or them, right? When you depend upon Congress for janitorial services, for electricity, right? These are things Congress can use to control, to influence, to regulate the court. Part of Taft's argument for the Supreme Court getting its own building was to make the court less dependent on Congress, and Congress acquiesced. Here's an easy one, the size of the Supreme Court, right? Congress controls how many justices there are. We know that one, right? Justice Alito himself sits in a seat Congress created in 1837. I don't think he thinks his seat is unconstitutional, right? The court's budget, right? Something else that Congress has long controlled. Now you might be saying, well, wait a second. I remember from Professor Hellman's class that Congress can't reduce the salaries of the justices. That's true. What percent of the Supreme Court's FY 2024 budget request do you think the justices' salaries are? Throw out a number. If you said 2%, you would be correct, right? The Supreme Court's budget request for FY 2024 is $151 million. $3 million of that is the justices' salaries. That's $148 million of leverage. Right, so when we talk about how Congress is never going to pass legislation regulating or reforming the Supreme Court, I guarantee you that Congress will pass the Supreme Court's budget. We have not yet quite made the buttons of defund the court, right? But this is not just a power, this is a lever, right? Congress used to use its power over the court's budget to require the justices to come and testify about things. One of the most interesting Supreme Court-related congressional hearings of my lifetime was when Justice Kennedy showed up in 2001 to ask Congress for money after Bush versus Gore. And Kennedy was in the awkward position of having to publicly defend the court's decision in Bush versus Gore in a congressional hearing. That's useful. That's inter-branch accountability. That's how these things work. All right, pensions and retirements. I mentioned already the story of poor Justice Hunt, right? Congress used to not give the justices pensions at all. And then Congress created a very strict regime after the Civil War. And then Congress sort of moved the regime around. And then finally in 1937, Congress gave up, right? And created a sort of a standalone regime where the justices could retire on their own terms as long as they met particular pre-requirements. As a result, Congress has sort of surrendered the power it used to have, right, to regulate the court. Okay, and then, right, behavior, right? Congress, this is Justice Alito's central point, Congress can't tell us how to behave. Well, Congress has done a lot to control how the justices behave. Just one story to illustrate this, when Justice Fortas resigned from the Supreme Court in May of 1969. By the way, the last day on which the Supreme Court had a majority of justices nominated by Democratic presidents, May 14th, 1969. He resigned at least largely because he feared what Congress would do if he stayed, right? He was worried about the specter of an impeachment investigation. He was worried that Congress might shift its sights to Justice Douglas. It's Chief Justice Warren who goes to Fortas and says, you've got to resign for good of the court because otherwise Congress will come after us. I don't think Chief Justice Roberts has gone to Justice Alito or Justice Thomas and said, wow, these stories in the press, you know, you got to resign, otherwise Congress is coming after us. Why? Because Congress has stopped coming after us. Okay, so it seems to me that when we talk about all of the levers Congress pulled historically, controlling the docket, controlling the budget, controlling the building, controlling the justices' travel, which used to be, by the way, by horse and not yacht, right? Congress circuit riding, something Congress made the justices do in some way, shape, or form until 1911. My favorite fact about circuit riding, at least in the beginning, Congress didn't even pay for it. right? Hey, do you want to be a Supreme Court justice? Great. You're going to spend 6 months out of the year traveling around the country in 1794 when there are no roads, right? And we're not going to pay for it. There's an early justice you've probably never heard of named Thomas Johnson, who resigns after about 190 days in office because, as he writes in a letter to George Washington, he was completely misled about what the job was, right? The point is not that these are interesting, fun stories. The point is that these stories all circle around what used to be and isn't anymore, right? That to me, when we talk about what makes the current Supreme Court unique, and I will editorialize uniquely problematic, right? The point is not a particular data set about its docket. I think that's a symptom. The point is not particular quotes by justices in the Wall Street Journal. I think that's a symptom. The point is not Chief Justice Roberts telling the Senate Judiciary Committee, no thanks, I'm not going to come testify. We don't do that sort of thing, parentheses, except when you want something, right? Another symptom. The point is not that any of these things are unique. The point is that this is signs of a Supreme Court that is no longer accountable to the elected branches in ways that historically it used to be. And it leaves us with the impression that maybe it ought not to be accountable to the elected branches in the ways that it used to be. And so when I think about what makes this moment of the Supreme Court different, the culmination not just of Professor Hellman's work, but of so many other threads in scholarship and in history, it's not that there's a 6-3 conservative supermajority. We've had that before. It's not that the court has a rather casual relationship with prior precedent. We've had that before. It's not that the court is handing down decisions that are divisive publicly. Guess what? We've had that before. You might have heard of Dred Scott, right? What makes this moment unique is how unaccountable the court has become. And part of that is because we have stopped talking about and teaching all of the levers Congress used to pull, and we've stopped talking about why Congress doesn't do it anymore. And that, to me, is one of the great lessons and real contributions of Professor Hellman's scholarship, which is it is wrong, it is impossible, it is malpractice to talk about the Supreme Court in isolation and to not talk about all of the ways in which the Supreme Court historically has been and ought to be in conversation with the other branches of government. Thank you very much.
All right, thank you. Given where we are on time, I think it probably makes sense for maybe the panelists to provide their kind of final thoughts on their own presentations and maybe the other comments that were made here today. I'll start with Judge Hardiman, who I know doesn't have a formal presentation, but I think is coming at this from more of a judicial perspective. We can maybe come down the line here.
Yeah, I think I should defend the court now because, you know, I mentioned earlier that circuit judges talk sometimes about, you know, gee, there's this ripe circuit split and why isn't the court taking it up? And, you know, one of the reasons I think that's the court sometimes doesn't take cases that circuit judges would like to see them take is this development of the Supreme Court bar. You know, to the extent Professor Hellman is correct about the Olympian sort of nature of the court, you know, it really isn't accessible to the regular lawyer in Toledo. You know, there really is this Supreme Court bar, and you do get the sense that they're only taking cases from the elect. And, you know, that sort of offends my, to the extent that's true. I don't know if that's true, but that's a sense. And to the extent it is true, that does sort of offend my democratic sensibility as a trial lawyer, you know, small d, not political. Because, you know, I tried cases, I did appeals, you know, it was kind of fun to do cases at all levels. Trial court, the intermediate appellate court, the Supreme Court of the Commonwealth of Pennsylvania. And that just seems to have gone away. And I also do think the panelists are correct to the extent they're saying that these big blockbuster cases are taking a lot of oxygen out of the room. But in defense of the justices, you know, they're getting 50 to 100 amicus briefs in several of these cases. And I also think the digital age has a real impact here. You know, we're living in a society that wants answers and they want them now. So it's sort of taken away from, I think, the historic deliberation that the appellate courts, including our own court, have been able to enjoy over the years. We're getting all kinds of interlocutory appeals on our court. People want answers and they want it now. And they don't like what the district court judge did and they want us to reverse it now. And that's even a change I've perceived from, 17 years ago when I first went on the circuit court. And you see also Congress is exercising its power in some ways on us with CAFA. We've got to, these CAFA cases can be very complex, but you got to decide them, within 60 days. I think it's 60. So we're living in a society that is real time. And I think the judiciary, what I've always loved about the judiciary is it's very countercultural. We're living in a society that is immediate, intense, frequently rude and intemperate, and often wrong. That's how I view the digital age anyway, the blogosphere and the Twitter sphere, whatever you want, the exosphere, is that what we'd call it now? And what I love about the judiciary is that we're slow, we're patient, we're cordial, and I'd like to think that we're frequently right. And I'm a little concerned that to the extent that the courts are under pressure to sort of stop being countercultural, I fear that that's going to conduce to worse decision making.
So guys, just to piggyback on that, just to add one data point that might illustrate this. The Supreme Court has the power to grant something called certiorari before judgment. And that's basically granting certiorari before the Court of Appeals has had the chance to do its full review. Cert before judgment is an innovation of the Judges Bill in 1925. And it was really meant for the once a generation cases where the question was so important and time was so of the essence. Basically your common law class. So the Nazi saboteurs case during World War II, the steel seizure case, the Watergate tapes case, right? The Iranian hostage crisis case. You could sort of color them by history. Between 2004 and 2019, the court grants cert before judgment 0 times. Since February 2019, the Supreme Court has exercised its discretion to grant cert before judgment 21 times. That's a lot, right? And that's a court that is, I think, maybe having its hand forced by lower court decisions. It's a court that maybe is responding to other pressures, like wanting to take these cases quickly instead of deciding them through the context of emergency applications. Again, the point is not that there's one cause. The point is that this is a really significant shift in the Supreme Court's docket, in the behavior, in the nature of cases that the justices are deciding. They're now getting them on an even skimpier record. The student loan case, the Supreme Court decided last term, one of the biggest decisions of the term. In the lower court proceedings, in the district court in St. Louis and in the 8th Circuit, the 2 lower courts between them before the Supreme Court ruled combined devoted 1 word to the merits. The 8th Circuit called the merits substantial. Right? This is, the Supreme Court has said historically, we are a court of review, not first view. That's not true anymore. I have an article coming out called A Court of First View about how the court is now a court of first view. And again, this is not an ideological point about conservatives versus liberals. This is not a point that this is per se bad. There probably are cases where we're going to want the court to move quickly. It's just a point that is so, I think, deeply aligned with Professor Hellman's work that these are shifts in the court's behavior happening right in front of us. Something is causing those shifts, and we ought to take seriously the possibility that those shifts are producing negative consequences that either the court or Congress or both should be addressing.
And just to follow up, is one of the shifts that what seems to me to be the increase in complaints among some of the justices that we're deciding this case on a question that we didn't grant cert on. And as I've said to my law clerks on many occasions, one big distinction between our court and the Supreme Court is they're deciding questions. They literally, they grant cert on questions. I don't think I've ever decided a question in 20 years as a judge. I decide cases and controversies. Now, embedded within those cases or controversies are many questions, many issues, but we are singularly focused on deciding the case. not the question. And I don't know if that's changed over, I don't know enough about the Supreme Court to know if that's changed over time.
I think it's accelerated over time. I mean, right? So one of the innovations of the Judges Bill, the Judiciary Act of 1925, is the shift from with the shift to cert. It's actually Chief Justice Taft who converts this into questions, not cases. There's a great new article by Ben Johnson, who's at Penn State. Am I allowed to say Penn State in this room? What's that? Was at Penn State when he was at Penn State. All right, now he's in Florida. Sorry, Merritt. Go Gators. But so Ben has this great article about sort of the rise of question selection. And one of the things that happens is not only does the court claim the ability to only resolve specific questions as opposed to cases, which Taft had specifically said the opposite in testifying in favor of the Judiciary Act, but the court actually starts writing the questions itself. So let's just take two slightly visible cases from 2 terms ago, Bruin and Dobbs. In Bruin, the court decided a question that it wrote, not that the parties presented. In Dobbs, the court decided a question that no one presented, right? Again, you might say, no problem, I love those results. You do you, Supreme Court, right? But the point is how much power this is the justices claiming in a context in which historically Congress asserted more of a role. And again, like we might disagree, Judge Hardiman and I might disagree about sort of what's good and what's bad. What should be undeniable is this is different. And it's different in ways that really ought to influence how we think about the current court.
We're almost out of time until we have a couple more minutes. Just get final words. Maybe Professor Wong, anything you would like to add?
Sure, just to step back or look at this conversation from an airplane above. I think what struck me about today's conversation, and also what struck me about a conversation I had with Arthur in preparation for this, is how much a sense of history of the court's practices can really frame a lot of these current changes. And it's kind of obvious that there's a lot to learn from history, although I didn't quite think that. And it was reading Arthur's work. And I said to Arthur, when I close my eyes and I think about a map of Germany, there's still like an East Germany and a West Germany, just because like that's the formative moment when I learned what Germany was supposed to be. There's a formative moment when I learned what the Supreme Court was supposed to be. And that's completely contingent on that moment in time. It's always changing, as Arthur said to me, it's always changing. And that's something for us to help, that's something that can help us understand now, but also maybe help us be more imaginative about what the court could be.
Thank you. Professor Shapiro, any final words?
Yeah, I just want to pick up on what Judge Hardiman and Steve said about questions and issues. I think that one of the ways in which the court is I think it has always, well, I don't want to say always, for a long time, it has sometimes been a little bit loose with the record when it decides cases. It like takes into account things that aren't in the record. It looks at things that are in the amicus briefs. It might, right, and there are reasons why I think that's okay, to the extent that what the court is doing is laying down a rule for the whole country. And in many ways, that's more important than the specifics of the particular case. But I think the court has gone significantly far in the other direction, where it is really just disregarding entirely fact-finding by the district court in a variety of different cases, and in particular in hot-button controversial cases. I think the court increasingly seems to see itself as a political player. I think other people certainly see it as a political player. Litigants are trying to use it in that way, and it seems to be happy to go along with that. I agree Congress could address that, but the court itself could address that as well.
Professor Salamini, any final thoughts?
Okay, I'll use this just very quickly. Those are great comments, and just to pick up very quickly on something Judge Hardiman said, I've been struck by the rise of amicus curiae briefs, and the shrunken docket has been accompanied by many more amicus curiae briefs filed, and maybe there's a connection there. The few and it's been mentioned that the fewer cases heightens their importance, and there's just been an avalanche of such briefs. The Solicitor General of the United States, when the U.S. is not a party to a case, frequently weighs in either at the court's invitation or just by itself. And some people, I'll just mention one, Allison or Larson at William and Mary, and others kind of wonder and worry about that. Not that no one is arguing, to forbid amicus curiae briefs from being filed in the Supreme Court or in lower courts, mind you, but still, you wonder about the effect on the court itself and in the public perception of the court by the avalanche of such briefs. And per your point, Carolyn, the use of them on a kind of then citation of them on seemingly inconsistent or odd ways by the justices. So I didn't want to end on a melancholy note, Judge, but that's my comments. All right.
Well, Judge Arndt, I'll give you the final word.
Okay. I'd be remiss if I didn't also add to the praise of Professor Hellman, and much has been said about the substance of what he has written over the years, but I just want to make one note about the tone, because I think that it's really important to look at Professor Hellman as a model, because he has shown us what constructive criticism is like. And we're living in a world right now that is so full of destructive criticism. And I want to personally thank you for that, Arthur. And I want to also say that, if we had more constructive criticism, then I think those of us serving in the third branch would feel a lot less besieged. We need to be held accountable. The Supreme Court needs to be held accountable. And the way to hold us accountable is to read our opinions and write thoughtful articles telling us where we went wrong. So I'm very grateful to you, Arthur, for that.
All right. And I think we can end on that note. So I want to thank the panelists and give them a round of applause. Thank you, everybody.
Okay, we're going to have a relatively short break, coming back at 11:10, not 11:05. Should be a good one. Thank you very much.
May not be able to stick around too much longer. I just want to say thank you. Good job on thank you. I might have to duck out here in a few minutes. We have a gift for you. Oh. Yeah. Totally. Thank you. Good job again. Thank you. Thank you. Yeah. Yeah. Time.
Yeah, so your bags are they checked? Yes, yes, it is, it is. Did they give you a tag? That would be great. And then they said we can have, as long as we have the tag, we can come over and grab it. Yes, we'll go get it during the panel. So if that works, if you grab that, thank you, thank you. Yeah. Good card. Daniel, Judge Hardiman. He's right there.
Okay, that's yellow and that's green.
Professor Hellman.
Thank you very much and good morning. We're going to move now into the segment of the discussion dealing with where the real work of appeals takes place. That's not in the U.S. Supreme Court, but of course in the United States Courts of Appeals. I had the privilege of being one of Professor Hellman's first students when he began teaching federal courts at the University of Pittsburgh in the 1970s. We're not sure if it was 1975 or 1976, but I do want to express my appreciation to Professor Hellman for teaching me not only to think about these issues under Article 3 and not only to think about them analytically, but to think about them critically. And that's something that has benefited me throughout my practice. And I owed such a debt of appreciation to Professor Hellman for those lessons, not only in law school, but for the discussions we've had over the years since. So, and I hope those will continue for many more years. Talking about the United States Court of Appeal structures, we have a distinguished panel consisting of Professor Stephanie Lindquist, who is a professor and executive director of the Center for Constitution Design at the Sandra Day O'Connor College of Law. She also is the dean designate of the Washington University College of Law. We also have Dean Merritt McAllister from the University of Florida Levin College of Law. And from the bench, we have Judge Mary Schroeder from the United States Court of Appeals for the Ninth Circuit, and Judge Mary Ellen Naraika, who also had the privilege of serving as one of Professor Hellman's students at the University of Pittsburgh. I urge you to look at their biographical material in the program. We're going to start this panel by talking about process, examining the trends and changes within appellate procedures, and procedural experimentation through new administrative models. Professor Lindquist is going to lead off by talking about what might be an emerging theme today, that of subtraction. We've talked about reduced dockets. We've talked about reduced accountability, and Professor Lindquist is going to start by talking about the vanishing appeal.
Thank you, Robert. I have a PowerPoint slide. So if I press, there we go. Thank you very much for inviting me here to the law review, and a special thanks to Arthur. In fact, this work that I'm going to present to you today is derivative of Arthur's work dating back.
Turn your mic on.
Is it on now? Okay, yes. I hear myself loud and clear. This work today is really derivative of much of the work that Arthur did going back to the Rushka Commission, looking at the Ninth Circuit, looking at courts of appeals and workload within the U.S. Courts of Appeals. And about a year ago, I started replicating a project that I worked on in 2007, looking at what I called the bureaucratization and balkanization in the United States Courts of Appeals. And I decided to update the data from 2007 to 2023 or 2022. And as I did that, I discovered a data puzzle. And I'm going to tell you about that data puzzle today. Arthur has worked with me through the graphs in this presentation as we sort of collectively scratched our heads together to try to understand what's going on in the U.S. Courts of Appeals at the moment, especially since 2006. But I very much look forward to hearing your reactions to these data that I'm going to show you today. Okay. This is a data puzzle, again, because it's really an inductive, in a sense, an inductive project. I found some data, I found some trends in the data, and I'm trying to explain the trends in those data. But they are of a piece of 4 different parts of sort of developments and change within the U.S. Courts of Appeals and the U.S. District Courts as well. First, as has been very well documented by Mark Galanter in connection with an American Bar Association project started in the early 2000s, the trial is vanishing, and it's vanishing rapidly, and I'll show you some data there, both in state and federal courts. In addition, though, in addition to that, petitions for writ of certiorari are also vanishing. And we're not talking about the sort of uptake end at the US Supreme Court in terms of how many petitions they take. I'm talking about how many petitions are filed in the US Supreme Court, and I'll show you some data on that, which is quite dramatic. Then we're going to see some data on the vanishing appeal in the US Courts of Appeals from the US District Courts. And then I've got some data also to show you whether or not that reduction in appeals at the US Courts of Appeals is actually having an impact on procedural justice in the US Courts of Appeals. So first, part one of our story here, our data story, is the vanishing trial. And you can see that since 1962, the rate of trial in the US district courts has diminished substantially. In 2012, it was down to 1.1% of all civil cases ended in a trial. And now that number is actually lower than that. This is true also in the state courts. And it's a reduction across all case types, actually, both civil cases and criminal cases. We're seeing the trial simply going away. And there's a number of good reasons that Mark Galanter and his co-authors have suggested, and we can talk about those. But that's a very important first piece of this puzzle. These are some of the hypotheses that they've raised and tested in some respects regarding the elimination of the trial. Greater reliance on settlement and summary judgment, greater reliance on arbitration, all the things that you might expect. Fewer and diminishing statutory causes of action. I was talking last night with Judge Schroeder about this, and what she pointed out is Congress is sort of a little bit lazy these days. It isn't passing as many statutory causes of action. That could certainly, obviously, also be changing the dynamic at the district court in terms of trial in the state courts, too. And then tort and procedural reforms, we're all certainly familiar with those. The vanishing certiorari petition is also very, very interesting, though, and is kind of a corollary. I actually saw someone noting this on SCOTUS blog one day, and I thought it really fit nicely within this larger data story I'm telling you today. And here's the data. And what this is data from the Supreme Court Journal. They record the number of certiorari petitions they receive. And I broke this out by paid petitions and informal pauperous petitions. And what you can see is since 1994, in the context of paid petitions, while recently there's been some spikes in the filings, you can see a steady decline since 1994 in paid petitions. And then in informal pauperous petitions, what you see is around 2006, a dramatic decline in the number of informal pauperous petitions filed at the US Supreme Court. So something's going on there. And these are petitions for the writ of certiorari issued by or that arise from each circuit. And so if you want to look circuit by circuit, you can see here what these data show is that in some circuits, there really is a pretty dramatic decline. The Ninth Circuit, you see there's, in all of them, there's no spike upward. In all of them, there's really a steady and sort of, in some cases, gradual, but in some cases, more dramatic decline in petitions of certiorari coming from those circuits to the US Supreme Court. And then just because it's interesting, if this is, perhaps this is not just a federal phenomenon, perhaps it's also a state phenomenon. And so the National Center for State Courts does gather data on filings in state Supreme Courts. And here what we have is filings on 46 states. That's all they had at the National Center. But you can see since 2012, when the data became available to me to put in a graph here for you, you can see in both California and in all other states, filings in the state Supreme Courts are down. So something interesting is going on. How about in the US Courts of Appeals? Okay, here's the kicker graph. This is the graph that Arthur and I spent a lot of time looking at. So what this is simply a graph of population in the United States, and you'd expect that, as has been the case up until 2006, as population rises, appeals would also rise, as would be natural. And what you see instead is in 2006, which is the pivotal year, you see a decline in appeals coming to the US Courts of Appeals, and it's monotonic. So it is steadily decreasing over time, with one exception in about 2018. So the vanishing appeal is not a COVID phenomenon. The vanishing appeal is not a recession phenomenon either, since it started in 2006. So something else is happening here. And this is just across all case types, actually 3 case types I broke out for you, so you can see that the appeals are sliding downward in both criminal, civil, and prisoner petition filings. So you can see them by case. And then because Merit has done such excellent work sort of sussing out the influence and the impact of pro se filings, I wanted you to see that this decline in appeals is happening both in pro se filings and in paid, counseled cases. And so this graph breaks those out so you can see the difference between the two of those. And this is simply a graph. The question here that's in your mind is, oh, it's due to some specific case type, right? Something has changed in prisoner filings. Something has changed in habeas cases. Something has changed in criminal cases, civil cases. But if you look at this graph, what you see is that filings are down from 2002, and you're looking back across these years, filings are down in really all case types. But district court decisions are not down. So the district courts, again, you might say, oh, it's because the district courts are deciding fewer cases. Wrong. The district court is actually deciding, as we might expect, more cases as our population rises. So these are data from the Administrative Office of the Courts, and the terminations in the U.S. district courts has just steadily gone up over time. And so there's no necessary correlation between what's being decided at the district court and what's being decided in the U.S. Courts of Appeals. Okay. Now, very few studies in the course of really history has ever evaluated what happens when a docket diminishes. Now, the U.S. Supreme Court, we're seeing some of that now, obviously, but for the most part, when courts' dockets are reduced, we might be interested in seeing, does that actually have an impact on how courts make decisions, right? And of course, the courts of appeals are always under criticism. They're not publishing enough opinions. They're not giving an oral argument frequently enough, right? And all that sort of thing. And if you look at this particular graph, what you see is, notwithstanding the fact that since 2006, the courts are actually having a reduced workload, the rate of oral argument continues to decline, or at least remain steady over that period of time. So what we have here is broken out oral argument rates in pro se cases and in counseled cases, and we do not see any increase in oral argument rates since 2006, even though the court's workload is apparently less. That's also true for publication rates, which continue, generally speaking, to decline. A couple of exceptions, but this is year to year and circuit by circuit in pro se and counsel cases. And then here's the weird one. Here's the really weird one to me, and I'd love to get the judge's perspective on this from the audience. Reversal rates are in decline, have been in decline for years. So cases that are coming out of the district court, going to the Court of Appeals, I've just put a trend line in all of these graphs, but you can see as a general matter that reversal rates have declined over time. Likelihood of winning on appeal has been reduced. Okay, hypotheses. I hope you all your brains are moving quickly. My email is sl@asu.edu right now, real easy. So I'm desperate to hear your thoughts about this. But what are the explanations? Well, any explanation that applies to sort of that might involve things like procedural reforms, criminal justice reforms, et cetera, those should also have affected the district court too, for the most part, right? But they didn't, as I showed, because district court terminations continue to rise. So it's hard to match many of these what I call institutional hypotheses. And it is absolutely the case that trials give rise to more appeals than cases resolved by summary judgment or otherwise. But the diminishment in the trial has been happening for decades. And what we see here in the diminishment of the appeal doesn't happen until 2006. So it's not necessarily and only the fact that fewer cases are going to trial. Political. I'm a political scientist, by the way. So, I mean, I'm going to look for political sort of explanations for this phenomenon. And what some people have suggested to me is that, well, courts are more conservative. They're less open to innovative arguments on appeal, perhaps, and all that sort of thing. So maybe as courts become more conservative, those courts are, the litigants are less likely to bring an appeal because they're more likely to assume they're not going to win. And so they settle before they get up to the Court of Appeals. Well, so I want to look at that and see, indeed, what is the central tendency in courts of appeals over the last, since 1983, when my study begins. And this is a measure of central tendency for what's called the judicial common space scores. These are scores that were developed by Lee Epstein and Andrew Martin, happen to both be WashU affiliates. But what these show is the central sort of mean of the medians across circuits over time. And you can see that, in fact, the central tendency in terms of the ideology of the judges on the U.S. Courts of Appeals and the district court has actually become more liberal compared to, according to these JCS scores, compared to the Reagan and Bush years. But here's what definitely has changed, and that is polarization in the U.S. Courts of Appeals. And what this graph shows is the range in these ideology scores shows that, indeed, over time, judges on the Courts of Appeals have sort of spread out farther in terms of extremes on the left and the right in the range of those ideology scores across the period of time that I'm looking at here. And in terms of looking at this graph, you can see that in 2006, you definitely see an uptick in terms of polarization on the U.S. Courts of Appeals. And there have been other studies that show that polarization on appellate courts do actually reduce the likelihood of appeals being brought, because it's very difficult to predict what's going to happen once you get to the Court of Appeals. That's the hypothesis anyway. And so it may be that what we're looking at here is an artifact of, or a consequence of, polarization on the U.S. Courts of Appeals. But again, at the moment, it's hard to test that causally, but that it doesn't seem to be at least one potentially useful explanation. And in fact, this is my last slide. I just did a real quick analysis here of the impact of a broad range of ideology scores and extreme scores on a particular circuit. And you can see that once you control for the number of district court terminations in the previous year, the size of the circuit, the population within the circuit, the actual range of ideology scores, that is how polarized the circuit is, has a substantial impact on the number of appeals brought to a particular circuit. And I'm happy to explain to you what the meaning is of that coefficient and the p-values associated with it, but take my word for it. That's a very large coefficient, and I think extremely important to understanding how it is that ideological polarization may affect appeals or the rate of appeal in the U.S. Courts of Appeals. And I will stop there. Thank you very much. And thank you to Arthur, more importantly. Study wouldn't happen without him. Thanks, all.
Next, Dean McAllister is going to talk about learning from laboratories of federal appellate adjudication.
Thank you. Let's see. There we go. Okay. Thank you so much. I'm really honored to be here. I met Arthur over email. I think you have probably written me about every article I've ever written, which is means that you read every article, which is a remarkable thing. I think only my father can say that. But I love getting emails from Arthur that'll often be like, I was really struck by something in footnote 29. And that just shows a measure of care and dedication to this field that's really impressive. So I'm so honored to be here and be part of this conversation. And I'm especially grateful to be following Professor Lindquist, Dean Lindquist, as we, I think these conversations are very much of a piece. And I'd like to spend a little bit thinking about, I've written a lot about some of the disparities in the courts of appeals in terms of the procedure that is afforded litigants, specifically focusing on unpublished decisions and oral argument, and looking at differences across the circuits in response to perceptions of caseload demands. So the story on the overall sort of ways in which the traditional appellate process has changed over time from being what we call the learned hand model, where judges were hearing oral argument and writing reasoned decisions in all cases, is something that started fading away in the sort of from the 40s, 50s, 60s, 70s, and by the time we get into the 80s is really sort of firmly gone. And a lot of that was driven by increased caseload demands at the same time that the courts were not receiving new authorized judgeships to keep up with the pace of the caseload demands, and so a need to find other innovations to handle workload. And one of those significant innovations, and I'd love to see how, as we think about this and how it plays out in each circuit, was about adding staff attorneys. So instead of having law clerks, adding a lot of staff attorneys who can handle a great portion of the caseload in each circuit. And how different circuit courts use staff attorneys more and less is, I think, potentially part of the story of just the way in which there have been a lot of procedural shifts and changes at the courts. But I'm very interested in picking up on the question that Professor Lindquist sort of noodled over, which is, you know, as we've seen a dramatic caseload drop, and this is my very basic version of some of what Professor Lindquist showed you. So this is the volume of filings over time, right? We see this spike in like 2005, 2006, and a precipitous drop ever since. And we're now down to a level that we haven't seen since like the early 90s. And yet, at the same time, and this is down across, I should say, down across all the circuits, right? So all the circuits are down pretty significantly. This is data ending in 2022, but this is just a percentage decrease from that high watermark to where we are today. At the same time, the volume of unpublished decisions remains very high across all the circuits, including over what I would call the most precipitous drop. And they've lost like 10,000 appeals in the last 4 years alone, right? And yet the volume of unpublished decisions is high. But one of the things I want you to sort of see in this graph is not just that it's high and persistent, but it's quite variable, right? The DC circuit, the First Circuit, the Seventh Circuit, the Eighth Circuit have, relative to some of their peers, lower rates of unpublication, or you might say higher rates of publication. And that's true sort of going back in time, a slightly different way that they handle publication decisions. And this is just the rate of unpublication over time for all circuits. So, and this is a little dated, but the numbers are still holding. It's around 86, 87% each year from 2021, 22, 23. And yet, when we were in like early 90s, when the caseload volume was more like it is today, the publication rate or the unpublication rate was a little over 70%. So that's a huge difference, right? Between when the last time we had this amount of volume of appeals and the kind of procedural justice that litigants were seeing in the courts of appeals. If we look at oral argument, same kind of story, right? High variability among and across the circuits, but fairly consistent over the last 4 years, where the rates of oral argument are really not shifting perceptibly in light of the significant decrease in demand on the courts of appeals. Now, one thing to say is that perhaps it's just, I mean, the courts of appeals have been busy for a very long time, although I have a close district court judge friend in the Middle District of Florida who says it is a luxurious life being on the 11th Circuit compared to what the Middle District of Florida faces, in part because the Middle District has been in like a judicial crisis for years and can't get new judges, and the volume of work is just extraordinary. And the 11th Circuit is kind of like laid back, relaxed, focusing, not unlike the way the Supreme Court focuses on those 60 cases. The 11th Circuit is hearing argument in like 12% of the cases, and they have a huge staff attorney pool that handles everything else. So a very different approach to judging. And a lot of what I do thinks about like, how are we structurally dealing with all of these differences across the courts while still providing the same level of quote unquote appeal, right? There's a right for most litigants to have an appeal in the federal system, and yet what that appeal looks like is quite different depending on the circuits. Now, you might say, well, of course, some circuits are going to be different just by the nature of their docket, right? The DC circuit probably jumps out to you in all of these slides as being high in terms of publication, high in terms of oral argument, and it's true, they are unique, and I usually like exclude them from most of my data. But there's actually no significant docket difference between like the 7th Circuit and the 11th Circuit. They both have high volumes of pro se litigants, of prisoner appeals, et cetera. So the 5th Circuit too, if we threw in the 4th Circuit, all of these are circuits that actually have pretty similar types of appeals and types of demands, and yet very different ways of handling them in terms of these measures, right? Looking at publication, oral argument, and even behind the scenes, and this is part of where I think Arthur's work has so significantly educated us in what's happening in the 9th Circuit, and he often brings it to my attention the way in which the Ninth Circuit, even though it's very big and has huge demands on it, does things differently than other circuits. So in the Ninth, they have a conference calendar, for example, where judges will sit down and talk with staff attorneys and talk out cases, even if a staff attorney is primarily making a recommendation and handling an initial recommendation and draft of a decision. In other circuits, like the 11th, there's no conversation at all. The staff attorneys are in one building in Atlanta, and they just draft something and it's sent out to all the other judges, and they deal with it in a round robin fashion where it starts with one judge and then goes to the next and goes to the next. And it's more like a rubber stamp process. So a very different process, much less collaboration among the judges and the courts, a very different way of using staff attorneys that also contributes just to some of these back end things that we see on the front end. So if we think about just sorting courts based on the quality of oral argument, the types of decisions they're issuing, you can start to see some circuits are just doing a lot more to provide more points of contact, more reason giving to different circuits versus less. So this sorts the courts where based on oral argument rate and based on unpublication rates. So you can see some trends here, like the 4th and the 11th are persistently low in both of these measures, right? They are not providing argument or publication very often, quite stingy. This is looking at, if we dig a little deeper beyond the surface, this is actually looking at mean word count, so average word count of decisions across the circuits, published and unpublished decisions. This is from, this is a little bit old. The article came out last year, but the data was starting in 2017 for lots of reasons that I can explain later. But what you see is some variability just in terms of the average word count for decisions. So the orange line is unpublished decisions, the blue line is published, but even within published decisions, right, a huge range. In Second Circuit, right, on average, close to 7,000 words. In the Eighth Circuit, much closer to 3,000. How we deal with unpublished decisions, in some circuits, it's over 2,000 words per average, and in some, you're talking about barely, like if you look at the Eighth, it's like 300 words on average. So huge variability in terms of just the kind of way in which we handle, and this is just numerically representing what I showed on the prior graph, the type of consideration that litigants get in the different circuits. So all this to say that there's I think undeniable variability across a lot of the ways in which we measure the courts. And so do we care about these differences? And I would say to you that if we care at all about sort of procedural justice and the access to sort of your day in court values, then these are at least questions for concern, especially given the fact that there's a reduction in overall caseload volume, right? Like it would be one thing to say, okay, courts are really overburdened, they are doing the best that they can, and that's no doubt has been true for a long time. But as we see the vanishing appeal, the question is, why are we not readjusting with more time on our hands to look more like the courts did back in the 90s, when they also had, by the way, the same number of judges. That was the last time there were any significant judicial additions to the federal bench. And we don't see these changes, and we see some persistent disparities across the courts. Some courts providing a lot more robust attention and oral argument in published decisions, and some not. So do these matter? So I would say that some kinds of differences are totally benign and beneficial. And Allie Larson and Neil Devins have a book coming out and have written a lot on this, including the great article called Circuit Personalities, where they identify some of the differences in circuits about, traditions, norms, formal and informal. Like in the Fourth Circuit, everybody comes down and shakes your hand after oral argument, right? A lovely benign tradition that's part of the culture of the court. I would put these kinds of disparities in a different bucket, not part of the benign tradition building, sort of norm building, collegiality building kinds of differences, but more a question for what do we expect as kind of a minimal level of process that for all non-frivolous appeals we might expect in terms of reason giving, in terms of access to an Article 3 judge to review and engage with your appeal. And I think we can see from the data that there's some unevenness in terms of what that looks like across the country. And so I would separate out some benign differences from some differences that I think are a little more questionable. All of that said, I think sometimes the courts are not always aware of what their sister circuits are doing. I had this moment earlier in the year where I was on a panel with a judge from the DC Circuit and the Fourth Circuit. And I'm always like a little cautious because I tend to beat up on the Fourth Circuit a lot because they're, you know, at the bottom of the list. And the Fourth Circuit judge, who was lovely, was shocked to realize that her circuit had been persistently the lowest in publication for years. And I thought, that is so bizarre. Like, how can you not know this? Like, I mean, maybe I'm, you know, overly a nerd and I know this really well, but there was a lack of communication. She was like, yeah, I have a sense that we don't publish a lot, but had no awareness that other circuits were publishing a lot more, had different practices, and that there really is a lack of the ability to sort of share and learn from one another, to realize when you're actually out of step. So if we think about the way in which process has been indifferent to the drop in caseload demand, I think there's I don't know if there's a mechanism where courts are being asked, well, hey, we actually have less coming in. Is this a moment now to step back and say, are these processes in the right structure or order? What might we do with more time on our hands? Should we revisit the triage systems that we have in place that send more cases to staff attorneys for resolution? Those conversations, and how, by the way, do we compare to our peers, right? Those conversations, I think, don't happen in the way that we might expect if we tolerate these laboratories of experimentation, and we have them, right? That's the point of the circuit structure. We have these laboratories and we generally exalt experimentation, but there are not back-end mechanisms for sharing the results of that experimentation, right? If we have labs and we have experiments, there's no process by which we talk, look, this was the result of the experiment. These were the good things. These were the things that didn't work. Are there system and process improvements? I think there are informal ways this happen, right? Like on a panel where I have a chance to talk with a judge or a judge asks a peer. And when visiting judges, visit other circuits, right? That is a mechanism for sharing this information. But I don't think that's enough. I think those kinds of informal mechanisms are not enough to trigger those conversations or to do the kind of self-assessment that maybe courts need to be doing now. There are formal mechanisms, and I think the obvious one is like the judicial conference, right? And Arthur has written about some of the failings of the judicial conference, especially around adding authorized judgeships. So there's a process that the judicial conference uses for authorized judgeships, and it's not at all transparent. It allows courts like the 11th, which I also beat up on, but it's my home circuit. So I feel like, you know, they don't invite me to the 11th Circuit Judicial Conference very often. That's actually not true, but you know, I tend to be delicate about it. I clerked there, so I try to sort of emphasize the love for that. But the 11th Circuit has been like one of the busiest circuits for decades, and it's never asked for more judges because they like this system. They have a fear of being a jumbo court like the 9th Circuit, but they refuse to ask for more help. You might wonder, like, how are they doing their work then? Well, the easy answer is they have the highest ratio of staff attorneys to active judges by a factor of 4, actually it may be more than that, of any other court of appeals, right? So they have just decided we're going to use staff attorneys instead of adding authorized judges. And I'm not sure that's the right answer to this question if we value Article 3 judicial review and a right to an appeal under federal statute. But there's also no mechanism to have that conversation because I think the judicial conference's main function is to help the courts do and carry out the goals that they have, right? It's a policy apparatus to protect the judiciary before Congress, for example, right? Back to the earlier panel where we're talking about that relationship between the Supreme Court and Congress, there is a similar relationship there. So I guess the question is that I'm thinking and trying to think, and I'd love thoughts on new mechanisms to force these conversations. I think spaces like this are part of the answer, where you bring together judges and academics and those from the bar to talk about and be conscious of some of the way in which we're studying courts, we're thinking about what courts are doing, we're thinking about how they affect the litigants who are there before them. So is there a way to formalize some of those conversations where courts are required to have these dialogues with chief judges who are, maybe all gathering together and having conversations with academics, with those who are practicing before their courts, to learn from one another and to learn best practices or different practices, or at least shine light on the way in which the practices that are different, how those might affect litigants in their before their courts. So I will leave it there as we think about how to sort of tackle some of the problems that Professor Lindquist highlighted and that hopefully I sort of picked up on. So thank you. I'm happy to be here.
Thank you very much. One question I have is to what extent would a more robust program of using visiting judges help in terms of trying to educate circuits with respect to the practices that other circuits are using?
I think visitors are a great way on some of the more informal sort of collegial mechanisms. I think having visitors travel and visit other courts, they can learn other sort of, camaraderie building, more of the informal norms. I don't know that it's sufficient to be a mechanism that forces the kind of change that I'm imagining, as opposed to some of the more positive, circuit personality type change that Devins and Larson have written about. Although they also think that it's very important that circuits have their own personalities and preserve that in order to hopefully respond to some of the partisanship that Professor Lindquist highlighted. So visitors, I think, are good. Also, by the way, I should say not all circuits accept visitors. So it's not a perfect solution unless some of the circuits, based on their own personalities, like the DC Circuit doesn't accept visitors because they want to be this protective little insular court, and they don't really need visitors because they're one of the least busy courts in the country, so they don't need them to help with their work. But there was a period of time in which the 11th Circuit had had potentially 2 visitors and 1 active judge on a panel because they were so busy, and again, they didn't want new judges. They didn't want to ask for new judges, so instead they had it was not even the 11th Circuit, right? It was you got 1 judge on the 11th Circuit and the rest were judges not from the 11th Circuit. So visiting judges, I think, are part of the answer, but there needs to still be a formal mechanism to bring them together to have conversations.
Any comments from any of the panel members? Judge Schroeder.
Well, on the subject of visiting judges, if it's going to do any good to have interchange between the circuits, they have to be visits from one circuit to another, not district judges and other kinds of visitors that take place. And there's a limit to how much that can be. And I recall once years ago, one of our judges deliberately went to all of the circuits in order to come back to us and report on what they do. And I thought it was quite valuable. But more often than not, when he would describe what the other circuit did, the reaction of our judges around the table was, "They what?" So I think there's a limit there.
Yeah.
Let me just turn my machine on here. You all hear me? Oh, I guess I need to put this up somewhere where it'll actually catch sound. Okay, can you hear me? Okay, great. This conversation is interesting. There's 3 variables that the AO collects that I really love. One is the percent of decisions that are attributable to active judges. In each statistical year, the number of vacant judge months that are in each circuit each year, and then the disposition time, how long it takes from filing to the conclusion of the appeal. And I think, one of the things that empirical social science, especially modeling of the kind that I do, is useful, is you can sort of test what are the impact of visiting judges on actual outcomes, on the time it takes for appeals to be decided in a particular circuit, on how likely oral argument or the percentage of oral argument rates and that sort of thing. And that's what I'm actually working on, replicating a study I did in 2007, which does perform these modeling functions to find out, what are the impact of things like visiting judges. because we can talk about them anecdotally. And of course, the experience of the judges is the most important thing, but then looking at the data themselves. So anyway, just want to make that point about data. If you're a geek like me, like data.
Judge Naraka, did you have a comment?
Well, first, let me point out the obvious thing that was missing in Professor Lindquist's slides, which was that it could be just that the district court judges are doing such an impeccable job that there is no need for appeals. So I was.
And that's why the reversal rate's going down.
Exactly. The reversal rate's going down. So, clearly there's kind of, there's a correlation there. The question that I had on Dean McAllister's presentation was, oral argument to me, that seems, sort of a preference, and maybe it's good to give people their feeling that they've had their day in court. But the slides that caught my attention were the ones with differences in precedential opinions versus, and also the word count, which you have to tell me how you did that. But
Took a lot of time.
but because, a lot of the benefits of having things, cases decided in multiple circuits is the percolation, right? Where ideas are expressed and, you see a split and the judges can consider what the other judges are doing and think about it. Does that have any effect? The fact that some judges aren't really writing about it, so there might be a split, but it's not really percolating and the ideas aren't getting out there.
Sure. And I think this is one of the spaces where this was an early worry about even moving to unpublished decisions, is that would affect the development of law, because judges are not always you can't always foresee how a case might be used and whether it will be needed or become the focus of a circuit split, right? Or need to be sort of hashed out and relied upon. And so you can write in an unpublished decision and then think it's gone, but it can create all sorts of weird shadow effects. And I actually think that one of the parts of what's happening with especially in some circuits that have both high unpublication rates and then very low average word counts for unpublished decisions, is that there's actually a fear of unintentionally creating a circuit split or resolving a case in a way that if you put too much down, it's possible that it creates bad law in a way that you're not intending, right? So, for those of you who know much about this area, right, for a long time, there was actually a federal rule of appellate procedure, or there was no rule of procedure that limited the citation of unpublished decisions. And for a long time, unpublished decisions were not citable in the courts of appeals. And then there was a rule change that was very controversial that would require the citation of these unpublished decisions. So I think there's all sorts of ways in which what judges say and don't say, and the willingness to create circuit splits or disagreement gets played out both across publication and the length of decision. I also think some of the courts where you're seeing huge, very long average decisions, they may be courts where, you're writing for not just to resolve a case, but to get attention, right? This is back to the political science literature on how courts of appeals judges view their job individually. I've suggested, with all respect to courts of appeals judges, that it's the most glorious dead-end job in the world, a wonderful job, but there's often nowhere to go from there, right? Because it's very hard to get a position on the Supreme Court. And you don't have a lot of control over your docket in the way that you do as a district court judge, right? You are dependent on colleagues agreeing with you. You have different constraints on your role that are not present. And all of this has effects on maybe how expansive one is on writing and how much flourish one uses in their judicial opinions, which is also another topic of debate these days, funny opinions and witty opinions, et cetera.
Hey, Merritt, do you think the deans and Court of Appeals judges have a lot in common?
I do, actually. I'm in a dead-end, unhappy job. No, I'm kidding. It's what's the next step?
Now you know what you have to look forward to. So, with that, let's move the discussion into about structure. So we're going to examine how the size of a circuit affects its jurisprudence and reviewing the advantages or disadvantages of having a specialized appellate court. So we're going to start with Judge Schroeder, who's going to talk about preserving the federal court structure of the West.
Thank you. Thank you very much. I'm so delighted to be here. And I want to express my deep appreciation to the University of Pittsburgh and to the students and faculty for organizing this symposium in honor of, I don't have it on, in honor of a professor
who I've known for more decades than either of us would like to acknowledge, but about a subject that is dear to the hearts of both of us, which is the structure of the appellate courts. However, I have to say that the main reason I accepted your invitation so quickly had nothing to do with the honoree or the subject matter. It was because I jumped at the chance to participate here at the University of Pittsburgh because I owe my very existence to the University of Pittsburgh. So let me just take a brief personal minute to explain. My mother was a very bright girl from Squirrel Hill. My father was the son of a headstrong Irishman who worked the oil fields of Pennsylvania in the early 20th century. My mother and father both went to Pitt, and they met in the 1930s in the Cathedral of Learning, when my father coached the men's debate team and my mother coached the women's debate team. And during the 1930s, Pitt was the salvation for many folks in Western Pennsylvania who couldn't find work and who turned to education as a way out of hopeless poverty. Thus, Pitt was able to provide employment for my mother and father and enable them to support their families and eventually marry and have a family of their own, which is where I came in. So when you walk around the campus, take a minute to reflect on what this university has meant, what that remarkable cathedral symbolizes to this region for nearly 100 years. Now, when I looked at the topic that this panel was to address, and particularly what I was to address, which had to do with the design of the courts of appeals, I had to chuckle. Because in truth, there never was much structural design to the courts of appeals. The Edwards Act created them in 1891 from the existing 9 circuits that were ridden by the Supreme Court justices. The circuits had grown in number and size as the country spread west, including until the 9th Circuit encompassed the Wild West, including California, Oregon, and Washington. And it was a pretty wild place. Its most famous 19th century circuit justice, Stephen J. Field, reputedly survived several assassination attempts and had special pockets in his trousers to hold his pistols. The 9th Circuit came to include the states later added to the Union after the Edwards Act, because all of these states were west of the Continental Divide. Arizona was added in 1912, Alaska and Hawaii in the 1950s, thus extending the circuit across the Pacific to encompass about 1/8 of the circumference of the globe. So when the call for circuit division started up in the 1960s, the rallying cry was, "It's just too big." But no one ever came up with a sensible way to divide it. A big problem is that California is so big, it historically has accounted for more than 60% of the circuit's cases and has traditionally been historically bigger than all of the other circuits itself. So there would be no way to achieve a roughly equal division of the caseload of the 9th Circuit without dividing California. And no one has ever thought that was a good idea, and California won't stand for it. So any circuit that includes Alaska would have the largest land mass, and any circuit with Hawaii, and don't forget Guam, would include the entire Western Pacific and the Northern Marianas as well. So as my own role model, the first woman to sit on the 9th Circuit, who was Shirley Huffstetler, once put it decades ago, you just can't legislate geography. There have been circuit divisions. The 8th Circuit divided to create the 10th Circuit in 1929, which was an equitable division, as I understand it, that was quite amicable. The Fifth Circuit, which used to be comprised of the Old South from Georgia through Texas, was officially divided to create the 11th Circuit in 1980. That division was not amicable. The division is documented in a book called A Court Divided that was published about 30 years ago by Yale University Press. And it came after a decades-long tug of war between the powerful segregationist senators of the South and the courageous judges of the old Fifth Circuit, led by Judge John Minor Wisdom in New Orleans, Elbert Tuttle in Atlanta, and John Brown in Texas. And they, along with federal district judge Frank Johnson in Alabama, decided the landmark cases that desegregated the South after Brown versus Board of Education. And the senators didn't like it. So as the caseload of the Fifth Circuit grew, the senators refused to create any more judgeships unless the circuit divided. And the goal was to separate Judge Tuttle and Johnson in the East from Judge Wisdom and Brown in the West. And as time went on, the caseload increased, new judges came on board, the court relented and voted to divide. And Judge Wisdom, whom I had the honor to know, was opposed to division until the day he died. And his famous article bemoaning the division was entitled A Requiem for a Great Court. The pressures that grew on the Fifth Circuit to divide in the 1970s were due to an increase in the appellate caseload that my colleagues have alluded to. And it came to be known as the crisis in volume. So enter our hero of the day, Arthur Hellman, who made his debut in the field of appellate court structure, staffing the commission Congress established to make recommendations on how to deal with the problem. And that was known as the Hruska Commission, after its chair, Senator Hruska of Nebraska. Now, its main recommendation was to create a new court to resolve conflicts among the Court of Appeals, a new intermediate court, and relieve the Supreme Court from having to decide the great flood of cases that folks believed in the 1970s were coming its way. The flood never happened. The new court was never established. The Supreme Court today, as we have heard, is deciding fewer cases than it was 30 or 40 years ago. And indeed, the most salient contribution of the Hruska Commission was to give us Arthur Hellman, who went on to become our court's first staff director and to his distinguished career here at Pitt. As Professor Hellman can attest, the pressure of growing caseloads that led to the division of the Fifth Circuit had exactly the opposite effect in the Ninth. Our judges resolved not to divide and embarked on a number of important initiatives that Professor Hellman has analyzed. The courts of appeals normally sit in panels of 3. The most problematic feature of a large court, and the one that still terrifies judges, appellate judges around the country to the amazement, puzzlement, and consternation of the Ninth Circuit judges, it was seen to be the potential for conflicting decisions that would have to be reconciled by a court sitting on bank, i.e. with all the judges. When the Fifth Circuit sat on bank with 15 judges in the late 1970s, after it got its judges, it resolved to divide. Now that was a setup job. They sat on bank with all 15 judges because they knew that it would take too long to decide, to talk about the cases, and they wanted to be able to show it didn't work. So that was the justification for dividing. But at the time, the Ninth Circuit decided that it would not divide and that it would never sit on bank with all of its judges if it could help it. And so we devised the system known as the limited on bank. And it has worked very well, as Professor Hellman's work has helped to demonstrate. The Ninth Circuit is, in terms of judicial administration, is a great success. The limited on bank sits with 11 judges. They're randomly drawn from all of the judges in this, active judges in the circuit, but the chief judge sits on all of them to provide some continuity, and it really has worked well. We have a fail-safe provision that there can be a vote to have all of the cases, all of the judges sit on bank. If a judge calls for that after the limited on bank, I think we've had one call for a vote. That was defeated. That was in a death penalty case years ago. The court has never sat with all of the judges. We've never had a vote since. So what led to the division of the Fifth Circuit was political opposition to its decisions on civil rights. And what led to repeated efforts to divide the Ninth Circuit has been from the first few years of this century, but it's also been political opposition to the court's decisions. And the political opposition began in the 1960s with decisions recognizing fishing rights in the Pacific Northwest and perceived derogation of the rights of the commercial fishing industry. It went on in the 80s, the brouhaha was over the timber of the Pacific Northwest and the efforts to save the spotted owl, and that infuriated the timber interest. During my tenure as chief judge in the early 2000s, the decision that sparked the loudest controversy was all about the Pledge of Allegiance, which some of you may recall, when our court struck down a California statute emanating from the 1950s, when Under God was added to the Pledge of Allegiance. And the statute required there was a California statute that required California teachers to lead the pledge every day, because that was to show that we were not a godless country like Russia. And whether that was establishing a religion is a very difficult issue. The Supreme Court eventually punted on it and dismissed the case for lack of standing because the father had lost custody of his child. But the plaintiff had lost custody of the child, so he lacked standing, and that case went away. But the uproar was intense, and we survived the battle in order to prevent Congress from dividing the circuit. How did we prevent that? Well, it was with a lot of help from those who understood our system of justice. The Ninth Circuit has let me tell you briefly how it was done, or some of the ways that we were managed to preserve the structure. The Ninth Circuit has long had a network of lawyers who have helped us organize our conferences, served on our committees. They understand what the courts do. After the Pledge of Allegiance case, the lawyers actually hired an attorney in Washington to keep on top of developments on the Hill. I testified 5 times before congressional committees with my colleague and successor, Sid Thomas, by my side. Now, Professor Hellman has testified many times before committees, but he testified as an expert. I was testifying as a target. We invited our principal congressional adversary, the then Republican chair of the House Committee, Judiciary Committee, to visit us in San Francisco and meet with our executive committee. And Judge Susan Graber, who is here, took charge of our presentation, did a masterful job of explaining how we worked in answering every conceivable question the chairman might have raised. His party members voted to split us anyway, but it never in the House, but it never got out of the Senate. So an overwhelming majority of our judges, it was because an overwhelming majority of our judges signed petitions, district, circuit, bankruptcy. More than 500 law professors signed petitions opposing the division of the Ninth Circuit because it was contrary to the independence of the judges. And all of the support, but here is a point for today, that all of that support from our judges and lawyers would not have been so persuasive had it not been for the scholarly backup provided by Professor Hellman and a few others. And they documented and supported our position that dividing the Ninth Circuit was a solution in search of a problem. His most valuable contribution, in my view, was his influential study of decisions of the court, trying to figure out whether there was an inconsistency in our decisions. That article was called Jumboism in Jurisprudence, which is pretty good. He has a great title. And it was published in the University of Chicago Law Review and explained that there really wasn't the problem that people perceived. His favorite title, my favorite title of Arts, is dividing the Ninth Circuit, an idea whose time has not yet come. Now, this fight was difficult because feelings of the pledge ran high. There were nasty letters. There was an avalanche of threatening postcards. And the San Francisco Chronicle actually printed a letter to the editor saying, kill all the judges of the Ninth Circuit. But I never felt personally threatened because the threats were all directed to the circuit headquarters in San Francisco, and no one dangerous ever figured out that I actually lived in Phoenix. Now, this was before the internet. So let me quickly fast forward to today. Mark Twain is reputed to have said that history never repeats itself, but it often rhymes. Today, there is a loud rhyming in my ears. We hear of personal attacks on judges, on their families, accusations of wrongdoing, weaponization of the system, and all on account of fear and disagreement with what the courts may decide. These are attacks on the rule of law. I do not hear many voices yet calling out these threats as misguided and defending our system of justice. I don't hear the bar associations, judicial organizations, law deans, and professors yet. I understand it takes a while to get organized and to get a grasp of what is happening in the currents of events. But as the experience of the Ninth Circuit, not to mention the Fifth Circuit, demonstrates, when justice becomes political, our courts are in trouble. So I want to close as I began as the daughter of teachers at the University of Pittsburgh during the 1930s. Then folks thought the country was doomed to fall victim to the Great Repression. Yet my parents lived to see the country after World War II become the greatest in the world. In looking at our justice system today, I see the future as bright. I know that our system of justice is resilient. It has strong pillars, attorneys, judges, and the academic community. They're all here today, and they believe in the Constitution. I believe our system of justice will survive as it has in the past, but it takes all of us to successfully defend us. Thank you.
Thank you, Judge Schroeder. Moving to our next structural topic is the question of should appellate courts be specialized? And for that, we have Judge Mary Ellen Noreika, who will talk about the experiment that resulted in the United States Court of Appeals for the Federal Circuit.
Thank you for inviting me to be a part of this symposium. Professor Hellman has had a huge influence on me. He has taught me just about everything I know about federal civil procedures. It's certainly an honor to be here. My part I feel like I have to break into song. Okay. All right. Well, this is the part that's important. This is my part of this presentation is on the structure of the United States Court of Appeals for the Federal Circuit. And when Arthur first mentioned this to me, I thought, sure, we're going to have a symposium on him and his extraordinary body of work, and I'm going to talk about the one court that I don't think he's ever mentioned in an article. But when I looked into it some more, I realized that there was some method to his madness. You see, like the Ninth Circuit that Arthur has studied so extensively, the Court of Appeals for the Federal Circuit has a unique structure. Like the Ninth Circuit, that structure has been extensively studied and criticized. But unlike the Ninth Circuit, the work of the Hruska Commission that Arthur served on was not almost entirely irrelevant when it comes to the Federal Circuit. In fact, it was that commission that raised some of the issues involving patent law that ultimately resulted in the Federal Circuit. So let me start with some basics. You all have seen multiple slides up here and heard discussions about the circuits 1 through 11 and the DC Circuit. There are actually 13 federal intermediate courts of appeals. They were just kind of left out on some of those slides. The Court of Appeals for the Federal Circuit is the latest, the most recent of the federal courts of appeals. It was established in 1982 by the Federal Courts Improvement Act of that same year. The court was formed by a merger of two courts that already existed, the Court of Customs and Patent Appeals and the Appellate Division of the United States Court of Claims. It is unique in its structure in that it is the only federal court of appeals that is based, has jurisdiction based not on territory, but on subject matter. The Federal Circuit has subject matter over the patent and trademark decisions of all 94 federal district courts, as well as jurisdictions over decisions of several administrative bodies and subordinate courts. It was, however, the patent law issues that ultimately drove the formation of the Federal Circuit. So what were those issues? Well, primarily it was a lack of uniformity in the regional courts of appeals. Now, patent law has always been very important to this country. It's included the grant of power to Congress to establish patents is in the Constitution. Patents promote innovation and advances in technology that drive our economy and make this country competitive throughout the world. But patent law is rather esoteric. It's technical and it's just not for everyone. And you add into that back at the time, the different courts of appeals had very different views on the patent system. Some were thought to be pro-patent, others distinctly anti-patent. And the result was a lack of uniformity that meant the same patent could, and in fact, in many cases was, interpreted differently in different cases. That, of course, led to forum shopping. And when you consider that the nature of patent litigation is that litigations are brought all over the country, even for the same patent, that resulted in cases being brought in both cases that were seen to be patent friendly and those thought to be patent unfriendly. And the result was that a large number or portion of patents wound up being invalidated. Now, it's not so clear that Congress actually cared about the percentage of patents that were going down in these cases, but certainly some people who were pressing for reform to the way courts addressed patents were looking for a more patent-friendly forum. What Congress clearly was concerned about, though, was the inconsistency of the decisions that were happening across the country. And given that the Supreme Court at that time was not jumping in to fix those, the circuit conflicts persisted. So ultimately what happened is Congress decided that a nationwide appellate court should be given jurisdiction over patent cases and trademark cases with the desire that there would be some certainty in patent law that would help to encourage investment and innovation and spark on the economy. And with that, the Federal Circuit was born. So that was more than 40 years ago. How's it going? And that is the subject of more than a 12 to 15-minute talk. Many scholars have written about this over the years, but I think it's safe to say that in terms of its structure, as a specialty court, it's lived up to some of its promised advantages and also validated some of its opponents' worst fears. So let's start with what's gone right. Well, for starters, the court has achieved one of the main goals of Congress. It addressed conflicts in regional courts of appeals and has brought some uniformity to the law. Now, uniformity is a relative term, and there are, of course, intra-circuit conflicts that have arisen, but the court did eliminate much of the lack of clarity that existed. In its first 3 years, the Federal Circuit identified and resolved 13 inter-circuit conflicts that it had been identified with respect to patent issues. The court's presence also, to some extent, relieved some of the concerns raised by the Hruska Commission regarding overburdened appellate courts. Anyone who has been in law school and has seen the proliferation of patent law classes that have occurred, anyone who's glanced at the dockets of the district courts and seen how many patent cases are filed, Anyone who's looked in the popular press and seen that there are descriptions of patent cases going on knows that in the last 40 years, patent cases have exploded in terms of their filings. And to the extent that some portion of that explosion in patent cases was inevitable, then that's not an insignificant burden to have been removed from the regional circuit courts. And finally, clearly, by having a creation of one single court, the forum shopping, at least with respect to the appellate level, was resolved. But all is not rainbows and unicorns. And as Professor Froelich said last night, it's the disadvantages and the failings that tend to get most of the writing done about them. So there have always been concerns about specialty courts. Judges are presumed to be generalists. And it's important often that judges are generalists because it helps them to understand how any particular area that they're talking about fits into the whole overall grand scheme of the law. And the concern is that if you have a singular focus as a judge, you can become myopic. And that leads to not being able to understand how your particular issue fits into the broader scheme. And that was a particular concern in the patent cases because they thought, you know, if you just have a bunch of people focused on this technical arcane law of patents, it's going to take it even further out of the mainstream of legal jurisprudence. There was concerns that removing particular subject matter from judges would result in a lack of new ideas, stagnation in the law, and ultimately bad decisions. And those are all valid concerns. So at the time that the Federal Circuit was established, Congress tried to mitigate that a little bit. So what they did with the Federal Circuit's jurisdiction is it was a hodgepodge. Okay, in addition to patent cases, it got cases from the Court of Federal Claims, from the Merit Systems Protection Board, from the Court of Appeals for Veterans Claims. So its jurisdiction was broadened from just patent cases. In 1982, when the court was established, 20% of that court's docket was patent cases. 15 years on, the patent cases had risen to about 30% of the court's docket, but the main portion of the docket was appeals from the Merit Systems Protection Board. In the ensuing 10 years, patent cases overtook those Merit Systems Protection appeals to become the largest chunk of the docket. And in the last 2 years, patent cases have comprised more than 50% of the Federal Circuit's docket. Much of that has to do with the Patent Act that Congress enacted in 2013. But the fact remains that the Federal Circuit has actually become the specialist court that many people feared when it was set up. And that's so much the case that at a recent seminar where I was where I attended, there was a Federal Circuit judge who was on the panel, and he gave remarks and he said sometimes he thinks that the judges on his court have actually become glorified patent examiners. And for those of you who aren't sure, that wasn't a good thing. All right, and to the extent that there were concerns by people who wanted, who were studying the patent issues and they wanted a more pro-patent court, the fact is that the current rates of invalidation rival or exceed those that were seen back at the time the court was established. So it is now a much more specialized court, and the question is, have the fears of specializing in patent cases been borne out? And I think that to some extent you have to say yes. Certainly the lack of a robust exchange among appellate courts on novel questions of law has led to suboptimal results. On some issues, the Federal Circuit has swung to the extremes, going all the way in one way and then coming back. In other areas, it's failed to articulate a singular approach, leaving the law unsettled. The Federal Circuit has had some myopia set in. For a long period of time, the Federal Circuit treated patent law as if it were some kind of unique unicorn. For one example is for many years, the Federal Circuit had determined that in a patent case, if the patent is found to be valid and infringed, there's an entitlement to an injunction. They didn't look through the factors that go into whether an injunction is appropriate in any other portion of the law. So the Supreme Court was ultimately forced to step in and correct them and say, no, an injunction needs to have particular findings and a showing made before an injunction is appropriate. Now, I've mentioned the Supreme Court here, and I should note that when I said earlier that the Federal Circuit had alleviated or perhaps alleviated some of the burden on the regional appellate courts, I didn't say it had alleviated the burden on the Supreme Court. Congress had hoped that because you had one court deciding the patent issues, that there would be fewer circuit splits, and that would result in a thinning of the Supreme Court docket. But it did get rid of the circuit splits, but I think that thinning of the docket is not as clear. In the first 15 years of the Federal Circuit's existence, the Supreme Court heard 8 cases involving patent issues. In the next 15 years, the court increased its review and considered 28 patent cases. And in the following 11 years, it again stepped it up and reviewed 25 patent cases. And it's not simply on issues of procedure, like the injunction issue that I was talking about, but substantive patent issues as well. And this has led to a concern that the specialization may have given some measure of consistency, but the consistency has not necessarily correlated with accuracy. And that is perhaps borne out by some of the data of the 60 or so patent cases that the Supreme Court has taken up. More than half involve substantive issues of patent law that the Supreme Court felt that it had to step in to address. And that's not insignificant when you take into account that 80% of the cases that the Supreme Court has addressed have reversed, modified, vacated, or in some way pretty harshly criticized what had happened in the Federal Circuit. So with all that, I'm not sure where that leads us, but I guess what I would say is that at the time of its creation, people were worried that the Federal Circuit would set a precedent for there being other specialty courts that come into existence that would undermine the status of the existing regional courts. I think it's safe to say, after 40 years and no further specialty courts, that that didn't happen. That being said, I don't think that that we should count on anything being done terribly different structurally with respect to this one unique court. I don't think it's going away anytime soon. I practiced patent law for 25 years, and in my informal survey of clients and patent practitioners, I can tell you there's not a lot of desire to eliminate the Federal Circuit and go back to risking the differences and the forum shopping in the regional courts of appeals. Some of it may be the devil you know is better than the devil you don't, but there is not a lot of appetite for that. There is, in the scholarly publications, a lot of criticism of the court and proposed solutions, but it doesn't seem that any of those have gotten tractions. So I think where we end up with the Federal Circuit as this unique court is that it is going to remain a unique court that has a unique structure, but will not be emulated anytime soon.
Thank you very much, Judge Noreika. I have one question for Judge Schroeder with respect to the Ninth Circuit's methods of resolving intra-circuit conflicts. What is the secret sauce?
Oh, this, I don't know that there's secret sauce, but we do a lot of things to prevent, to resolve or prevent conflicts. The limited on bank is a way of having an expeditious and available way if there are conflicts. We have not found that there were very many conflicts. Many of our on banks actually go because of the importance of the issue rather than because of the existence of an intra-circuit conflict. We have an inventory system where we inventory the cases as soon as the opening brief is filed. We've been doing this for years and decades. And we used to use, the staff used to use numbers to identify each issue. This kind of jurisdictional issue was a 1, this was a 14, this was a, and then they'd match them up and put the same issue before the same panel. Now we have computers, and so we can easily find similar issues, put them together, alert when one case is decided, what other cases have similar issues that are trailing behind, so that those judges know that there's a case that might affect their case, their decision. And all of these things seem to work quite well to minimize conflicts. At one point, we asked lawyers if they saw a conflict to tell us, and we had a little box on our website, and we didn't get any. So.
Now, here's a question kind of hearkening back, though, to the presentations by Dean McAllister and Professor Lindquist. To what extent, when talking about these intra-circuit conflicts or the absence of them, are we looking at just so-called published or precedential dispositions, or are we taking the non-precedential or so-called unpublished, because they really are published decisions, into account?
Oh, I think we are, because we get them cited to us. And the lawyers, if there is one out there, they'll cite it to us.
Let me ask if anybody in the audience has any questions.
Thank you very much. I did enjoy that panel a lot because I like statistics, which tells you how boring I am. My name is Beverly Mann. I'm a 1981 graduate of the University of Pittsburgh School of Law, and I'm also adjunct faculty here. I have a question concerning the cases. What's the effect on the fact that about 70% of the cases in the federal district courts are apparently MDL cases? Did you look at that and how that impacts your, what 70% of the cases are MDL cases? How does that impact your findings with respect to rulings and settlements, et cetera?
That's a good observation. We're technologically challenged. I could do statistics, but I can't use a microphone, for crying out loud. That's a great point. And sometimes when you look at the district court filings, for example, you'll see some spikes, and that tends to be MDL litigation or something like that. So you have to keep your eye out for it. I'm not sure it's making a difference because the diminution in appeals is pretty consistent across all issue areas. Now, MDL, I guess, tends to focus in certain areas of law, but so I don't think that's what's driving the change in the docket that we're seeing at the U.S. Courts of Appeals. But you have to keep your eye out for it because it can create outliers, which then obscure the general trends. So I have thought about that a lot. Thank you for pointing that out. Mary, do you want to say anything?
Oh, I'll just add, I've noticed when I've done data work on this, that there are times that are differences in terms of how the circuits count MDL appeals. There was, I think, an instance out of the Third Circuit, for example, where the Third Circuit didn't treat an MDL appeal as one, or it treated it as like 500, and it actually affected the percentage of publication and oral argument that year, depending on how you treat that, right? So there's all these sort of data issues in terms of how the administrative office counts, what counts as a consolidated appeal, what doesn't. And I don't think there's always consistency across the circuits on that.
Are there any other questions from the audience? Yes.
I throw this out to those who crunch numbers because I couldn't crunch numbers. So something to think about. And I wrote it down. So as an appellate practitioner, and this premise could be entirely wrong, but a conventional wisdom, we often tell our clients that if the circuit is posed to reverse, they're probably going to have argument. You know, we can't say they always are. So I'm wondering if there's certainly a correlation, but wonder if there's any sort of causal connection between the decrease in reversal rates, if I got that right, and the decrease in oral arguments. But the question is, what comes first, the chicken or the egg? Are courts less inclined to reverse, so they're calling for oral argument less frequently? Or are we having fewer reversals because there are fewer oral arguments? So that's not a question I expect either of you to be able to answer now, but it's something when you were talking about the rates, I couldn't help but think about that. And again, led by this sort of conventional wisdom that there is some connection between argument and reversal.
Sorry.
I have tested that. You're right. I mean, there is a relationship between the two. You can lag a variable to try to get at causality, but your point is well taken. I'll continue with the research. I'll send you the results I finally get once I'm able to control for some of these sticky statistical issues. But that's exactly right, and it's not clear which way. What I have tested, however, is whether appeal rate is related to reversal, and I have not found evidence of that yet. I found evidence of the polarization, and I had a variable for reversal in there for the particular circuit, and didn't find a relationship yet. Now, that may be because the model I'm specifying is not properly specified. So this is a work in progress. Great point.
I think mine's on, right? Is it on? Yeah.
Yes.
Yeah. One thing I've wondered about is there are some institutional pressures on circuits where you use a lot of staff attorneys, that the staff attorney's role is not to recommend oral argument or reversal, right? Because I mean, there's some pressure on this. This is not unlike how the cert pool functions, where there's a norm where, folks want to just say deny, don't actually accept the cert petition. But that the staff attorney's job is to handle it, not to create more work for the court. And so I'm wondering if in circuits that rely even more on staff attorneys, that's part of potentially what's driving down both the rates of oral argument and reversal rates, because there's a little bit of an institutional norm against creating more work for the court, because the function they're serving is really to handle a huge volume of cases and not create more work for others.
And with that, I want to thank the members of this great panel. I want to thank Professor Hellman, and we will now recess for lunch.
All right. Thank you so much to our panelists and our moderator. That was a wonderful discussion. So as he said, it's time for lunch. Lunch is out to the right in the lobby area. And we just ask that you return to your seats by 1:30. Thank you.
Hello, everyone. I hope you all had a really nice lunch. And for the afternoon crowd, we're really happy you're with us instead of at opening day for the Buccos. 6-1, that's just absolutely fantastic. But we know where that usually goes at the end of the season. Before we get started, I did want to get a chance for Joseph Schaefer, a member of the local chapter of the Federal Bar Association, an opportunity to provide an update. Thank you.
Thank you very much, Daniel. I'll be brief. If this is of interest to you, we hope that the Western District's Federal Bar Association chapter will also be of interest to you. We'd invite you to join. You can do that by going to fedbar.org. It is free for law students, for judges, and for their term clerks. And we put on a number of different programs, including an upcoming program that we'd like to invite you to as well on April 10th at the federal courthouse here locally. And that is titled Ethics for the Rise of Artificial Intelligence in Litigation. Again, that's Ethics for the Rise of Artificial Intelligence in Litigation. And we will have one of our judges speaking as well as a partner from K&L Gates. So would like to invite you to that. And the easiest way to find registration information is to Google that rather than have me tell you a URL. So thank you very much, Daniel, and forward to the rest.
Thank you. And before we start the third panel, I do want to take a moment to discuss the accomplishments of the Law Review and the work we have going forward. First, the Law Review, whose members are in the audience today, I hope you do get a chance to meet them at the reception. We're publishing some really great work that's changing the conversation in public policy and the law. Just some examples. We recently published an article by criminal law scholar Christopher Soblogan about the scope of the Fourth Amendment in the digital age. And just last week, Pittsburgh Mayor Ed Gainey brought Daniel Bird, an author who we just published in the Law Review, to discuss his article on tax-exempt status for large healthcare systems. So what we're doing matters. The conversations we are having today, they also matter. And in 2025, the Law Review will be dedicating a special issue commemorating today's panel discussion. Many of the participants here will contribute articles or essays inspired by their presentations. So we eagerly anticipate that this scholarship will have also a great impact in the field. Furthermore, when we decided organizing a symposium last year, we had two goals in mind. First, we wanted to center around issues that would broadly appeal not only to legal practitioners, but also those who were civically engaged in the Pittsburgh community. And second, we wanted to create a space that would allow for law students, alumni, faculty, and local attorneys to reconnect or meet for the very first time. Looking back, it's clear that Professor Hellman was the perfect anchor for this symposium. The topics of scholarship on the federal courts remain incredibly relevant today, and he continues to publish new work. Furthermore, the impact he has had on his colleagues and his former students has brought all of us here today. So we are so proud to honor you in this special event. And after months of planning, I will say, to see the space filled, it's really gratifying and relieving. And we're so happy that you're here to participate. And so thank you. And so now I'll move on to the third panel, Federal Jurisdiction, Federal Courts in a Federal System. Moderating this panel will be Ms. Emma Schucare. Ms. Emma Schucare is a lawyer with experience in general civil litigation and election law. She served as counsel to the Senate Democratic Caucus during the state reapportionment process and subsequent appeals to the Supreme Court. Originally from Pittsburgh, she clerked for the Honorable Ellen Hollander of the District of Maryland and the Honorable Jane B. Straunch of the Sixth Circuit, and she received her JD from Michigan Law School. Thank you, Emma.
Good afternoon and welcome to the first post-lunch panel. So I do expect all of you to stay awake. As we know, Article 3 of the United States Constitution places limits on the jurisdiction of federal courts. This afternoon's panelists will examine some issues with that jurisdiction that have come up in much of Professor Hellman's scholarship, including litigation strategy, federalism, comity, and whether we need to dial in our definition of federal question jurisdiction. I'd like to briefly introduce our distinguished panelists. Judge Susan Graber currently sits on the United States Court of Appeals for the Ninth Circuit and formerly sat on both the Oregon Court of Appeals and the Oregon Supreme Court. Professor Fred Smith is the Charles Howard Candler Professor at Emory Law School, where he focuses on the federal judiciary, constitutional law, and local government. Judge David Strass sits on the United States Court of Appeals for the Eighth Circuit and previously sat on the Minnesota Supreme Court. And Professor Sandra Strokoff is a professorial lecturer in law at the George Washington University Law School and was the first woman to serve as legislative counsel for the United States House of Representatives. We will begin this panel with Judge Graber, whose talk is entitled Both Sides Now: Diversity, Jurisdiction, and Illusions of Equal Competence.
Okay, I think that's now on, if I've done it correctly. I am delighted to be here. One more what? Okay, I turned it on. I guess it has a little delay factor. This is my first visit to Pittsburgh, but not my first encounter, I'm happy to say, with Professor Hellman. And it's also special because one of my former law clerks, Matt Hawes, is an alumnus, and I'm looking forward to seeing him as well. Professor Hellman asked me to bring some perspective as both a federal appellate judge and a former state appellate judge to the topic of federal court jurisdiction. And I chose to speak about diversity jurisdiction. And I'll begin by placing my comments in context. Diversity jurisdiction is a constitutional requirement, so it's here to stay. The real debate is whether the scope should be broad or narrow. I know that some litigants and academics, including Professor Hellman, favor a broader scope, for example, by doing away with the requirement for complete diversity, and some favor a narrow scope, for example, by increasing dramatically the amount in controversy requirement. I once had a law clerk who suggested that $1 billion would be a good start. I actually don't have a strong opinion on the topic. For what it's worth, I think the present middle-of-the-road approach works fairly well. Although, as with all things, there's always room for improvement. Judge Strass's proposal for a small increase in the scope of diversity jurisdiction to accommodate uniquely federal interests, and Professor Hellman's proposal for addressing snapback jurisdiction strike me as reasonable tweaks at the margin. On the other hand, the amount of controversy is quite small by today's standard. But from a pragmatic viewpoint, I simply take the general scope of diversity jurisdiction as a given. Another relevant topic that's received some attention is parity, the relative competence of federal courts and state courts to apply federal law, especially in the context of civil rights litigation. My comments will address a related but distinct topic: our system of judicial federalism, including diversity jurisdiction, means that each system must apply the law of other jurisdictions. Federal courts must apply state law, and state courts must apply federal law. So of interest to me is the relative competence of each court system when applying the other system's law. And on this topic, I do have a very strong opinion. State courts do a far better job of applying federal law than federal courts do of applying state law. And I should note that my perspective, of course, relates only to appellate courts because that's the only place I have experience. And I also would note that my comments are not meant to reflect on the relative skill or talent of appellate judges, because in both systems, in my experience, we have very talented and earnest and fair-minded jurists. But I think there are structural reasons why state courts are better at assessing federal law than federal courts are at assessing state law. No matter what law school we attended, this fine institution or any other, we all studied federal constitutional law.
and the fundamentals of federal jurisprudence. Judges of all stripes in all courts start with a basic understanding of how federal law operates, but that's not at all true with respect to state law. And I'm sure many of you, studied very little state law while we were in law school. Our practices may have focused primarily on federal law. And even if we have some expertise as federal judges in the law of a particular state, that knowledge will not translate to the law of other jurisdictions. Oregon law, with which I once was quite familiar, differs a lot from California law. So my understanding of Oregon law doesn't help me when examining a question of California law. And as I somewhat alluded to just a second ago, our knowledge of state law, even if we had it, dissipates over the years. I've now had 26 years on the federal bench, and I am no longer an expert on Oregon law either. So the additional problem is that the variety of state laws multiplied by dozens of jurisdictions is enormous. By contrast to the federal government's limited powers, state governments have plenary authority to regulate the full range of the health and welfare of the state's residents. There's a wider range of laws in any given state, and of course, more than 50 separate jurisdictions that may have regulated the same issues differently. It may seem at first blush that this is a bigger problem in the Ninth Circuit because, as you've heard from in the previous panels, the circuit covers 9 Western states plus Guam and the Northern Mariana Islands. But I would say the issues in the Second Circuit with only 3 states to deal with is just as difficult, because a diversity case doesn't have to involve only the states in your own jurisdiction. You could be looking at a contractual choice of law provision that is of a state that's not in your own circuit. There's another issue, and that is that the jurisprudence that we can rely on is more limited when we're assessing a question of state law. A state judge, for example, who is confronting an issue of the warrant requirement under the Fourth Amendment can look at cases from all over the country, all circuits, lots of information out there to inform the judge's decision. But federal judges considering an issue of state law may have just a very few cases, if any, to inform the analysis. We regularly confront issues on which there is basically no state law. So in short, deciding issues of state law is difficult. And given these challenges, what are we as an appellate court to do when we're faced with an important question of state law that dictates the outcome of the case? In my view, the answer is clear: certify the question to the state Supreme Court. Scholars have spent some time outlining the pros and cons of certification. And as I see it, when the prerequisites for certification are met, the pros outweigh the cons. Generally speaking, the prerequisites are that the answer is to a state law question. The answer must control the outcome of at least one claim in the case, and the question must be important, such as an important issue of state policy. And a couple of recent examples in our circuit: mineral rights on private property in Montana, or the interpretation of insurance contracts resulting from the COVID-19 shutdowns and related governmental orders. Those prerequisites ensure that we're not wasting the party's time or the state court's time. Obviously, not every state law question deserves certification. We hear a huge number of these cases. Probably, I'm not a statistics person, but it feels like about a third of our docket probably. And most of the time, they're obvious questions of contractual interpretation or things that are not novel. They're just important to the parties, but they don't raise public policy issues for the states involved. but certification is warranted for important dispositive questions of state law. When the prerequisites are met, the benefits are clear. I'd like to highlight three of the most important ones, and scholars have named many more than this. First and foremost, certification results in a definitive, uniform answer to the legal question. By definition, the state Supreme Court's decision is correct. The parties get the right result in their case, but so do future litigants. And so do future potential litigants. By having a final answer on an important question of state law, individuals, companies, entities of all kinds can make legal arrangements accordingly. Second, the use of certification discourages forum shopping. I do feel strongly that the substantive law should not depend on the choice of forum. Litigation results should rise or fall with the strength of the case and not the ability of a panel of 3 federal judges to make an accurate, eerie guess. So whatever considerations go into a party's decision to seek a federal or a state forum, the content of the substantive law should not be one of those reasons. Last but not least, certification of important state law questions promotes what the Supreme Court has called cooperative judicial federalism. As one scholar put it, the use of certification can lead to a better, more collegial relationship between the federal and state benches, which can promote heightened judicial efficiency and cooperation in other areas of mutual interest. On the other side of the scale, scholars have raised several cons to the certification process, but only one of them strikes me as important. Although the process provides an overall benefit to all litigants and courts by generating a definitive answer to an important question, the parties to this case must bear the full cost and delay that are associated with certification. For example, this varies by jurisdiction. California is notoriously slow. And so we do consider that in deciding whether to certify a case. But to me, it's only the unusual case in which the delay or the cost would be such an undue burden that we should forego certification. Obviously, I don't, again, have the statistics, but my sense is that state courts will accept certified questions in 80 or 90% of the cases. When they do reject our requests, it seems to me there are 3 common reasons. One that is possible, but again, I don't know empirically whether it's true, is that they just feel overworked, or they look at the case and they see what they think will be a distasteful result, or existing precedent resolves the issue. When a court chooses to explain why it has refused certification, which is rare, it usually is that existing state precedent resolves the issue. And not too long ago, the Nevada Supreme Court refused a case in which it felt that the prerequisites were not met because the issue was an issue of evidence. And they said, well, it's not dispositive of a claim. And I'll give you an illustration. A few years ago, I sat on a 3-judge panel that faced a state law question. One of my colleagues and I on the panel concluded that existing precedent resolved the issue, and we held that in a published opinion citing the relevant state precedent. The 3rd judge dissented on the ground that we should have certified the question to the state court. In the view of the dissent, we had usurped the authority of the state court to decide the issue. So a couple of years later, the dissenting judge happened to be on another panel with the same issue, and they certified it to the state Supreme Court. And you can probably figure out why I'm telling you this, because The state Supreme Court rejected the certification and said the existing precedent that we had cited earlier resolved the issue. So I have a pretty good confidence in my ability to decide whether to certify a case, but I don't have much confidence in my ability to predict how the state court will resolve an unanswered question. Again, I'll give you an example. I thought that the answer to a particular question before us was clear, but all three of us decided that there were good reasons to certify a question to the state Supreme Court because it involved relatively new legislation in that state. And we thought the statute overruled an earlier Supreme Court precedent. So, and the question was important. So we certified it, and the Supreme Court of that state unanimously held that our guess was completely wrong. Its precedent remained good law. So our Erie guess was way off the mark, and it was excellent that we chose to certify the question, and the procedure worked just as it was designed. So the issue of applying state law in federal court, of course, did not arise really until 1938 when the Supreme Court decided Erie. And the Supreme Court highlighted the possibility of certification in a 1960 case called Clay versus Sun Insurance Office. And the Fifth Circuit was unable to guess confidently the content of Florida law, and the Supreme Court praised the legislature of Florida for having had the foresight to have enacted the court. So in the years following, the Supreme Court has given various other boosts to the idea of certification. And in response, the number of jurisdictions allowing certification blossomed. In the 1970s, only about a dozen jurisdictions accepted certified questions. And now every state domestic jurisdiction except North Carolina has a procedure available. The most recent boost, I would say, to certification from the Supreme Court came in 2020 in McKesson versus Doe, where the court held that the Fifth Circuit should have certified questions of Louisiana law to the state's highest court before having reached a federal constitutional issue. And that case, I think, also has piqued the interest in certification. But how often does this happen? Over the past 30 years or so, there has been some research on this question, and I asked my wonderful career law clerk, Jamie Harris, to conduct some additional digging into the numbers. Some of the studies focused on the Third, Sixth, and Ninth Circuit. And the Ninth Circuit issues about a dozen certification orders a year, so about once a month, which is a significant increase from the 1990s when we filed only about 4 a year. The Third Circuit issues about 3 a year compared to around 1 in the 90s. And the Sixth Circuit certifies perhaps 1 case a year, and that's been true all along. I guess what I would like to say about that is that there has been a changing attitude in the state courts that has helped this increase occur. When I was a judge on the Oregon Supreme Court, we tended to look at certifications with some disfavor. And one of my colleagues said, "We're not federal court law clerks." But I think there is an attitudinal change, because the state Supreme Courts are not law clerks. They are state court judges expounding on state law in a definitive way. And the Ninth Circuit also reached out to the chief justices of all of the states in the circuit to ask about their attitudes towards certification. And they all said they welcomed certification orders in appropriate cases. Even accounting for the difference in caseloads, our circuit certifies more questions than most, and I'm not sure how to account for that. But, and so I won't cry. I think there was some discussion of court culture, and I think that may have to do with it. And I would offer 3 groups of suggestions in closing for furthering the trend of certifying state law questions more often. First, to those jurisdictions that lack a procedure or that have big obstacles to certification, I would encourage them to take another look. Many of the early predictions about the detriments of certification have proved to be false. And one of the procedures that I find most difficult is that some jurisdictions require briefing and oral argument on whether to accept the case. So if they do accept the case, there's a double load on the litigants that seems to be unnecessary delay and burden. Second, I would encourage federal courts that have stagnating or low certification rates to examine whether they should be more receptive. They might also want to, for example, reach out to state court justices, as our circuit did, to get some feedback. Third and finally, and perhaps most apt in the present context, I will invite scholars to devote resources to a deeper study of this issue. The empirical research to date is either too shallow, focusing on surface level data, or too narrow, looking deeply, but only at 1 or 2 courts. So more intensive study could answer questions such as, what are the reasons for the variations among circuits in certification rates? What are the uses and foregone uses of certification? What opportunities exist for improving the rates of certification and the processes by which that occurs, both at the federal court level and the state court level? And ultimately, what opportunities exist for improving cooperative judicial federalism? Cases come and go, but diversity jurisdiction is here to stay. And I appreciate your attention. Thank you.
Next, we are going to hear from Professor Smith. The title of his talk today is Younger and Older Abstention.
All right, it's a pleasure to be here. Thank you so much to Professor Hellman, and thank you to,
All right, let's try now. All right, great. Thank you to Professor Hellman, and thank you to the Law Review, both for this invitation and for this wonderful event at which I'm learning so much. And my point of departure when it comes to the work of Professor Hellman is ways that Professor Hellman has encouraged in the space of judicial federalism to focus in federal courts classes on things that lawyers actually do. And so that, with that in part in mind, I'm going to talk about a doctrine that actually is showing up more and more in practice, and it's a doctrine that we call younger abstention. This doctrine appears in the criminal legal setting. So these are cases in which there is a state criminal case, often one that is ongoing, or at least where there's some debate about whether it's ongoing. And then there's a federal judicial proceeding in which someone is challenging some dimension of that state criminal trial. And the general rule is that federal courts are not to interfere with or join ongoing state prosecutions absent great and irreparable harm, or absent certain exceptions like bad faith, or like bias, or like timeliness. There's no timely opportunity in the state proceeding to deal with the federal constitutional issues. I actually want to problematize that, and in particular, what I want to press down on is this idea that this should be called younger abstention at all. Okay? So younger abstention is a case from the early 1970s. By calling it younger abstention, we almost invite a kind of amnesia in which we start with that moment, or perhaps where we start, sometimes we start just a few years earlier in 1965 in a case called Dombrowski. So even though we call it younger abstention, we acknowledge at least that this was an issue a few years earlier in a case called Dombrowski. And on this telling, the way that we often will tell the story is that Ex parte Young was decided in 1908. This opened the door to opportunities for federal courts to interfere on state criminal matters, and enters Younger, which sort of puts the brakes on that. But actually, two things. Number one, intervention by federal courts in state criminal proceedings predates Ex parte Young. And number two, exceptions to chancery courts, courts of equity, intervening when it came to state criminal matters predates younger abstention. If you'll bear with me, I'm going to tell the story of the origins of criminal abstention. And if I'm going to relate this back to the idea that we want to talk about things that lawyers actually do, the nature of equity jurisdiction today is that the Supreme Court has encouraged deep attention to history and to tradition. And if we're going to do that, that requires looking to more than a handful of cases from the late 1960s and the early 1970s. Criminal abstention, or the idea that chancery court shouldn't interfere in criminal legal matters, can be traced back to the 1600s or the 1700s. And part of this was because in the centuries before, going back to the 1300s, in the time of Richard III, it was often the case that chancery courts would get involved in criminal matters, but really they would actually often act as criminal courts. So people would seek injunctions for what would be called breaches of peace. And so they were intervening in matters that looked on their face much like criminal matters. This created a great deal of tension, and that tension reached a boiling point in the 1600s. And that's in part because of the relationship between chancery courts and the Star Chamber, which at the time was deeply unpopular because it was a kind of, in some ways, was not an institution that was friendly to rights. How about that? So one place where we see, and sometimes where I have sometimes seen this cited, there's a case from 1742. It's called Mayor of Pinkerton, Lord versus Mayor of Pinkerton. It's a British case that articulates the view that chancery courts are not generally should not generally be involved in interfering with criminal matters. And in that particular case, what you had was a criminal case that was ongoing, and then you had someone seeking an injunction that would interfere in that criminal prosecution. And the Chancery Court said, as a general matter, that's something that we don't do. And I could point to many cases after that, including in the United States, cases like Fitz versus McGee at the United States Supreme Court in the late 1800s, where that particular principle was articulated. At the same time, even if we're going to pay attention to these earlier instances in which criminal abstention existed, what I also encourage, though, is to pay attention to those earlier moments in which there were exceptions to criminal abstention. So in the Pinkerton case that I just described, it turns out that even though the Chancery announced and articulated that general principle, the Chancery Court nonetheless intervened. The Chancery Court intervened, given its view that the ongoing quasi-criminal matter, as it referred to it, would have been biased because the individuals who were seeking the injunction were the same people who would be serving as judges. So they were plaintiffs in one case and they were judges in the other matter. And the Chancery Court thought, at least in those circumstances, it did make sense to intervene. Often today, when we talk about a bias exception to younger abstention, we cite a case from the early 1970s, Gibson versus Berryhill, and that's where we begin to tell the story. But when we look to the longer history, we see that actually this is something that existed long, long before Gibson versus Berryhill. It's also the case that when we look to earlier cases, we see intervention in instances of great and irreparable harm that predate the 1970s. So I won't give you a whole lot of cases. I'll focus on one right now. So one is a case called Wood versus City of Brooklyn from the 1840s. This is a case, it's in the state court system, but it's a case where there was a law that, a law from Brooklyn that banned the sale of alcohol on Sundays. That was in violation of a state law that would have authorized the sale of alcohol. Someone sought an injunction after they had been arrested for this particular offense. The Chancery Court acknowledged, once again, as is often true in these cases, acknowledged the general rule, but nonetheless said that in that instance, given that, among other reasons, it involved one's right to earn a living, that intervention was warranted. There's other cases about the right to earn a living at the federal level as well. There's a case called Louisiana versus Fitzpatrick. This is a case in which Louisiana in 1868 granted an exclusive ability to one entity to operate a lottery. In the late 1870s, Louisiana took that away. The entity that had been given that exclusive authority continued to operate the lottery in violation of a criminal statute, and sought a federal injunction, which was granted, given that this involved great and irreparable harm, namely the right to earn a living. There's also cases that recognize that various dignitary interests also qualify as great and irreparable harm. There's a case called In re Sims, which is a case in which involved essentially a debtor's prison, where someone was alleging that they were being held in violation of a law that banned debtor's prisons, and a court granted an injunction in that setting. There's also a number of cases that arise in the racial justice context, a number, especially from San Francisco, given the treatment of Asian Americans during that time period. In the case of In re Sing, the city of San Francisco created a law that prohibited Asian businesses from operating in certain parts of the city and prohibited Asian Americans from living in certain parts of the city in the 1880s. A number of residents of San Francisco were arrested for violating this particular ordinance, and as you can guess, based on the theme, right? This is another matter in which a federal court granted an injunction, even though this was a case that implicated criminal justice issues, and that halted those prosecutions going forward. In another case out of San Francisco in the early 1900s, there's a case in which Asian Americans were required, and Asian Americans alone, only Asian Americans, were required to receive a vaccination for the bubonic plague. And at the time, there were two vaccinations that were known to potentially help. And one was significantly more dangerous than the other one. And the one that was more dangerous also was much less efficacious. And that dangerous one was the one that was required for Asian Americans and only Asian Americans to take. And in a suit on behalf of 25,000 Chinese Americans in San Francisco in the early 1900s, that law was challenged, and an injunction was in fact granted. So when we lift back, what we see then is that a number of exceptions, great and irreparable harm, bias. I could give you cases as well about bad faith, but there's probably only so many cases I can rattle off without completely losing you. And even cases about timeliness. There's cases about whether or not one has to go to the state court system before coming to the federal court system, right? And this is actually an issue that's emerging right now in various courts of appeals, where people are fighting about whether the timeliness exception should continue. It's an issue in the Fifth Circuit. And in the Eighth Circuit, one question that has emerged is whether or not, as a matter of younger abstention, if there's an opportunity to go to a state court and file the civil case there first, under those circumstances, should a federal court abstain? And in a United States Supreme Court case called Smith versus Ames, the Supreme Court says that is not the case. The Supreme Court says that one does not have to first go to a state court proceeding, and that one can choose their forum. But we miss all of this. We miss these cases. We miss this broader picture. We miss this history and tradition if we focus in on a handful of cases. And that is often what happens. And it's happening right now in cases, we're in a place where younger abstention is showing up quite a bit. Is in cases that are challenging regimes that criminalize poverty. And I've written about those sets of cases in particular. So cases in the pretrial detention context, cases that involve essentially debtors' prisons, where there's fines and fees that were imposed without attention to one's ability to pay. Younger abstention is often invoked in these cases. It's often rejected in these cases. But in the last few years, especially in the Fifth Circuit, there has been younger abstention is being expanded. So I invite us to stop calling it what I just called it, younger abstention. Start calling it criminal abstention, and we can find novelty in our oldest ways. And stop finding novelty in our oldest ways. Thank you.
So, Judge Graber and Professor Smith, broadly speaking, one of you has laid out a sort of a vision for an expanded role of state courts in federal litigation, and one of you has sort of discussed an expanded role for federal courts. And I was just curious if either of you had any comments for the other, if anything came to mind while you were listening to the others talk.
Well, I think the issues are significantly different because the cases that I'm talking about are civil only. So they don't really call for an analysis like the one that Professor Smith has given. And they also, I suspect, arise less frequently than the issues that he has addressed. For example, I mean, the years that we've had 12 certifications from the Ninth Circuit, we've processed about 12,000 appeals. So this isn't, it's the tail wagging the dog from my perspective. It happens to be an interesting tale in my view, but it is, I think it has kind of less dramatic effect. I think it may have more effect within the states themselves than the thing that Professor Smith is talking about, because by definition, when a state court accepts the certification, they are going to affect and definitively answer questions of state law. And I think that's less likely to happen. So it's less frequent and maybe more significant for the state as distinct from the federal court.
Yes, I also see them as distinctive, and I'm a big fan of certification. And part of what I appreciate, I mean, when certification expanded, a lot of this was in the context of something called Pullman abstention, so a different kind of abstention than what you were referencing, which is sometimes called Thibodeau abstention. Sorry, I know I'm getting really fake horsey here, but but it arose in the context of federal questions where the argument would be made that if you resolved a state court issue, then it would obviate the need to reach a federal constitutional question. And in particular, it would potentially obviate the need to reach what Justice Frankfurter called sensitive social questions. And in the context in which he said that, Pullman, he was talking about racial segregation specifically. Certification arose as a response to that. It was a way of operationalizing that particular principle. And what I'm hearing is ways in which the greater use of that could appear in a different context, which is diversity jurisdiction, right? So even if certification initially arose in this federal question context, it's increasingly being used, it sounds like, in the diversity jurisdiction context. And I would imagine, I mean, how many states are in the Ninth Circuit? 8, 7, 8, 9
states.
9 states. I would imagine we're in a circuit with that many states in particular, that the use of it. And actually, that would be the question I have for you. Do you think that the number of states that are in your circuit influences your perspective on the greater use of certification or the need for it? So if you were in a circuit with only 3 states, for example, do you think that it would be easier to kind of?
I think it's easier to ignore, but I'm not sure that it actually arises less frequently. Because as I mentioned in my talk, sometimes the question is not, let's say you're in the Second Circuit, but there's a choice of law provision on Nevada law for, they know nothing of that. So I think we're more conscious of it because we do cover more states and we're more likely to recognize our own lack of expertise in the state law of a state that we're not from, but I think it is just as important elsewhere.
All right, I think this is on. I hope it's on. So I just wanted to comment on certification. I agree with Judge Graber completely, that I think state judges, having been one, state judges are better at federal law than federal judges are at state law. So I totally agree with the premise, and a lot of it is structural, what you learned in law school, what you may have practiced in court as a young attorney and things like that. But the funny thing is I don't know that I agree on the conclusion, which is that more certification is warranted. And a large part of it is based on sort of one's experience. So the court I joined, the Minnesota Supreme Court at the time, basically said, don't certify anything to us. Told the federal judges that, and did not welcome them. And the one certification that we did get was from a Seventh Circuit decision. It was a case in Wisconsin that dealt with Minnesota contract law. And they certified a particular question, and we decided to answer an entirely different question. It was case dispositive, but it sort of gave me a skewed vision of what certification is all about. And it's a sample size of 1, so I should dismiss it. But I just wonder sometimes whether it gives unnecessary delay. That maybe, and this was I think the view of my court. My court said, you know what, we welcome a differing view. We now have an opportunity to have a 3-judge panel of a federal court or district court judge tell us what they think the right answer is. We can always overrule them essentially the next time we get it, but it's interesting to hear somebody else give us their opinion on it. Maybe that's unfair to the parties, but that was sort of the thinking of my court. So I just wanted to sort of present a differing view, but it's a really important question. It comes up a lot on the diversity docket.
I want to say something about this is highlighting all the more how different these two contexts are, the federal question and the diversity jurisdiction context, because part of what happened with Pullman abstention is that a federal court would say, all right, we're going to abstain, we're going to stay this case, or even dismiss it if it was in the equitable context, but either stay or dismiss the case. And what you're supposed to do now is go to a state court and file your suit there and litigate the state question, right? And then you can decide whether you want to litigate just the state question or the federal question. But if you want to reserve the federal question, then you need to make sure that you explicitly reserve the federal question. That was even more inefficient. That was certainly more. It was more inefficient than certification. But I suppose in diversity jurisdiction, maybe there's a different. Maybe that story looks different. I don't know.
Okay, in the interest of time, I'm going to move us along. Next, we are going to hear from Judge Strass, whose talk is entitled "When Removal Doesn't Quite Work."
All right, hopefully it's still working. Okay, good. I want to start out just with a little bit of a story, a personal privilege. You heard from another judge this morning, Judge Schroeder, who took a moment of personal privilege. And that's because I wanted to say something about where this came from, this idea. It didn't come directly from Arthur, but it certainly came indirectly from Arthur. And I'll tell you why. So as a young professor at the University of Minnesota, I was probably 32 years old at the time. I emailed Professor Hellman, Arthur, and I said, you know what, I'm an admirer of your work. Shrunken Docket Piece was a piece I had read, and he had this wonderful case book on federal jurisdiction that took what I think is a very practitioner-centric view of federal courts. There's, of course, Hart and Wexler, which is a ginormous book, and there's other really academic type federal courts books, but there were very few that were practically oriented. He said, yes, and 16 or 17 years later, I'm still a co-author on that book. But here's why that's significant. Our book has a chapter on removal jurisdiction, special problems in removal jurisdiction. And I've got to admit, I didn't always know why it was in there, because it's the one part of our book that contains just circuit cases or not very many Supreme Court cases. But it was practically oriented. I wonder whether we were putting too much of an emphasis on removal jurisdiction. Turns out we weren't. And the way I figured that out was when I became a federal judge and had to deal with removal jurisdiction. And it comes up all the time, and a lot of books don't deal with it. And so then fast forward 16 or 17 years later, and I'm sitting as a judge, and I start getting these removal cases, and I'm thinking about them in a critical way precisely because Arthur wrote about them, because he put them in the book, because we talked about them in conference calls. And so for those of you who are students of his who feel like you've learned so much from him, that goes for co-authors and colleagues too. I've learned a lot from him. And so when I wrote this, I'll talk about it in a second, but I wrote an opinion. It channeled a lot of what Arthur had taught me and a lot of what we did in the book. So I'll tell you what the problem is. The problem is when removal rules don't quite work. 99% of the time, they do. And there's a lot of wisdom to removal rules. But I encountered a case a few months ago, and I'll get into it, where the well-pleaded complaint rule and the removal rules don't make any sense at all. There is an answer that you come out with that just is a matter of history and text and structure of government. It just doesn't make any sense how they come out. And so I've thought critically about how we can tweak the rules. So let's see if this works. There we are. Ooh. So this is where we're going to cover the well-pleaded complaint rule, complete preemption in Grable, Minnesota versus American Petroleum Institute, which was my case, and then Merrill Dow versus Thompson. And I think seeing it is helpful. So the well-pleaded complaint rule, everybody knows that. Everyone's taken civil procedure. What's on the face of a well-pleaded complaint, defenses and other counterclaims, they just don't really matter. There are two exceptions. We'll go through this quickly because many of you are familiar with this. One is complete preemption. There's ordinary preemption and there's complete preemption. Complete preemption is a congressional intent basically to make that cause of action exclusive. The only problem with complete preemption is it's rare. It's only come up on 3 occasions according to the United States Supreme Court. So while it's an exception, it's a relatively narrow exception. LMRA, ERISA, and the National Bank Act. So one question I want to posit, because I think this is important, should the complete preemption doctrine be expanded? Now, what's interesting is I have long been an opponent of complete preemption, thinking that it comes out of nowhere. It's not textually based at all. It's sort of a weird doctrine. But this case that I encountered a few months ago makes me think that maybe complete preemption should be expanded beyond these 3 narrow areas. All right. Maybe I've stepped too far away. Oh, all right. So the second exception is the Grable doctrine. Okay. So the Grable doctrine is necessarily raised, disputed, substantial federal issue that's resolvable in federal court. That's the Grable doctrine. And this came after a case called Merrill Dow versus Thompson, which was a 1986 case that we used to have in our case book. That I think provides an interesting parallel to the case I'm about to talk about. All right. So this was the case. And for many of you who follow the federal courts, almost every circuit now, in fact, I was talking to Arthur last night, I think every circuit has had one of these cases. They are climate change cases. And what has happened is states have sued the energy companies for things like misrepresentation and fraud, because the allegation is they lied for years about the effect on emissions on the environment. So it's sort of like a tobacco-like litigation type of theory. And that's the theory that they filed in state court. So all of these cases, with the exception of one coming out of the Second Circuit, have been removed to federal court. Okay. And the question is should you remand the claims? And here's what happened and this is the underlying issue. Was Minnesota's claim here well pleaded, in which case it goes back to state court, or is it artfully pleaded, in which case they're pleading around a federal issue and it should remain in federal court? All right. So federal common law on pollution may provide a defense, but this is the majority, but it's not completely preempt state claims. So now you see complete preemption coming up. Minnesota's claims were state law fraud and consumer protection. And Congress has not really acted in this area, not with regard to misrepresentation, fraud, and consumer protection, even though they have acted in the Clean Air Act, right? But not in the particular area in which Minnesota was suing. And then removal fails step one of the Grable doctrine. It does not necessarily raise a federal issue. It's a federal defense, so it won't necessarily bring up a federal issue, despite the fact that we're talking about transboundary pollution. And I'll tell you what the significance of that is in a second. So I looked at this case and I said, the majority is absolutely right. No question about it, right? Under current doctrine, this case has to go back to state court, despite the fact that we're talking about climate change and pollution. But I did note how confounding it was. Minnesota's lawsuit does not arise under federal law, but perhaps it should. Despite pleading state claims, Minnesota seeks a global remedy for a global issue. And the complaint, this was what was most striking to me, explicitly references climate change and seeks, quote, a far-reaching injunction. So the case to me, at least if you look back at history, resembled an interstate dispute. It was like Pennsylvania was suing Ohio. The only difference is there was a nominal defendant, private defendant here, which just happened to be the energy companies. But what they're really suing about is global energy policy. I mean, that's really what they want with a far-reaching injunction. This was not about money damages. It was about changing the behavior of the energy companies. All right. There we are. So this is what ultimately ended up coming out of it. I said these are unique federal interests. It was a pure interstate dispute, and that the well-pleaded complaint rule tacitly enables this by hiding a federal issue in a defense. Okay, so it didn't make a lot of sense to me. And here was the kicker for me. If you go pre-well-pleaded complaint rule, and you go back to the Smith test, which I think somebody might have mentioned, maybe it was last night, I can't remember, or maybe it was this morning, but real and substantial disputes that depended on an act of Congress could be removed. So if you go back to pre-well-pleaded complaint rule, this was the type of case that would be cognizable in federal court. And of course, everybody knows, because it's in the Constitution, that state disputes, Pennsylvania suing Ohio, those end up in the United States Supreme Court. They are so important that they're within the original jurisdiction of the Supreme Court. Yet somehow, some way, this case not only doesn't end up in a single federal court, it ends up potentially in 50 different state courts, which did not make a lot of sense to me. All right, so now we go to Merrill Dow. This is the model that I'm going to use. The Supreme Court, I think it was an opinion by Justice Stevens in the mid-1980s, came up with this really bright line rule on when a cause of action presented a federal question that sort of upset 60 years of precedent. So Merrill Dow was again a removal case. Plaintiff sued in state court. I don't know what that is. Arguing that Merrill Dow's drug Benedictine, it's a thumbs up, but I don't know where it came from, caused deformities in children if ingested during pregnancy. The defendants removed the state law negligence claims on the ground that there was federal question jurisdiction because everything in the case rode on the back of what the Federal Food, Drug, and Cosmetic Act said. The district court declined to remand. The Sixth Circuit reversed. And the question was, does this federal statute, this key federal statute lingering in the background, because it was like a negligence per se type of claim, did it create federal question jurisdiction? And the answer was no. Despite only the fighting issue in the case being the interpretation of a federal statute, the Supreme Court said the fact that Congress did not create a private cause of action in the Food, Drug, and Cosmetic Act was dispositive here, okay? And I can tell you, because I was teaching federal court at the time until Grable came out like 2 decades later, this was a confounding decision for federal courts professors because it deviated so substantially from what the Supreme Court had said before. And Justice Stevens said, providing a supplemental remedy here would effectively make Congress's choice meaningless. Notice the dissent, Smith. It was all about Smith. We've been doing it this way for 60 years. I don't understand why we're all of a sudden reversing this longstanding precedent on how federal question jurisdiction works. All right. Hopefully no thumbs up. All right. Pulling back in Grable. Fast forward a couple of decades later, and the Supreme Court backed off Merrill Dow versus Thompson in a case called Grable. And there, the Supreme Court kind of came up with a balancing type test. And it didn't overrule Merrill Dow, but it said instead of it being dispositive, that there's no federal cause of action within the federal statute that creates the federal question, it's a factor to consider among many in determining whether there should be federal question jurisdiction. So that was clearly backing off what the Supreme Court had said. And I think it was a Souter opinion, Justice Souter opinion. I like this a lot. The missing cause of action was akin to a missing welcome mat, not a missing federal door key. And the federal door key was a reference back to the Thompson decision. So after Grable, Merrill Dow almost became a dead letter. It's been cited less than 100 times in federal courts over the last 2 decades. The only case that I could find where it was dispositive was a Sixth Circuit case that basically said, this case is almost exactly like Merrill Dow, so we're going to follow Merrill Dow rather than Grable. But other than that, Merrill Dow does not have, much efficacy or power in federal courts anymore. So then the question is, does Grable provide a template for perhaps going back to a pre-1880 sort of real and substantial federal question test, at least for unique federal interests, where you have a state versus state type of cause of action that is being litigated through the medium of a private company? And so that's the question I pose. Is the well-pleaded complaint rule has a sort of outlived its usefulness to some extent? Should we use Grable as a model in scaling back and dealing with cases like API? I'll tell you that the aftermath of my case, it did go up. They sought certiorari at the Supreme Court. I got exactly 1 vote for certiorari with my separate opinion. It was Justice Kavanaugh, who just simply wants to hear more cases. So I don't think I can't speak for him, but I don't know if my case was special in any way. But my point is there at least some interest on the United States Supreme Court? And I think it's time to think about these, particularly as our economy becomes more global and is different than maybe it was 100 years ago. And that is it.
Our last speaker for this panel is Professor Strokoff, and her talk is entitled Drafting Laws Relating to Federal Jurisdiction.
There we go. You hear me? No? How about now? It's green.
It's on?
Yeah. Yeah. You can hear me now? Can you hear me now? Okay. So a lot of people may ask me, why am I here? And I can start out, first of all, I'm going to say it's a pleasure to be here and an honor to be among so many distinguished scholars and jurists. And thank the Law Review and thank Pitt Law and thank you, Professor Hellman, for making this all possible. And if I can start out by saying that what John Cleese would say in Monty Python's Flying Circus, and now for something completely different. And I'm going to talk as wearing my hat as a drafter of federal legislation. Just a quick civics lesson. Few people know that legislation in Congress is drafted by two offices, the offices of Legislative Counsel in the House of Representatives and the Senate. They're nonpartisan, established by law, and they've been in existence since 1919 and are founded upon two principles, impartiality and confidentiality, which are mandated in its statute. The statute for the House says the purpose of the office shall be to advise and assist the House of Representatives and its committees and members in the achievement of a clear, faithful, and coherent expression of legislative policies. Some people say that's an oxymoron, but I'll get into more of that. Impartiality and confidentiality are musts so that parties on opposing sides of an issue will feel comfortable seeking the assistance of Legislative Counsel to have their proposals drafted accurately or to the best of their ability. And it's been so successful that, say, you have Republican staff coming into the Legislative Counsel, having their proposal drafted, knowing that as they walk out, the Democratic staff will be walking in and the same attorney will be drafting it. Because given the myriad of statutes covered in the 54 titles of the U.S. Code and the relatively few attorneys in the office, attorneys specialize, and we use that word sort of cautiously because you wind up covering a lot of areas. I worked in the Office of Legislative Counsel for over 40 years, and my areas of specialty covered patents, trademarks, copyrights, matters affecting federal courts, international trade, international relations, and laws relating to lobbying and ethics. And that covered the jurisdiction of 5 different committees. The workload varies, but can be staggering, especially at the end of a Congress. Draft at every stage, bills for introduction. When a bill is considered in a committee, you draft amendments that members want to offer for the consideration. You draft amendments that members want to offer on the House floor. If it passes the House and then passes the Senate, then you work with your Senate colleague in preparing the final text that can pass both houses and then be presented to the president. The committee, once it decides it wants to consider a bill, will hold hearings inviting subject matter experts to testify on the merits of the bill and views on ways to improve it. And Arthur talked last night about, thanks to a Rolodex, he was called as an expert myriad times for the Judiciary Committee. And because of the wisdom of the staff, he was called over and over again. Because the fact remains that although you develop an expertise in a particular area of law, you can't really draft something accurately. You can't make the policy. You have to understand the policy, and you have to have the input of outside experts to make sure that the legislation does what it's intended to do, and they'll have a view of perhaps unintended consequences. Guiding principles for drafting are every word, every comma, or designation is subject to challenge. King v. Burwell, the Supreme Court case deciding whether the term state, including the federal government, in the case of federal health insurance exchanges under the Affordable Care Act. U.S. v. Rompier Enterprises, a case interpreting the placement of a comma, and Coons Buick Pontiac GMC versus Nye, in which the issue was what was the meaning of a subparagraph, and this arose because of a drafting error. And it was a provision that you could tell was not drafted by the Legislative Counsel because it was just very sloppy. But can you imagine something that is always Supreme Court, and they have to decide what the meaning of a subparagraph is. And they used as a source, I co-authored this book, legislative drafters desk reference, and they quoted from it about what, the hierarchy and how you would observe it in a bill. So every word has to pay its own way. Every statutory term adds something to the law's regulatory impact. And this is the rule against surplusage. I'll get a little bit more about the rules of statutory construction. Beware of words having more than one meaning. Be consistent, consistent, consistent. If a bill uses a term repeatedly that may be unfamiliar, unclear, or ambiguous, define it, define it, define it. Drafter has to have answered a series of questions before the writing begins, the foremost of which is, what is the issue that needs to be addressed? What is the policy and legislation? Legislative counsel is prohibited from expressing views about whether something is a good or a bad idea. By asking questions, the policy can be honed, and sometimes you get the client to modify the policy by asking questions of what you perceive what some of the results might be. The staff of the member of the committee requesting legislation must answer questions of policy. Ultimately, it comes down to say only what needs to be said, nothing more, nothing less. Also, the drafter has to has to know what laws exist on the subject. So you don't want to you have to be aware of repeating existing law. You don't want to pass the same thing twice, and or say the same thing twice. And a little story about that, I drafted for the Judiciary Committee for a lot of years. And at one point, one of the chairmen of the subcommittee on courts and intellectual property, I had drafted an amendment for him, and he was offering it, but he didn't like the idea that it didn't say, he wanted the thing to be said essentially twice. So on the committee, he says, I want to insert this, amend my amendment. So basically the impact was that it said the same thing twice. So he said, if something's worth saying once, it's worth saying more than once, which is exactly the opposite of how a court would look at it. Are there conflicts with existing law requiring collateral amendments? That's a big issue. Under what constitutional authority will Congress be acting? That has been a big issue since 1995, when I guess Lopez v. Morrison was, or maybe it was Lopez v. United States. So it was the first time since 1937 that the Supreme Court overturned a law of Congress for violating its powers under Article 3. And since then, there have been a series of cases, which you all know. So you have to be aware of what the bill does and under what constitutional authority Congress is acting. How will the bill take effect and be implemented? If the bill will change the rules of the game affecting the status quo, the bill will have to address in an effective date or transition provisions how to apply the changes to those persons or circumstances. And effective dates can be the most challenging provision a drafter faces. What is the relationship with state law? Should preemption provisions be included? All this requires time to draft and for the legislative process to work. The drafter strives to draft legislation that is clear and concise, is not ambiguous, is constitutional, and avoids unintended consequences. But to get the policy, the objectives, the involvement of outside experts in subject matter is often necessary, hopefully sought as early in the process as possible. The later the stage, the less likely changes to be accepted. The more quickly legislation is rushed through, the more likely to be unintended consequences. I have a lot of stories in other areas of the law that would be true. But thanks to visionary staff of the House Judiciary Committee, as I already said, Arthur was around to answer questions on legislation I worked on which he had expertise. What it comes to mind most is I drafted the new Chapter 16 to Title 28, which established a new judicial discipline. It got rid of whatever provisions were in there and established a new procedure for judicial discipline. And Arthur was there every step of the way to review what I had drafted, to tweak it, to offer suggestions, and it was just invaluable. So you need that input, and especially in an area like federal jurisdiction, in the overall scheme of things, laws relating to federal jurisdiction are really rare. There are very few amendments to Title 28 that deal with that. So if you look, for example, and I'm going to talk a little about unintended consequences, at Public Law 101-650, the Judicial Improvements Act of 1990, it covered a large number of issues. So Professor Hellman discussed with me recently when we were talking about this symposium. One provision that added a new supplemental jurisdiction provision to Title 28 United States Code, Section 1367. The language having been drafted and sanctioned by some in the academic community, it was not Arthur. The provision, unfortunately, had the unintended consequence of overruling a Supreme Court case relating to diversity jurisdiction. It was on the International Paper Company. Now, the drafter can't be expected to know this or have time to research relevant case law. You rely upon the experts. Because this law, this was one, I say teeny provision, this law also added a new chapter to 28 requiring district courts to implement civil justice expense and delay reduction plans, added new circuit and temporary and permanent district judgeships, implemented many recommendations of the Federal Court Study Committee, included a separate title of the bill on judicial discipline. This was pre-Chapter 16. Had amendments to Title 17 United States Code establishing so-called moral rights in works of visual art, amendments to Title 28 to ensure survivors' annuities in the case of judicial officials who have been assassinated, which was a new issue to deal with, and they actually made it retroactive to sometime in the 70s when there had been a judge had been assassinated, and a slew of miscellaneous technical amendments to fix minor errors in existing law. But the most challenging provisions for me is I had to draft a new retirement system for claims court judges in Title 28, and that required a slew of conforming amendments and technical amendments to Title 5 U.S. Code, which was the system under which claims court judges had operated before. So it's a difficult task for a legislative council to compose and organize such a large bill in logical fashion, ensure the bill is internally consistent and technically precise. If not, the amendments to existing law may not be executable and therefore be ineffective. To ensure that all necessary collateral amendments, both within the bill and to existing law elsewhere, are made to avoid conflicts with the existing law and to ensure the formatting is correct, et cetera. All this is always against the ticking clock, the formidable enemy, time. So Judge Harmon was talking about, the speed of the digital age, and that I think is true everywhere. And sometimes I think staff think you can push Control-Alt-B and it will just produce a piece of legislation as if there's no thought that goes into it. The drafter won't know how a new provision will impact the community to which it applies without the input of that community. What is what I found most interesting about the supplemental jurisdiction provision is that the bill hadn't gone to the House floor yet. So technically the language could have been fixed. The language was added to the House committee report, again, something filed before it's considered on the floor, saying that the language wasn't intended to overrule the Supreme Court case, even though legislative history cannot change the clear words in the statute. So there was time to fix the language, but there was likely no political will to do so for a few words in a huge bill that had likely been signed off on by members and stakeholders, probably in both the House and Senate, which would likely be collaborating throughout the process to reach language that can be accepted by both houses. Its collaboration starts early on in the process. They don't wait till House to pass something and then go to the Senate. If it's something they try to do between the houses, they'll work collaboratively from the very beginning. The end result was a Supreme Court case interpreting 28 U.S.C. 1367, Exxon v. Alapata, refusing to, quote, give any effect to such a deliberate attempt to amend a statute through a committee report. And this was done because of political realities. As I said, they had time to fix it, but politics was not there to make it so. So this lesson was a lesson in the politics of drafting and the judicial treatment of legislative history. So I just want to turn for a minute to the Leahy-Smith American Vents Act, which Judge Noreka was referring to before as a I don't know if it was the reason, no. This was important for the establishment of the Court of Appeals for the Federal Circuit. That's a clicker. All right, here it is. So this bill, it changed the way patents were considered. It changed it from a first to invent rule to a first to file rule. So that was drastic. But in patent law, like in federal jurisdiction law, so much it depends on decades of court decisions and case law that you didn't want to mess with too much of it. But since this was a change, involvement of the experts was from the very beginning. And because of the same wise judiciary staffer, they said the representative of the patent lawyers were in there because they knew what the laws and knew what they wanted. And it actually, but I had to ask questions so I could figure out what they wanted and make the words say that. So at times it came down to, he actually drew diagrams to try to figure out what the timing and placement with all these parties was. But as a consequence, we came up with language that worked. It was a very scary process, but it was also a very long bill. So in it, I point to this because you talk about consequences. In it was a provision, there'd been a provision inserted in the CREATE Act, which was the, let's see, did I say it there? The Research and Technology Enhancement, the CREATE Act, Public Law 108-453, which protected patents that had been done cooperatively between companies and researchers. There was something that patent law said you couldn't be owned by two different people, and this was one where they're deeming owned by the same person. So there was such a concern that all this bill did was move it from one section to another section verbatim. So it was in 103C, and in the way the new thing was structured, became 102C of Title 35. And they were so nervous about it, and they had, it turns out their lawyer representing them used to work on the staff for Congressman Kastelmeyer, and he'd been the chief of staff of the same subcommittee, that they lobbied to have language put in that said that, the enactment of Section 102C under paragraph 1 is done with the same intent to promote joint research activities that was expressed, including the legislative history through the, and they named the act, the amendments of which are stricken by subsection C of this section. U.S. Patent and Trademark Office shall administer 102C in a manner consistent with the legislative history. So that was overboard and wasn't really necessary. But you can see, you can have people who want to protect what the law is, and that was fearing an unintended consequence, which probably wouldn't have happened. Okay, so I'm going to jump to more examples of the role of politics. And this is all kind of neat because do this right. Okay, whoops. Okay. This bill was introduced in, I don't know which Congress, it doesn't say in here, but you see what the title is. Command entitled with respect to the jurisdiction of federal courts over certain cases and controversies involving the Pledge of Allegiance. Draper was talking about that. And so was whatever Congress 2005 was in, so, okay. So this is pretty simply, Chapter 99 is, Title 18, Title 28 is amended, and then adds this new section, except as far as such as being no court created by act of Congress shall have any jurisdiction, the Supreme Court shall have no appellate jurisdiction to hear or decide any question pertaining to interpretation of or validity on the Constitution of the Pledge of Allegiance as defined in Section 4 of Title 4. That other exception just has to do with protecting, making sure it didn't apply to courts in DC and courts in territories, which are also established by Congress. And it was pretty clear that this was politically motivated. Likewise, the bills to split the Ninth Circuit that Judge Graber was talking about, and those bills are still introduced every Congress to split the Ninth Circuit. And I think the most recent was introduced by representatives from Idaho and Arizona. But the Legislative Council would be concerned with, okay, you want to create this new court, but then there are all sorts of technical questions. How do you divide it up? How do you deal with the current court? And then you create a new, so there was a definition of old Ninth Circuit and then new Ninth Circuit. And then there was going to be a new, what number are we up to? 13th, I guess, circuit. And then how do you divide up the, the states And then how do you handle existing cases? How do you divide the judges up? If you let them pick, what do you do if there's an uneven amount, if there are too many judges in one district and not enough in another? All these kind of technical questions. How do you determine when the existing 9th Circuit shall terminate? Who handles all the administrative side of things? So these are all technical questions, aside from amending Title 28, making sure that's precise, that Legislative Council has to make sure are answered in the bill. So I saw this bill, and it rose after a 9th Circuit decision, Newdale versus United States in 2002, declaring that under God in the Pledge of Allegiance was unconstitutional. So I saw this. I guess I don't know. I guess it was introduced, maybe reintroduced, and I don't remember drafting it. But even if I had, there were a lot of bills that come across the reintroductions, and you ask why someone is doing something, and then ultimately you tell them why they're doing something, and ultimately the customer is always right. And if it's something that a member insists on, then you have to do it. While I think of political realities, you'll see language, lots of times there'll be language in bills that might be ambiguous or word choice, and it's there because it's the only way to achieve consensus among maybe competing parties or consensus on a bill. That happens a lot in copyright bills. You have all these stakeholders representing different interests. And they say, we won't sign off on this unless you have that comment there or something. And I might have to argue, but the comment there creates ambiguity. But there's that happens a fair amount. Legislative Council tried to talk them out of it if it is going to create an ambiguity, but ultimately you may have to put it in there. And likewise, you say, I think this is unconstitutional. That usually scares off people. But however, in this case, I wondered how this bill was constitutional. But apparently the Judiciary Committee staff had held a hearing. Arthur said he was at that hearing representing an opposite view. And the majority of the witnesses had said it was constitutional because of Article 3, Section 2, to make regulations accepting cases from the jurisdiction of the Supreme Court, which was mentioned earlier. And a majority of the expert witnesses had so testified. So the majority party decides which bills will be considered, selects the majority of the witnesses who will testify. And then when the committee considered the bill, this had to be maybe the most fascinating debate I ever was at in my 40 years. It was a fascinating debate on in the committee about the consequences should this bill become law. There would be a patchwork of decisions. So you'd have Idaho determining that it was constitutional, California asserting it was unconstitutional. So you cross the state line and then law would become constitutional, unconstitutional. And that didn't seem to bother the proponents of the bill. Ultimately, one of the members said, do you think Marbury versus Madison was wrongly decided? Do you think it was wrongly decided? Do you think it was wrongly decided? And this member said, yeah, because 1803, it was fascinating. It was great. One member broke from the majority party. He said basically this bill came about because, quote, wacky decision of the 9th Circuit. But if you pass this bill, then the decision will then be made by the California Supreme Court. That makes no sense. So he didn't vote for the bill. The committee could not get a vote. It was tie vote. So they couldn't report it out favorably. And they tried a parliamentary maneuver the next day where someone who's opposed to the bill can make a motion to reconsider the vote. So they called another meeting and this member was standing in the back. The chairman said, under the House rules, someone who opposed the bill can offer for can make a motion to reconsider the vote. Do I hear such a motion? He didn't say anything. So they couldn't file a report on it. But it's very unusual for a bill to be considered on the floor without a committee report. But the House leadership decides which bills will be brought to the floor, how it will be considered and debated, and it passed with one amendment adding an effective date to make sure that the bill applied retroactively to all pending cases as well. So just a word about rules of statutory construction. I'm going to read from this book. Let's see. So I was involved in the second edition of this book. I said, why don't I add a chapter on statutory construction? Because when you're learning how to draft and you learn from senior attorneys, and it takes years really and you never really master drafting federal legislation. What does the role that rule statutory construction play? Well, you don't think about every single one of them, but if you draft clearly and concisely and with economy, then the hope is that you'll avoid it going to court. But if it does, you have to be aware of some of them. So you have to keep some in mind, such as the rules of statutory construction may not reflect the political realities that determine how and what constraints under which a statute is drafted. The court studies the words of a statute that are in dispute, considering multiple possibilities and ascribing meaning to them. The reality may be that the language was composed hurriedly without the kind of analysis done by the courts. The knowledge of the canons attributed to the legislature may be lacking, to say the least. But I guess the courts have to do something, right? So in this King v. Burwell decision that I mentioned earlier about whether the term state includes federal in case of the healthcare exchanges under the Affordable Care Act, the reality was that this was, I mean, I could write a thrilling novel about how this thing got enacted into law. It was a set of circumstances I don't think we'll see repeated. But ultimately, you had the tax drafters drafting the tax provision when they used state exchange. You had the healthcare committee guys drafting over here, talking about federal exchanges. And the Senate bill passed rapidly, and then there was no conference on the bill because that lost a 60-vote majority and all this kind of stuff. And it was really thrilling, but but that's, so I used to think, well, the courts really don't take into account how laws are drafted until this law. And the majority, well, I think it was majority, or was the ruling opinion said Congress wrote, the Affordable Care Act contains more than a few examples of inartful drafting. To cite one, the act creates 3 separate sections, 653S. Several features of the act's passage contribute to the unfortunate reality. Congress wrote key parts of the act behind closed doors. That's nothing new. Rather than through the traditional legislative process, which rarely happens. And Congress passed much of the act using a complicated budgetary procedure known as reconciliation, which limited opportunities for debate and amendment and bypassed the Senate's normal 60-vote filibuster requirement. As a result, the act does not reflect the type of care and deliberation that one might expect of such significant legislation. That wasn't really accurate what happened, but they got the major points across. And that was like the first recognition of the court saying, well, maybe we should look about how bills draft. And I think that's why the decision was right, saying, well, state really had, Congress had to meant that state exchanges included federal exchanges in those states that didn't have state exchanges. Anyhow, I think, did I have, oh yeah, those are my 2 examples. I wanted to get the bit in about rules of statutory construction. In these courses on legislation, they're casebook based, and I can understand that, but there doesn't seem to be any recognition of how laws and bills are actually drafted. And I think that would be a great addition to any course on legislation. GW, they're now requiring it of first-year students, and I've participated in, like, the professors might give us a half hour or an hour to discuss something which could take, we have a whole semester course on it. So it's a shame there's that reluctance because, the reality is there, and it really might help, I think, courts inform how they look at statutes. Anyhow, that's it.
I have a question for all of our panelists. Professor Hellman has recently written that certain developments in federal question jurisdiction specifically may not necessarily comport with the underlying logic and spirit of Article 3. And I am curious to hear from each of you, and I have no particular, whoever wants to jump in first, how you would summarize, conceptualize the underlying logic and spirit of Article 3.
I guess I'll start. I agree with him that the more amount of time that's passed since the founding, since the Judiciary Act of 1789, since the early days, probably the more and more, and I'm noticing this in a lot of areas, the more and more we've moved further away from Article 3. So, complete diversity versus minimal diversity, for example. What constitutes a federal question seems a lot more limited now by some of the rules I talked about than they did perhaps 100 or 150 years ago. To be sure, the Constitution does allow Congress to pass laws that regulate the jurisdiction of the courts. But one wonders whether in doing so, and it's certainly not any one Congress's fault or anything, but one wonders if in doing so, we've moved further and further away from sort of the core of what our Article 3 courts are supposed to have to decide, or need to decide.
Yeah, I mean, I think of Chief Justice Marshall's language that to not decide a federal question where there is jurisdiction is as bad as deciding something where you don't have jurisdiction, and that to refuse to do so is treason to the Constitution, in his words. And I think it is certainly the case that over time there have been more and more in the way of judicially constructed doctrines that kind of crowd out a role for federal courts. I mean, even if we think about just the relationship between federal courts and states, and when it comes to federalism, right? I mean, like Osborne versus Bank of the United States, like you don't, I mean, there is certainly an ample opportunity to see a lot of language about why federal courts maybe shouldn't be involved in certain questions that implicate state laws and so forth. And it's not there. So I think over time there's different barriers that have been constructed. And it's not to say that they're all bad, but I do think we've gone further and further away from norms closer to the founding.
I'm a pragmatic person. I really don't I've never been a professor, and I've never wanted to be a professor. So I don't really have the conceptual. I guess the only thing I would add is that I'm intrigued by what Judge Strass said earlier about where Congress ought to enact laws but doesn't. And that is part of our federalism, where the states are the laboratories. And for example, on the issues that you were talking about, the state of Montana has a constitutional provision that its citizens are entitled to a healthful environment. And that's something that is a state question for them, even though it also implicates the whole world. So I don't know quite where that leaves us in terms of federal questions and questions that ought to be but aren't yet.
So do you have anything to add? Please thank our panelists.
I know we went just a little bit over, so we're gonna come back here. What time is it now? 3:15. Can we get back here, or we'll start at 3:25? I know that doesn't give everyone as much time, but I do want to make sure everyone gets the reception on time. Thank you.
Yeah. Yeah. That's fine.
All right. There's nothing I can do. Yeah, I was on the first part because I was like, okay, there's like 10 minutes left, so I need to go. Like I was talking to Amy, and then I came back and there was still another 15 minutes. Like, Mine. What do that mean? Okay. I love it. I am. Yeah. I mean, it had to be documents. You're right. I have. Yeah. 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 Well, and it's originally was 19. Yeah, but that's one of the. That was me. Yeah. Yeah. No, thank you. Yeah. Someone said it. Yeah. I use that. Yeah. Yeah. Right. Okay. Turn green, so it takes a second. Yeah. I will. Yeah. slide it over. It takes 1 second and then it turns green. Everybody, I think. Right, and
but
they
it's
probably
yellow.
see it's still yellow. So now. That way it'll turn green.
Slide it to the green.
Yep. And that's on. Yep.
Right, okay. I will.
Turn it on.
It's muted now.
It's. Right, to turn it. That's on, and then you slide.
Perfect. Yeah, that's perfect. Thank you. I will. Yes, yes, I will. Okay, I'll decide. Okay, okay. Okay, great. All right, thank you to everyone who's filing in. Please go ahead and take your seats. Our last panel of the day is the very exciting federal judicial ethics. This panel is moderated by Professor Jesse Allen, who teaches jurisprudence, legal ethics and property at Pitt Law, and was my wonderful property professor, and I was her research assistant. So thank you for doing this, Professor Allen. Her writing and teaching is informed by her experience as a litigator and a civil rights advocate. Okay, she's cutting me off. She's wonderful. This will be a really exciting panel, so I will turn it over to her.
Okay, can you hear me? Great. So we do have 4 distinguished panelists here today to talk about judicial ethics, if I can talk. And we're going to divide this session into 2 parts because our first 2 speakers, who are Russell Wheeler and Judge Brooks Smith, are going to talk about the legal ethics and judicial ethics of the lower federal courts. And we're then going to hear from Charles J. and Kedrick Payne about judicial ethics regarding the Supreme Court. So let me very briefly introduce the 4 panelists and then we'll get going. Immediately to my right is Judge Smith, who's a member of the Third Circuit and has been for over 20 years. And before that, for 14 years, was a federal district judge here in the Western District of Pennsylvania. Also previously a member of the Judicial Conference. And I think interestingly, for several years at the beginning of his career, a state court judge, is that right? Court of Common Pleas of Blair County, Pennsylvania. So that's quite a bit of diverse judicial experience. And he's been a chief judge on both of his federal courts. Then joining him in the first half of the panel is Russell Wheeler. Let me get my page about Mr. Wheeler. Hang on. He's a political scientist, and he is a senior fellow at Brookings. He was with the Federal Judicial Center. He's written widely on judicial ethics in many different distinguished journals. Then, as I said, in the second half of our program, we've got Professor Charles J. He's from the University of Indiana School of Law. He has written very widely on judicial behavior, judicial ethics. I'm very interested to hear what he has to say. I'd like to say that his work has been part of my own scholarship for a while. And then we have Kedrick Payne, who I recently saw testify before Congress. He is Vice President, General Counsel, and something of ethics at the CLC, which is a very interesting organization in DC that's concerned with a number of different issues, including campaign finance and other democracy issues, as well as ethics. So without further ado, Judge Smith.
This should be working now. The green light is on. Green light is on. All right, there is a delay. Thank you. We've not exactly stayed on time, so I try to engage in a certain amount of self-editing prepared remarks here. Let me begin by saying that what judge, what legal scholar would attempt to plumb the depths of a tricky issue of judicial conduct or disciplinary process without reference to Arthur Hellman's work. I've known Arthur for many years, and little did I know that at this stage in our respective careers, I'd be focusing so intensely on his prolific output, his tireless work in the sensitive area of judicial conduct with disability. Think of that, judicial conduct with disability. What a way to start a weekend. In acknowledging the contribution that Arthur has made to an effective system of judicial discipline that ought to work, my role on this panel is to explain just how this system does work on the ground, so to speak. I need to be clear at the outset that I am not here to discuss conduct issues and the Supreme Court of the Supreme Court of the United States. It may seem a kind of plodding way to start, but federal judge needs to be aware of 3 main authorities regulating misconduct and disability issues. The Code of Conduct for the United States judges. The Judicial Conduct and Disability Committee
recently released a digest of authorities that our committee chair, Judge William Traxler, has described as a 200-page compilation of summaries of opinions that have been handed down by the various circuits in the United States, along with those released by the JC&D Committee, which will provide the Chief Circuit Judges and Judicial Councils a reference book showing, and will provide the Chief Justice and the judges with a reference book showing how other circuits have handled problems that may be similar to those that they currently have. Of the three authorities that I have mentioned, the Code of Conduct is the code with which we federal judges are most familiar. The Judicial Conference adopted the original code in 1973, and there have been revisions since, the most recent being in March of 2019. The code provides federal judges with black letter ethical canons and accompanying commentary that serve as guideposts for how we should conduct ourselves, both officially and in non-judicial activities. Topics include upholding the integrity and independence of the judiciary, avoiding impropriety and the appearance of impropriety, performing our duties fairly and impartially and diligently, engaging in or not engaging in certain extrajudicial activities that are consistent with the obligations of judicial office, and avoiding political activity. The Judicial Conference of the United States is the policy-making body of the federal judiciary, and it works through its various committees, a substantial committee system. The conference authorizes the Committee on Codes of Conduct to provide advisory opinions to judges who ask how the code may apply to a set of concrete facts. At all events, a judge who wants to be sure that she is doing the right thing may ask the committee member who represents her circuit for advice. It's a good system. As the National Commission on Judicial Discipline and Removal recognized back in 1993, the code was not intended as a source of disciplinary rules, and not all of its provisions are appropriately regarded as enforceable under the Act. As the commentary to one of the rules I'll be discussing puts it, the code was sets forth behavioral guidelines for judges. Ultimately, the responsibility for determining what constitutes cognizable misconduct is determined by the Act and the rules. The code has been amended to address systemic issues that have been brought to the fore. The Me Too movement led to some changes. In his 2017 year-end report on the state of the judiciary, Chief Justice Roberts alluded to the problem of sexual harassment in the workplace, including the judicial branch. The chief charged the judiciary with conducting a careful evaluation of whether its standards of conduct and its procedures for investigating and correcting inappropriate behavior are adequate to ensure an exemplary workplace, his term, for every judge and every court employee. And he directed a working group to recommend reforms. Recommendations from the working group resulted in the conference's amending the Code of Conduct in early 2019. The code now makes clear that misconduct includes unwanted, offensive, or abusive sexual conduct, and the federal judiciary has since been providing more training and information. We've created a national office of judicial integrity to provide judiciary employees with a source for confidential counseling, guidance, and intervention related to sexual harassment and other forms of harassment, discrimination, and workplace misconduct. And each circuit has at least one director of workplace relations. And Congress, of course, has spoken by entering the field. They've through the passage of the Judicial Conduct and Disability Act of 1980, which is separate and apart, of course, from the code itself, which was adopted by the judiciary. The Act authorizes any person to file a complaint alleging that a federal judge, not a justice, has engaged in conduct prejudicial to the effective and expeditious administration of the business of the courts, or has become unable to discharge all the duties of the judicial office. It provides for review of the complaint by the chief judge of a circuit, action by the chief judge after such review, and avenues for review by the circuit's judicial council. Every circuit has a judicial council. I'll not spend time on its statutory role in governance, except as it may be relevant to this discussion. The act also provides authority for the chief judge to appoint a special committee to investigate potentially meritorious factual issues that cannot be resolved from a view of the face of the complaint. The special committee will report on its investigation to the Judicial Council of the circuit where the complaint is pending. And if the council finds that an Article 3 judge's conduct may be so serious as to warrant impeachment, it must refer its findings to the Judicial Conference. In scenarios where the findings are not so serious as to warrant impeachment, an impeachment recommendation, a special committee is required to present its findings to the circuit's Judicial Council. Federal judges know the code, but the act, process-based as it is, hardly plays a role in the daily life of a federal judge, except for chief circuit judges, and even now, chief district judges. I'm confident that Professor Hellman and Russell Wheeler as well knows and has pondered the act more than the vast majority of federal judges. The rules for judicial conduct and judicial disability proceedings establish mandatory, nationally uniform guidance governing judicial conduct and disability proceedings under the act. As is the nature of rules, they fill in the details that the act doesn't or can't specify. They dictate the process for filing a complaint alleging judicial misconduct or disability. This is probably the point where I emphasize that the vast majority of complaints are dismissed very early on. Many are filed by disappointed litigants, a fair number by prisoners. And if a complaint goes to the merits of how a case is decided, it's dismissed by the chief judge on its face as relating to the merits. But anyone can file a complaint, whether or not the complainant has a connection to the allegations being made. The complainant need not even have personal knowledge regarding the facts alleged. Once filed, the circuit chief judge reviews that complaint. From there are two tracks for what may happen. And aptly, Professor Hellman refers to the first as the chief judge track and the second as the special committee track. Under the first track, the chief judge dismisses a complaint if it alleges conduct that, even if true, is not prejudicial to the effective and expeditious administration of the business of the courts, and does not indicate a mental or physical disability resulting in the inability to discharge the duties of judicial office, is frivolous, is based on allegations lacking sufficient evidence to raise an inference that misconduct has occurred or that a disability exists, is based on allegations that are incapable of being established through investigation, or has been filed in the wrong circuit. The chief judge may also conclude, a term of art, a complaint because voluntary corrective action has been taken. Then a dissatisfied complainant may petition for review by the Circuit Judicial Council. After reviewing such a petition, the Judicial Council issues an order affirming the chief judge, returning the matter to the chief judge, directing further inquiry, or by suggesting identifying or saying that he should identify a complaint, or even suggesting that a special committee be appointed. And if one or more members of the Judicial Council dissent from the chief judge's order, the complainant may petition for review by the Judicial Conduct and Disability Committee. That is a committee, the National Committee of the Judicial Conference, in which I serve. In the second track, after the chief circuit judge reviews the complaint, and if she spots a reasonably disputed issue, she must appoint a special committee where there is a reasonably disputed issue. That's important. As the commentary to the rules explains, unless the complainant's allegations are facially incredible or so lacking in indicia of reliability as to warrant dismissal, a special committee must be appointed to investigate because there is a material question of fact, material factual question. The special, once appointed and following the investigation, the special committee files a report with the Circuit Judicial Council. The Judicial Council considers the report, ultimately issuing an order. And after the order is issued, the complainant or subject judge may then petition for review by the JC&D committee. One rule that I will highlight and hope we can discuss further is Rule 5. The rule is of great significance to any chief circuit judge because it provides the authority by which that chief identifies a complaint of misconduct or disability. Just briefly, let me talk about a few instances where Professor Hellman has impacted the regulatory system. So far, I've discussed the basics. Let me turn for a few minutes to his valuable work. He and the federal judiciary have not always agreed, but the realm of judicial misconduct and discipline has had an impact. His work has, and it's been a positive one. Rule 23 governs issues of confidentiality when a complaint is brought against a judge. Professor Hellman previously suggested that at a hearing of our JC&D committee, that Rule 23 should authorize disclosures of a complaint, the name of the judge, when necessary or appropriate, to maintain public confidence in the federal judiciary's ability to redress misconduct or disability. The rule adopted, the rule was adopted. We adopted his suggestion as well as Professor Hellman's suggestion that there was no need to require extraordinary circumstances as a predicate for disclosure. Professor Hellman has since pointed out that the 2019 amendments added what he calls puzzling language to the 23B commentary. That language authorizes the disclosure of information about the consideration of a complaint, including orders and other materials related to the complaint proceeding, but only when a complainant or other person has publicly released information regarding the existence of a complaint proceeding. Professor Hellman has posited that the preferable approach is to amend what is now the final sentence of Rule 23B1 to make clear that the permitted disclosures include not only the existence of a proceeding, but also orders and other materials related to the proceeding. So while disclosure would still be discretionary, some disclosure would be the norm. Further, Professor Hellman has repeatedly emphasized the need to amend Rule 5A. That rule begins when a chief judge has information constituting reasonable grounds for inquiry into whether a covered judge has engaged in misconduct or has a disability. The chief judge may conduct an inquiry as he or she deems appropriate into the accuracy of the information, even if not no related complaint has been filed. He has discussed that this language makes it too easy for the chief judge to do nothing in the face of evidence pointing to possible misconduct or disability. This may be grist for further discussion because my experience has been that it is not easy for a chief judge to avoid making these hard choices. Arthur, I thought I ought to add just one where I didn't quite see it the way you see it. In any event, I've engaged in some self-editing here so as to cut back on the amount of time, hence some of my stumbling over the edits I was making instantaneously. I'd like also to speak as Russell Wheeler and I go back and forth of the responsibility to report, which is very different today than it was before the changes that were made back just a few years ago. So I'll sit down at this point and we'll resume with the format we've discussed.
The chair appreciates your timeliness. Thanks, Judge. And now, let's see if we can.
Are we on? Except the microphone is not on me.
See if you can flip that on. All right.
Oh. Can you hear me? Green light.
You see why he's a judge and I'm not. Arthur had asked me for this program to do a retrospective on the 1980 Act, what went right and what didn't, and I'm working on that. But we thought for this discussion, perhaps some questions and answers between Judge Smith and me might be a way to bring out some of the details of what he was talking about. I should say there's been references here to the Commission on Revision of the Federal Appellate System, so-called Ruska Commission, which went into business in 1973 with Arthur as its deputy director. I got to Washington that same time for a fellowship at the Supreme Court, and they sent me over to the commission to, I guess I didn't know what else to do with me, but in any event,
The director of the commission, some of this room will recognize the director of this commission was Leo Levin, who was a longtime civil procedure professor at a law school on the other side of the state. And he introduced me to Arthur. And he said, Arthur has a wonderful pen. It's a lovely pen. And so next time I saw Arthur, I started looking at his breast pocket, trying to see this wonderful implement that Leo was talking about. But indeed, he was talking instead about Arthur's ability to take what could be rather monotonous and dull subjects and really enliven them with a beautiful prose. And so I join everybody else here in thanking Arthur for all his contributions and his personal favors. Judge, you referred to, and you invited discussion on when chief judges can identify a complaint. A chief judge gets wind of something and there's no complaint filed, but it's likely to be, I would think, it's likely to be, get wind of some controversy involving a judge. It's likely to be more serious than, as you said, frankly, the great majority of complaints that get filed under the Act are dismissed, and properly so. I think there were 3 special committees last year, about 1,000 complaints filed and 3 special committees appointed. So they're a relatively rare thing. But you said you and Arthur disagreed a bit. Arthur's view is that the chief judge may have the authority to investigate further and perhaps the authority to identify a complaint. Arthur suggests perhaps they ought to have not the authority, but the obligation to do so. And you took some issue with that because you said it's hard not to investigate and identify a complaint. Maybe you can, obviously without going into individual cases, but hypothesize them up enough to let us know what you're talking about.
Yeah, the hesitation I have in joining the language change that Arthur suggested is simply this. I think the culture has changed considerably in the last at least 6 years. And I speak specifically since the Kaczynski scandals and the results from that, the actions taken by the Chief Justice, which I commend.
This is the chief judge out in the Ninth Circuit who got in trouble for some sexually explicit websites.
Yes. And he eventually resigned, retired. But that, I'm sure together with some other factors, but that was really what instigated the push, the changes, the working group that Chief Justice Roberts appointed, which resulted in rules changes. And I think from a judge's perspective, any federal judge's perspective, not simply a chief judge who's called upon to deal with incoming information, which, as you suggest, she or he has gotten wind of, and that's often the way it happens. It's almost impossible to avoid today. Not that one should avoid it, but we have made great strides in creating this culture of awareness and openness, but even more, the obligation on the part of a judge to report to the chief judge of a district or to the chief judge of a circuit information that has come to that judge's attention. And that judge doesn't have to have been a percipient witness. It's enough that the information has come to him or her. And if you don't report it, that in and of itself is a violation. So I think that presents a strong incentive for a much broader group of members of the judicial family, judicial officers themselves, to come forward with that information to the chief circuit judge. And I was that person for more than 5 years during this period of what I've called great change. And I know that it has made a difference. Will it result in every case? No system is perfect. But again, I emphasize what I think has been very enhanced awareness, which has resulted in a profound change in culture within the courts, within the judiciary, and then the potentially punitive nature of a judicial officer not reporting something that comes to that person's attention. The buck stops here, at least did when I was a chief judge. And alongside the fact, remember, Rule 5 is relative to the chief circuit judge. being able to identify a complaint based on the information that has come to him or her. Rule 6 is about complaints generally, really, that anybody can file. So there are those two different routes, those two different tracks, as Arthur has described.
I might say, you're listening to description of the act and its administration. There have been two studies of the act's administration, one in the early 90s and one in a committee chaired by Justice Breyer in the early part of the 20th century, after a member of Congress basically threatened to take away the judiciary's self-regulation authority. And we can go into that incident if you want. But both of those studies were conducted, and I can say this with some personal knowledge, were conducted with great rigor in the analysis they undertook. These were not slipshod or exercises, and they found that by and large, in both instances, chief judges and counsels were administering the act as its authors intended, as the act intended to be administered. It didn't comment on how much misconduct or disability there is, but as the instances of problematic dispositions, basically failure to appoint a special committee, were really quite low. They were a little higher in cases that had a lot of visibility. Too high, the Breyer committee said, but overall, both times they've had these studies have validated the approach that the judiciary has taken, and they did not do so going into the exercises with that conclusion already written. It raises the question, the Breyer committee recommended that this was 2005, 2006, whether or not the committee on which you serve might undertake another analysis, perhaps not quite as extensive, but to monitor the administration of the act. I don't know if you have any thoughts about that.
It's not, I can say, as one member of the committee, simply that it has not been a matter that has been at the center of our attention. We have had, again, without going into detail, a few matters that were substantial in recent times that have reached our attention. You're mentioning the special committee, though. I think bears emphasis, especially you're having pointed to the limited number of them. I wonder if there's any perception out there that particular avenue has not been pursued by chief judges with sufficient vigor. On the other hand, in my prepared comments, I indicated the availability of consideration by the Judicial Council if the chief judge does not go through with the appointment of a special committee. As I went back and reviewed the entire set of rules and reread all the commentary to them, it struck me as I first read the rule and then specifically read the commentary, which affirmed my thought. The standard really is the equivalent of a Rule 56 summary judgment standard. I mean, whether we have a question, a reasonable question of material fact here, and where a chief judge cannot answer this question from the face of the complaint, there is the availability of further investigation by the chief judge, and that's available in the language of the rule itself. It's that in and of itself is, if not vague, pretty wide open in terms of what the chief judge can do, but it clearly means he or she can talk to some other people, inquire further prior to reaching that ultimate decision of whether or not the question simply cannot be resolved without pursuing the appointment of a special committee. And I've had to go that route. I did it not within our own circuit, but I did mention, or maybe in my self-editing that I went through as a matter of time, I didn't reach this, but there is available to the circuit where a particular matter has arisen, where the chief judge may seek to have the whole disciplinary matter transferred to another circuit. Now, this is neither encouraged nor discouraged. It's pretty open, but there are some situations where a court simply doesn't want members of the court who may be colleagues or close friends or both of a subject judge to have to deal with the difficult questions of fact that really require the appointment of a special committee. And in that case, and I once had to make a request of the Chief Justice for that. The request is made and the Chief Justice either does or doesn't grant the request to transfer the disciplinary matter from this circuit where the conduct arose to another circuit at the choosing of the Chief Justice. And the investigation itself can be very wide ranging, and the one that I was personally involved in, we hired outside counsel. Boy, was that expensive. I went into it thinking, obviously I'm still naive after almost 40 years as a judge. I thought, boy, this law firm's going to cut some kind of a billing break. As I don't expect pro bono treatment, but maybe they shave the hourly rate a bit. Damn, did I have a lesson to learn? But anyway, the government's approved rates were not sufficient, and I had to really look around and finally came up with someone very good. But it's an extensive and detailed process and an appropriate one. And we get good counsel, we got a good report, and I think a good result that didn't result in any further action, which is very important.
It is true. And I was teaching a course in U.S. courts at the Law School of American University. I present those data about this many complaints, this many special committees, and the universal reaction is, oh, somebody's sweeping something under the rug. Something's got to, where there's all this smoke, there's got to be some fire. But I refer back to the two studies I mentioned, one for the Kastenmeier Commission and that Charlie's well aware of, and then one for them to Justice Breyer, that the courts, at least in those two, and I think, again, they're doing what the act tells them to do, and it just so happens there's just not an awful lot of complaints that gets filed that once filed that merit that kind of consideration. Let me another data point with one eye on the clock. Last year, about 1,000 complaints. This is the Judicial Conduct and Disability Act administered by the Judicial Conduct and Disability Committee. Last year, there were a little more than 1,000 complaints filed. Of those that alleged disability, there were 20, only 20. And now the reaction to that is there's got to be more cases of disability, physical, mental disability, perhaps age-related, than that comparison would suggest. And you know very well what I'm talking about. So it might be helpful to, what do you do in a situation like that?
I know he didn't mean you know very well what I'm talking about because I'm the center of one of this, but not yet anyway. But no, I know exactly what you're talking about. And it's a great point you made the other day when we were talking. I really regard this as kind of and this is not exactly an apt description, but sort of the new frontier in this area for the older members, usually of the Article III judiciary. We've experienced the shock of the Kaczynski and post-Kaczynski discussions, but we're dealing with Article III and life-tenured federal judges who love their jobs. Nobody likes to think of mortality or even of failing, and I've had to deal with a couple of those cases, and they are so fundamentally different from conduct cases, which may be conscious conduct. And these disability cases are so often unconscious conduct, and they're sad. And the big difference in how they're handled, and really in the statistical realm, they still end up playing into, I think, the same result, because most of the conduct complaints end up going nowhere. The extent to which the disability complaints, few as they are, go nowhere is because the human factor comes in. And a chief judge, if it gets to his or her point, goes to talk to colleagues and then goes to talk to family. And boy, those are tough. And sometimes the judge won't listen even to family. I've had that experience. But they do often get resolved. One of the cases I had, the judge actually ended up with a little blurb on network news on a CNN story because the judge took off in his car while this thing was pending. It wasn't a big story, but You don't want it to reach that point, but it still ended up with a friend of his talking him into it. That's the way those are handled almost all the time. But it doesn't make them any easier.
The people, the legislators who wrote the act said that they anticipated that some of the most difficult problems would never arise under the act, would be handled in different ways, and it has turned out that way. Let me ask one last question. You spent a lot of time talking about the rules, which Arthur has studied extensively. Somebody said Justice Brandeis used to read reports of the Cole Commission for relaxation. Arthur reads the rules for relaxation, I think, and there's not a movie he wants to watch. But the Judicial Conference, the governing body of the federal courts, has had the authority to issue binding national rules to administer the act since 1980. They didn't do it until 2009. And since then, this committee has been much more active, and the conference has been much more active. And you described it, the mandatory rules, the oversight, the digest to which you referred. Do you think there is right now the right balance that is, classic American government tension between central control and administration and local control and administration in this particular area?
I think there is the right balance in terms of availability, but still, these cases are almost always resolved at the circuit level. And this compendium that we've recently issued is almost entirely circuit-wide decisions, many, just a smattering, if you will, of JC&D committee opinions and decisions. Will that change over time? I don't know. I haven't seen evidence of it yet, though. And I'd like to think that a lot of it is because of the successful way in which these matters are being handled at the circuit level. These are not only judges administering it. We have staff that we never had before in the persons of directors of workplace relations who are one centralized at the administrative office in DC, and every circuit has at least one of them, and they are used by employees and I'm sure by other judges from time to time seeking guidance. So I just would repeat, as cliched as it may sound, the culture has changed, and that has helped.
I know you know one last thing. A lot of what Judge Smith talked about are available. The digest is available online at uscourts.gov. The advisory opinions to which he referred under the Code of Conduct, the committee often reformulates them into a general advisory opinion. They're all available. It's over 100 of them. Most of them deal with disqualification. The rules, the rules are downloadable from uscourts.gov. So this is all fairly transparent. There's also a requirement that every court post on its website how to file a complaint, the guidance on the complaint. Compliance with that has been a little bit iffy, but I think the judiciary, which I'm not always prone to praise, I think has done a pretty good job of trying to make these things fairly transparent.
I appreciate that. I'm prone to praise the judiciary quite frequently, in case you haven't noticed, but I viewed this as an opportunity to just say we've done a lot. We're not perfect. I simply leave you with this because it's one that remains in my mind. A conduct issue, sexual harassment issue, sexual harassment that definitely occurred after the use of alcohol at a judges and lawyers, actually lawyers event with judges in attendance. And to have to sit across the table and tell, this was a non-Article 3 judge, that I think you better retire. I think you better resign. This is what I have. This is where this is going to go. Having somebody break down in tears in front of you, and it's the job. But these are the human problems that arise and that we're handling. And I think by and large, Russell, we're handling. Thank you.
Okay, and now for something not completely different, but significantly different, we'll hear from Charlie.
Greetings, folks. I am more scripted than usual. I don't like being scripted, but if I don't script myself, I go over my time. And at the end of a long day, when all that's standing between you and drinks is us, I don't want to incite violence. And so I'm apologies in advance. I first met became aware of Arthur Hellman in 1989 when I was hired as counsel to the House Judiciary Committee and inherited a reprint of his article, Jumboism and Jurisprudence. It is a title that sticks with you. that my predecessor had left on his bookshelf. It was the first really insightful article on judicial administration I'd ever read, and it piqued my interest in a subject that, as it turns out, 2 years later would launch my career, and lo, 30 some odd years later, here I am. We finally met in person about 15 years ago when Arthur and I testified before the House Judiciary Committee together a bunch of different times on matters of judicial conduct and ethics, with Arthur being called by the Republicans and I the Democrats. If the showrunners of those hearings were looking for Arthur and me to strip down and jello wrestle in a partisan spectacle, they were deeply disappointed. We agreed most of the time, and when we didn't, I gotta say that I've never had more fun being on the opposite side of an argument. Arthur was never interested in showing off, never interested in scoring points. He was interested in getting it right. To that end, he approached the enterprise with an open mind and an encyclopedic command of the facts and law underlying the policy questions at issue. And so when we disagreed, I invariably learned from the exchange. Our world has become so cynical a place that calling what academics do a pursuit of truth is derided as naive, if not laughable. But if truth seekers are an endangered species, Arthur is our unicorn. He is a scholar's scholar who richly deserves today's celebration of his career. The focus of my paper today for this festival is on the Supreme Court's new code of conduct. In the past decade or so, all 9 sitting justices and several who are no longer on the court have been the subject of news reports calling their ethics into question. Throughout that time, court critics, myself included, have sort of been sprinting after the court like a dog chasing a car, barking furiously for it to adopt a code of conduct. Then last November, we caught the car. The court finally adopted a code, and here we are sitting blinking with a bumper between our teeth saying, now what? For some, it was time to start chasing a new car. The code was not worth the paper it was printed on, critics argued, because the court did not establish a disciplinary process to investigate and enforce code violations. Now, whether the court should adopt a disciplinary process or whether Congress should impose one, worthy debate. Regardless of where one stands on that debate, however, my point here is that fixating on the role codes play in discipline overlooks the critical role that codes play as a source of guidance and inspiration that creates an ethical climate within a court system which can reduce the incidence of code violations and the need for discipline. To lay the theoretical foundation for my point, I tap into 2 different literatures in my paper. One literature, pretty old, underscores the extent to which the rule of law is really faith-based. Alexander Bickel spoke in terms of the secular religion of the American Republic, while more recently, Sandy Levinson has written about our constitutional faith. The rule of law works in no small part because we believe it works. We're devoted to it. The law is fraught with indeterminacy, particularly at the Supreme Court level. Indeterminacy that the faithless judge can manipulate to serve their own agendas. The rule of law thus depends on judges, kind of like priests, being true believers whose integrity, impartiality, and independence to commit them to interpret the law as faithfully as they can for the benefit of a congregation whose continued confidence in the courts and devotion to the rule of law depends on it. To overwork the metaphor, codes of conduct gradually emerged as rules of the rectory to guide and inspire judges to pursue a righteous path essential to preserving the rule of law values and public confidence in the courts. A second literature has studied the role of codes of conduct in business, in government, and in academia from the perspective of institutional psychology. These studies have shown that establishing a code of conduct by itself does nothing to change workplace behavior. For codes of conduct to change the ethical climate of an institution, it is critical that those subject to codes of conduct buy into the project and take ownership of the code as their own. To that end, researchers have identified 3 factors essential to the success of codes of conduct. First, a code should not be rolled out as an isolated event or a one-off. It should be integrated into a more comprehensive ethics program. Second, the workforce should feel that the institution's leadership is behind the code and takes it seriously. Third, the workforce should play a role in code development and application itself. Now, the lower federal courts have checked all 3 boxes, and I think you can sense that from the conversation that we just saw. Its judges have bought into their code of conduct in ways that entrench an ethical climate there. First, the code of conduct has been integrated into a larger ethics program that begins the day the judges ascend the bench with baby judges school, where they're introduced to the code. I mean, that's the term, not my term, their term, where the judges are introduced to their code of conduct and its application. It includes ongoing ethics programming from the Federal Judicial Center. It then features the Committee on Codes of Conduct, which was alluded to before, which is if you have issued 116 advisory opinions and counting, and which functions as what's colloquially referred to as the Dear Abby Committee, answering over 1,000 inquiries from rank and file judges each year. Second, the code is actively supported by the judiciary's leadership. The Judicial Conference is responsible for this ethics program I've just described. It's revised its code 8 times over the years, and it plays a leadership role in regulating judicial misconduct and disability along the lines that Judge Smith and Russ Wheeler have just been discussing. Third, judges are actively involved in code revision and interpretation. One of the unique features about the way the judiciary is governed is that judges rotate through the Judicial Conference of the United States. So many of them share that experience at some point in their careers. They staff the Dear Abby Committee and solicit its advice, and they are invited to comment on proposed code changes. That, in a nutshell, is where the lower federal courts stand, and I feel pretty comfortable with where they're at. In contrast to the lower federal courts, the Supreme Court's ethical climate is underdeveloped. The court has never deemed it necessary to adopt a code at all. For more than a decade, it argued that a code was unnecessary because the justices already consulted somebody else's code. That is to say, the code applicable to the lower federal court judges, a perspective that assigned no value to establishing a code for itself that the court could embrace and internalize as its own. When the court finally adopted a code, its stated reason for doing so was not because the code would serve as a useful source of inspiration and guidance for its judges, and not because the code would promote an ethical culture on the court. Rather, in a prefatory statement, the court explained that its justices had already committed themselves to an ethical course of conduct, but that because critics mistakenly thought otherwise, the court was adopting a code to, quote, dispel this misunderstanding. The court's position that the code is intended for the benefit of its detractors, not itself, undermines the hope that its justices will embrace it as a useful source of guidance. Finally, the code that the court promulgated has not been written to guide and inspire good judicial conduct, but to barricade the court from its critics by diluting its responsibilities in relation to the issues that could be a source of controversy. 6 examples. They're quick. Hang in there. First, the court deleted the code of the court deleted the duty to faithfully uphold the law from its code, which is an omnipresent feature of all codes of conduct dating back to the 1924 canons of judicial ethics. For justices under fire, increased fire for being political hacks, to use the term that Justice Barrett used, erasing the duty from the code that it signals that the court's less interested in reassuring a doubtful public that it aspires to abide by the rule of law than avoiding criticism for violating a broadly phrased directive. Second, the court deleted the judge's duty to take appropriate action when she becomes aware that another judge violated the code. In the lower courts, this canon has facilitated informal resolution of ethics issues that obviate the need for formal discipline. And my first tenure piece featured questionnaires disseminated and answered by 38 present and former Chief Circuit judges talking about the ways that these informal processes operate. On a court that is not subject to a disciplinary process in the Supreme Court, editing the code back to eliminate a duty to do anything when confronted by a colleague who has committed a serious code violation signals a lack of shared commitment to taking the code seriously. Third, citing security concerns and historical practice, the court eliminated the directive that a judge should not, to any substantial degree, use court resources to engage in extrajudicial activities permitted by the code. Instead, the new code authorizes justices to appropriate court resources for any activities permitted by these canons. Thus, as rewritten, a justice may exploit court resources by directing law clerks to manage the judge's financial investments, help run the justice's family business, plan religious retreats for the judge's Catholic parish, and hawk the justice's latest novel. This provision does not serve to guide and inspire good judicial conduct. It serves to minimize ethical responsibility. Fourth, the court dilutes the duty to avoid exploiting the judicial office for personal gain. The Code of Conduct for U.S. judges provides that a judge should not lend the prestige of judicial office to advance the private interest of the judge or others. The Supreme Court limits this duty to circumstances in which the judge misuses the prestige of office knowingly. Judges in the lower courts are exhorted in advisory opinions to make appropriate inquiries and satisfy themselves as to the propriety of gifts and other perks that they are offered. The new SCOTUS Code, in contrast, adopts a don't ask, don't tell policy that enables its justices to accept problematic gifts and special deals as long as they maintain a veil of ignorance. Fifth, the court diminished its duty to disqualify in ways that confuse rather than clarify its ethical responsibilities. In its April 2023 letter to the Senate Judiciary Committee, and again in commentary accompanying its new code, the court noted that, unlike lower court judges, its justices may not disqualify themselves as a matter of convenience, given the need to minimize tie votes on the court. But lower court judges are not permitted to disqualify themselves for the sake of convenience either. They are under a Canon 3A duty to preside unless disqualified. In other words, justices and judges are in the same boat, just for slightly different reasons. Both are subject to the same disqualification statute that requires disqualification under the same circumstances. And both must preside unless they are disqualified. In the Supreme Court, because we want to minimize the risk of tie votes, and in the lower courts, because we don't want to burden a disqualified judge's colleagues with additional cases unnecessarily. The implication that a Supreme Court justice should not disqualify himself under circumstances in which a lower court judge should invites the legitimacy-threatening spectacle of the decisive vote in a 5-4 case being cast by a justice whose impartiality is so deeply in doubt that it would force the disqualification of a circuit or district judge subject to the same statutory language and the same code canon. Sixth, and finally, the court omits all commentary from the lower court code it used as a model, explaining that such commentary is inapplicable to it. But lower federal court code commentary is derived from an ABA model that state high courts around the country have adopted and applied to its justices. And the Supreme Court does not try to explain why commentary could be a useful source of ethics guidance to state Supreme Court justices around the country, but somehow be irrelevant to their federal counterparts. And so, for example, in its own code commentary, the Supreme Court bemoans the ambiguity of its duty to, quote, act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary, close quote, after deleting judicial conference commentary that helps to clarify the meaning of that ambiguous phrase. Once again, the court's goal for the code is not to guide and inspire, but to insulate itself from blame. In short, as long as the court parses its code like tax lawyers seeking to minimize liability rather than as a source of guidance and inspiration to ensure that its conduct is above reproach, the controversies that led to the adoption of the code are destined to persist. So what next? If the code is to be more than window dressing, the court must undergo an attitude adjustment. And that's going to take time on a court with what panel one referred to as Olympian tendencies. And it may take some nudging. I mean, it is going to be, I think it was Justice Vanderbilt who once said that, you know, court reform is no sport for the short-winded. And I think that is certainly true here. Now that the court has adopted a code, however, it creates an opportunity for the court to begin the process slowly and quietly of growing its ethics culture. It can follow through on plans described in its code commentary to offer periodic education and training on code principles. It can normalize the process of justices consulting with each other about code-related questions as they arise. And it can incorporate periodic review and revision of the code into the court's administrative process. Second, the justices can seek additional guidance and elaboration on their obligations in gray areas of the code by regularizing communications with the Dear Abby Committee, reviewing that committee's ethics advisory opinions, consulting commentary accompanying the Code of Conduct for U.S. judges, and checking with each other. Third, as the court gradually embraces a code culture, its justices can think about the code less as a document to be parsed for the purpose of averting code violations and deflecting criticism, and more as a source of guidance and aspiration that avoids close questions by taking the high road and applies the canons generously in light of their underlying spirit and purpose. Fourth and finally, when the justices fall short on a court that aims high, and that is just gonna happen, they can and should take corrective action with a simple concession of fault, which judges in the lower courts routinely do in the context of the disciplinary process. And with that, I will subside and wilt into my chair. Thanks.
Thanks. Mr. Payne.
All right. Hi, everyone. I recognize that on a full day of panelists, I am the last panelist, which is bad news because it has been wonderful. But the good news is that I will be brief and I will get to the point very quickly. So I'm picking up right where Professor G left off, which is what's next after there's a real effort to have a code of ethics with the Supreme Court and they actually take it seriously. What else can you expect to happen? And the way I know what's going to happen is with the help of Professor Hellman and a quote he had in an article in 2019 about how there is a continuing dialogue between Congress and the courts to have an evolution of the federal rules that apply to judicial misconduct. Now, he was talking about the lower courts, but this also applies to the Supreme Court. And you see that just last year where for 2 years, actually, the House Judiciary Committee, the Senate Judiciary Committee put pressure on the court to adopt a code of ethics. And they did, in a way, as Professor G said, they did it, at least they can check and say we have something that is a code of ethics. But there was something else in the background that was also happening besides simply a code of ethics. So in that analogy of the dog chasing the car and then catching the car, there were actually two cars that were being chased. I'm going to talk about that second car. Undue influence. Undue influence from third parties on the court. That affects the legitimacy of the court, at least the perception that the court is acting in an impartial way. In other words, if you have all of the codes you want that apply to the conduct of the judges, that's lower court, of the justices, that does not get at the misconduct of third parties and the perception that there's influence coming from outside the court. Now, before you never even thought about this. It only became a problem really in the past 2 years. You usually only think about this with the legislative branch and the executive branch. So for example, you expect that if there's a piece of legislation, that there's going to be an interest group on both sides. And they're going to use the three instruments of influence that everybody knows. First is going to be a lobbyist. You're going to get someone who can educate that lawmaker on what's happening, both sides of it. Second, you're going to use campaign contributions. Those campaign contributions are not to buy, vote, or buy to support. It's for access. Access with this lawmaker or this the staffers to get at a fundraiser or something along those lines, or just to show you support this person so they will listen to you when you try to tell your point of view. And then finally, gifts. Very common within the laws, wine and dine members of Congress. Now, there's certain ways you do it. It can be a reception, it can be a widely attended event, et cetera. But you do this to build the goodwill so people trust you. So when you have the education that comes in the form of the lobbyists, you have the campaign contribution, you get the influence. That happens in the legislative branch, executive branch. But we didn't think about that happening with the court. Because in the court, you think about it in terms of cases. If there's a case, you have two litigants. They try to influence the court by simply presenting their case, the brief, the oral argument, and that is it. That's no ex parte communications, and that's how it's done. But I think an important point that was mentioned today is that the Supreme Court doesn't do cases as much as they do questions. And that means that even if you're not a litigant in a particular case, you still may be an interested party in the question, and you try to influence court. So what does this mean? All right, so I'm going to show you what I mean. And again, I'm always right on the point. The point I'm going to show you in a very short 30-second clip is that with the legislative and executive branch, we have particular ways of dealing with the potential undue influence, but you don't have that with the courts. So we can go to the clip.
And here's your prescription. I know just the pharmacy to get this filled.
Who are you?
I'm a PBM,
What's a PBM?
your insurance company's pharmacy benefit manager.
Why can't I go to a pharmacy in my neighborhood?
Well, I make more money when you go to a pharmacy I own. Ah.
All right. Thank you. So you don't have to know much about what's going on there to get the point that I'm going to make, which is what do you see on the face of what is behind the scenes? On the face, you see this is paid for by pharma, which is the pharmaceutical industry lobbyists. And what they're doing is saying that they are against PBMs. You may or may not know what those are. But the point is you got two sides to this legislation. You got the pharmaceutical industry, PBMs. And then on the behind the scenes, for me to understand why are you trying to influence legislators? Which ones are you trying to influence? I can look at records and know that they've spent $27 million in lobbying last year. I know who their lobbyists are. I know they've spent about over $100,000 in campaign contributions and who those have gone to. And I know about gifts they've given. I know about donations they've made to honor particular leadership members in the House. And I know different events they've hosted in DC for lawmakers. That gives me transparency with what's going on. Because when it comes to our government and undue influence and what's going on from third parties, there are enough lawyers here to know we'll never agree on what is undue influence, what's too much. We'll never agree on any restrictions on that influence, but we can agree on transparency for you to at least know what's going on. So now let's take a look at what that means on the other side with the judicial branch.
And here's your prescription.
The Supreme Court, Alexander Hamilton called it the least dangerous branch. Its justices were to uphold the Constitution, to be above politics. Now, that legacy is being tarnished by secret money from liberals. The president and the Senate were bankrolled by Arabella Advisors Network. A record amount of dark money, over $1 billion, put them in office. So they'll put up an Arabella judge, a liberal activist, a Biden rubber stamp. A huge sum. A huge payback.
All right. So what's going on here on the face and in the background? On his face is paid for by the Judicial Crisis Network. Okay. Then they're making allegations against another group that you don't know much of from here. What's going on in the background? I don't know who pays for funds for Judicial Crisis Network. I don't know who their lobbyists are, what they're trying to influence. Don't know any campaign contributions or the like that they're doing. And I don't know any gifts or perks that they're providing to people to try to do this influence campaign. It's no transparency with something that the public perceives as influence. The public will look at this and say, what? Someone's paying for judicial nominations, or somebody's doing something to influence the court? Well, you might look at this and say, okay, that is the confirmation process. That's always political. That's not necessarily news. It's been like that for as long as you can remember. But more came out about 1.5 years ago that changes everything. And go, perfect. Operation Higher Court. Many of you may know about this, but I put it in context here so you can see the significance of it with knowing what's next and Congress's role with regulating the Supreme Court, and more importantly, third parties who try to influence it. Came out about 1.5 years ago that a leader of a nonprofit had a plan to influence the court. So he got an office across the street from the court, named his plan Operation Higher Court, wanted to influence certain justices. And how he thought about this was not to change someone's mind, not trying to change someone's mind on a particular case. It is to support them, to let them know they had a community that was behind them, and to embolden them to not hold any punches and go as far as they could when it comes to Supreme Court jurisprudence. And how did he do it? His plan was the exact same plan that you see with the other branches of government. He got lobbyists. He got people who were going to influence these justices by becoming friends with them and using particular talking points to get their point of view across. They use contributions to the Supreme Court Historical Society to get access to the justices in these small environments, meaning social environments, where the more money you paid, the closer you got, and more frequently you're with those justices. And finally, gifts. Part of the plan was to wine and dine these justices, whether it was at a restaurant or at a home. You take this revelation, which is something you would never know unless someone came out and told what was expected to be always be confidential, with the other allegations of justices traveling with wealthy benefactors who took them on trips, and the people who attended these trips either had something directly before the court or had some interest before the court. And it lets you know that the public starts to at least have the perception, whether it's justified or not, that there are third parties out there who are trying to influence the court, and you don't have the type of transparency that exists for the other branches of branches of government. So finally, my last point is just to say that when you look around the corner and you look at what's next, you see that there is this dialogue, and this is a dialogue that Professor Hellman talked about, where if you're trying to see what may end up changing with the court or in legislation that affects the court, look at what Congress is starting to talk about and what's bubbling up. And what was bubbling up just 2 years ago was not only saying you need a code of ethics. Bubbling up was the conversation that we need more transparency with those who are trying to influence the court. You had this hearing with Operation Higher Court, and there are other pieces of legislation that are tied to this real threat that there is going to be at least a perception that our court is influenced by those that should not have that role in our government. All right, thank you.
Excellent, well played, and the timing was fabulous. So we have time for a few questions. And well, my head is bubbling with them, so I'm going to take my prerogative and ask one, maybe two. I think actually that this addresses both panels in a sense, but it really came to mind during the first part about the district and circuit courts, particularly the mention of the Kozinski scandal and the change in culture. Because, I mean, I think it's interesting to consider how that change in culture might be driving, besides the specific pressures, the Supreme Court's adoption, and sort of how that could play into that. And just as another example of how much that culture has changed, I mean, I was a clerk on the Second Circuit in the 1990s. And although Judge Kozinski at the time sat on the Ninth Circuit, it was like famously well known amongst clerks on the Second Circuit that clerking for Judge Kozinski was a nightmare. And no, I mean, I was unaware of any allegations of anything specifically about sexual conduct, but he was well known as a completely abusive boss. I mean, that was, on the other side of the country. But so it certainly wasn't a secret. But so what changed? What changed was the culture that made that happen. So I just wonder, I guess, how you all think about how that, because we've talked a lot about codes and Congress, but the opening discussion of the cultural change seems to me to be such a huge factor here. And I guess I'd like to hear your thoughts about how that plays into all this.
I can throw my 2 cents worth in here. For me, it's always been fairly straightforward to say that what goes on between Congress and the lower courts has always been a dialogue. I mean, the courts have been responsive to public criticism. They've tried to keep their own house in order. I think the story that Russ Wheeler was telling about the Breyer Committee, that really was in some ways prompted by congressional interest in going perhaps overboard. And I think there's this dance that goes on, for generations. The Supreme Court, it's more challenging because I think it's reflected in Justice Alito's Wall Street Journal view, right? I mean, that you're not the boss of me, get out of my hair. It's not, this isn't a constructive dialogue. This is us doing what we're going to do and you keeping out of it. And that's going to take some time to work through.
It takes nothing away takes nothing away from my earlier praise of the courts to say that there's a certain amount of self-preservation acting there. I mean, no judge, few judges want to have their picture show up on the front page of a paper. Pardon the reference to an historical artifact. Or in the evening news, and so the best way to avoid it is just to stay out of trouble, and the committee provides some guidance on how to do it. I get the sense with the court, with all due respect to the court, that it's our court and we'll do what we want with this. And so, just, as Charlie says, don't bother us. So that culture hasn't seeped in there, but I think it's a culture of self-preservation and then assistance from the bodies that are appointed to do that.
I would like to make a comment that actually would have been more well-placed and more relevant to an earlier discussion, but it had to do with Steve Laddick's comments about Congress and how little it seems there is to fear from them if you are the federal courts. I could not disagree with him more strenuously. And today, more than ever, I dealt with the Congress over 10 years as a member of the Space and Facilities Committee. Mike Fisher has dealt with Congress back when he was on the Budget Committee of the Judicial Conference. There are ways and there are ways. The judiciary has done well, I can say, from a budgetary standpoint, because we have a good relationship with staff. But we are in a different age. I don't have to tell anybody that, where anything can happen with social media if the right issue comes along. So do not think for a moment that we in the federal judiciary and our administrative office does not live, I won't say in constant fear, but in constant awareness of what could happen if we're not careful.
Is somebody up there have a question? Yes, Professor Levins.
Yeah, I just, for the two gentlemen, I'm sorry, what were you saying again? So on the portion of the code, I'm curious as to how much you know about what happened behind the scenes in terms of if we have any information at all, because obviously the Supreme Court's more like a cartel than the lower federal judiciary is. And so I'm not surprised that they would have made far less, significant restrictions on their own behavior. And then for Kedrick, a quick question, and that is, I liked your last slide, but the question is, we already have transparency statutes that apply to the U.S. Supreme Court. And as I understand that as I understand that they're enforceable by the AG, but there's no way the AG is going to enforce them against the Supreme Court justice if I understand them well. So I just those two questions real quick.
Just answering the first question quickly, we don't know anything. We can speculate only because the Supreme Court was intent on gathering unanimity. And clearly, I think concessions were made in order to achieve that unanimity. Speculating, given what Justice Alito said in a public forum, about anything Congress does is unconstitutional, implies, and parenthetically, that itself may have been a code violation because he's talking about an impending piece of legislation that Chief Justice Roberts said explicitly ethics rules prohibit me from talking about, not Justice Alito. But I think that trying to bring him into the fold required a unanimous document, and that clearly affected its content, but to what extent?
I'm so glad you brought up that point because it is an important point that I didn't make clear. When I talked about the laws that apply for legislative and executive branch, those transparency laws are for third parties. And it's the lobbying law, the campaign finance law, and the gift laws. Those exist to have transparency with third parties. Supreme Court does not have that for the transparency with third parties. And the disclosure laws, I believe you're referencing, are for the justices themselves to disclose like their financial interests. And you're correct. So far, we haven't seen any enforcement of that.
Okay, I think this was a great end to a great day. So thank you all very much. Please thank our panel.
Helping us conclude this wonderful conference is Third Circuit Judge Mike Fisher, who's also known to us, many in the audience, as a professor, including myself. And we're so glad that you can help us conclude this wonderful event. Thank you.
Okay. Well, first of all, as Chief Judge Mark Hornak, this is the opening day of baseball here in Pittsburgh. And Chief Judge Mark Hornak, he started out as the opener like Mitch Keller. And here I am, I'm the closer, David Bednar. Okay, but I'm keenly aware that I am definitely, with one minor exception, the only thing that stands between you and the cocktails. So I just want to say that, first of all, I want to commend, as many others have, but I can't leave here without saying it, commend the Pitt Law Journal with Anna, Daniel, and all of their cohorts on the Law Journal for what a tremendous program they put together. I know how long they've been working on this. I know how hard it is to get the distinguished panels assembled here today. So thank you for having given them a big round of applause. Arthur asked me in giving these closing remarks, he gave me specific instructions that I was not to serve the role as a recorder, which would mean I was to stand up and record everything that you all said. Okay, I got that point. But there were certain themes that have permeated today's symposium, and they all relate to Arthur Hellman. First of all, the theme that scholarship is driven by critical thinking. Students who spoke today, and I don't mean Anna's and the Daniels, I mean the Chief Judge Hornacks and the Rob Byers and the many others who have been students over the years, they've all mentioned it. The speakers have all lauded it. And Arthur Hellman's writings, his papers, his textbooks have all shown it. The concept of critical thinking. Understanding the understanding of the federal courts, another theme would be the understanding of the federal courts would not be what they are without Professor Hellman's many contributions. His article on the shrunken docket of the Rehnquist Court and his many other papers on the operation of the Supreme Court. Excellent examples given in our first panel. His work with others on the Huresca Commission, the work that helped to explain how the Ninth Circuit remained as it is and how the Fifth Circuit was split. His inside view given by Judge Noriega regarding the Federal Circuit, and his critical work on jurisdictional changes with Congress and the court, something that I've had an opportunity to work with Arthur on in recent years. His help in drafting the rules of judicial conduct and his frequent comments to the media in response to inquiries that have set an appropriate tone and discussion. Another theme was many were helped by Arthur Hellman's guidance. His students, Pitt Law itself has been helped by Arthur Hellman's prestige over so many years. The courts, we've all been helped by what he's added to our system. The academy, from which many of you come. And I should say myself, when I came here to teach almost 7 years ago now as a distinguished jurist in residence, when I took senior status on the courts, I inherited Arthur's federal courts class. If you don't think that was a tough task, okay, even though he loaned me his book and he gave me his teaching supplements, and it was a very tough task to fill Arthur's shoes. And I tried that for 3 years. Dean Willermuth took it over for a couple more, and I'm going to step back in here this fall, and listening today to all of this commentary will certainly be a help in that regard. I recently completed a term for the U.S. Judicial Conference as chair of the Federal State Jurisdiction Committee. And Arthur and I had frequent conversations about work that he had done in earlier years and work that we were doing. and his insight was very valuable to my work and certainly the committee's work. Another theme which we heard throughout the day was tone. Respect was gained by the tone itself of his work. Also, as my colleague Judge Hardiman pointed out, the tone of Arthur's commentary was always respectful and was never in a tone that was any bit over the top. So having focused on these themes today, and without belaboring anything else that all of you have said and everyone's heard, it's only fitting that the final words at today's symposium comes from the person who we're all here honoring today, and that's Professor Arthur Hellman. Professor?
Thank you, Judge. Thank you. Well, thank you, Judge. Today has brought a true intellectual feast with outstanding contributions from a sterling array of speakers. It's been truly humbling to listen to this and to hear so many of them take inspiration from my own published scholarship over the years. Ideally, I suppose, at this point, I'd bring the program to a conclusion with a brilliant synthesis that masterfully weaves together the insights from all of the 4 panels. Well, that will have to wait for another occasion. This has been a long day, and I will be brief. My goals here are modest, but still important. And since the symposium is being sponsored by the Law Review, I'll use Law Review format with 3 sections identified by Roman numerals. Roman numeral 1, the past, Roman numeral 2, the present, and Roman numeral 3, what else? The future. The past. One of the most gratifying consequences of the Law Review's decision to organize this symposium is that it has given me a chance to reconnect with so many of my former students. Many have attended some or all of today's panels, and of course, it's been great to see you here. But others who have not been here have written with wonderful notes, recalling their days in my class, and that has been truly gratifying. There's an old adage that a good teacher's lessons don't end with the school year, they last for a lifetime. And based on what has been said, well, maybe I was a good teacher. Roman 2, the present. There is a tendency as you grow older to romanticize the past, particularly the past of an institution that you've been associated with for a long time. In particular, it would be easy to think that the former students who have written to me over the last few weeks were the product of a golden age that will never be replicated. I have solid evidence that that is not so. As you've heard, the symposium has been organized primarily by current students who are members of the Law Review today, not a generation ago, and they have done a terrific job, as you have seen. And you've heard their names before, but I want personally to express my own gratitude and appreciation. There's a complete list in your program, but I have to recognize Anna Miller-Little, the editor-in-chief, Daniel Tublin, and Danny O'Byrne. Again, please join me in applause for those 3. Fortunately, the students did not have to work alone. They received outstanding support from the leadership and staff of the law school. Again, too many all to list here, but Interim Dean Mary Crosley, Greer Donnelly, the Associate Dean for Research and Faculty Development, Amy Change, the Program Director, the Program Assistant, and Deb Hilton, the Marketing and Communications Manager, a terrific team. Finally, there's one individual who's in a category of his own. Professor Peter O. is listed simply as a member of the Planning Committee, but he did so much more. He worked with Daniel on programming, Anna on outreach, leadership team on development. He was everywhere. And I know that he's been an inspiration to all of the planning group, but I particularly want to say he's been such a wonderful colleague. And colleagueship is one of the things about being a member of the faculty that is just so important. Now to part three, the future. For that, I'm going to have to dip briefly into the past. In the last several years that I taught the federal courts course, I ended the final lecture by reading from a famous law review article by Professor Henry Hart. It's known as the Dialogue on the Power of Congress to Limit the Jurisdiction of Federal Courts. As the title suggests, the article is cast in the form of a dialogue, with Professor Hart on one side responding to an unidentified and perhaps somewhat naive and not totally understanding interlocutor. Toward the end of that dialogue, Professor Hart condemns in very strong terms a then recent line of Supreme Court decisions on the rights of aliens. Now, ironically, I'd probably get into some trouble today if I quoted that part, because Hart used some language that probably would be viewed as politically incorrect. Fortunately, I don't have to quote any of that, because the specific holdings are irrelevant to Hart's point. The point is that Hart viewed the decisions as terribly unjust and even perverse. Well, so Hart winds up this paroxysm of denunciation and finally pauses for breath. And his interlocutor says at that point, but that is what the court has held. And so I guess that's that. But for Hart, it is not. Here is what he says in response. The deepest assumptions of the legal order require that the decisions of the highest court in the land be accepted as settling the rights and wrongs of the particular matter immediately in controversy. But the judges who sit for the time being on the court have no authority to remake by fiat alone the fabric of principle by which future cases are to be decided. They are only the custodians of the law and not the owners of it. The law belongs to the people of the country and to the hundreds of thousands of lawyers and judges who through the years have struggled in their behalf to make it coherent and intelligible and responsive to the people's sense of justice. I thought those were inspiring words for young men and women on the threshold of a legal career, and I think they are even more relevant today. In particular, you should not assume that because your view of the law has been rejected by the Supreme Court, you as a lawyer or as a lower court judge should give up on working within the legal system, within its constraints, to change the law. For that matter, you should not assume that because your view has prevailed in the highest court of the land, that it will always do so, and that you can give up on persuading people to accept the correctness of your view. Probably everyone in this room is deeply unhappy with one or more of the Supreme Court's recent decisions. You can take comfort, I think, from Hart's reminder that the 9 justices who sit on the court at any one time
are only the custodians of the law and not the owners of it. And you in this room, as lawyers and lower court judges, have power to shape the law so that it conforms to the people's sense of justice, whatever that might be. That is one of the great attractions of the legal profession, and the insights we've heard today have made significant contributions to our understanding of and our ability to improve the operation of the federal courts in the federal system. Thank you all so much, and thank you again to the Law Review for organizing this wonderful symposium.
Thank you, Professor Hellman, for that. Okay, as the slide, we crafted the slide it took us a while, but yes, you bring Suter to the right. Thank you so much for coming, and we hope you remain engaged with Pitt Law and the Law Review going forward. Thank you.